hour, other side half an
Because
hour.
point I was
Mr. Chatterjee,
making, sir,
that is why
I'll
I
tell
can
you-
direct this matter to be kept under the heading hearing.
No, no.
That's
What I
better
am-
because
Yeah, Your Lordship, make
Mr.
it for
Chatterjee,
hearing,
I
but
tell
when
you.
he fixes a date for hearing,
because
no
you know, I tell you, this is a circuit of 8 days only.
that is the main problem.
Yes, that is right.
That is the main problem.
2 days are holidays. So motions I am trying to, because lot of matters for hearing have been mentioned. I have not allowed them to hand over the slips in. So that's really a problem. Hearing matters are not being
Because
taken
Your
up. But
Lordship did not want this to appear as a hearing matter, my Lord.
at that point of time,
Yes.
I heard it substantially, but
My lord.
now what can be done? Let
Can
me
we not have
take up some
sympathy
motions,
for
new
this,
motions.
next Thursday? Some sympathy for these poor people, my Lord. Your Lord, any day, my Lord. If Your Lordship reaches
My sympathy is with those, all the people, not only with your clients, but let me see, because others also have to be accommodated.
I bow down, my Lord.
Let me
So
see how
don't-
far I can proceed. Maybe I may be able to reach there.
Not really.
Let me see. New motion, please hand over the slip. New motion. Under motions, madam, it was taken up at one point of time. So some matters under the heading new motions have been included. Let me exhaust that bunch. Otherwise, I have not yet reached the motion bunch. Unnecessarily adding further matters in those bunch will not improve. Hearing you, I leave it to you. You fix it. I do not have any objection. I can take up hearing from 10:30. When do you want the hearing matters to be taken up? Next Monday, I can take it up, but not new motions then. All of you are agreeable that hearing matters will be taken up? I appreciate that. Let me see.
Lordship, correction, Lordship.
Try your luck in the next circuit, because this circuit is of 8 days only. 2 days. And if 1 day for hearing, then 1 day for motion is gone.
Lordship, liberty to mention 2 matters. Both are new motions, my lords, filed in the...
New motions, I have asked you to hand over the slips, sir. You did not mention.
My lord, maybe,
New motion, please hand over the slips. You did not mention.
my lord, may I be permitted to mention, my lord?
Under what heading, madam? Hearing matter, please don't mention now. Yes. Not now.
My lord,
That's hearing matter, not now. Yes.
Lordship, may I be permitted to mention the matter of WPA 1592 of 20?
For what?
My lord, for hearing.
Hearing, please don't mention.
my lord, may I be permitted to mention,
Yes.
my lord? My lord, my lord, it's a hearing matter, my lord. But it's a 2022 matter, my lord. There has been a cash seizure from my premises, my lord. I am covered by judgment.
Please
my lord.
wait
Cash
for
cannot
some
be
time
seized,
for
my lord.
hearing matters. Please wait. Yes, call the list.
Try my luck on Monday,
One
my lord.
extension
Then.
matter.
Extension, please hand over the slip. Please call.
But if the
I'm for the petitioner, Your Lordship.
Yes. Why to be mentioned?
Malad, there was a request from the Honorable Court to interfere the matter because there was a rift between the lawyer and a police officer in the court of Kalimpong. And that I have intervened, and there was a meeting I have convened pursuant to the the Lordship's order. And then matter has been settled. Both the parties said we do not want to pursue further.
All right, so I am disposing it off
Yes,
by recording that the
Your Lordship.
matter has been settled.
The report which I have submitted, Malad, to be kept with the report.
Report?
Report which there was a direction to file a report also.
Where is that report?
Give me a second, Malad.
Your Lordship, I have a copy of that report.
You have a copy of that report, but he has to file the original report. The learned additional advocate general submits that pursuant to the order dated January 9, 2025, he has intervened in the matter, and the dispute between the parties have been settled. Full stop. the report filed by the learned additional advocate general is taken on record. Full stop. Nothing remains to be decided in this writ petition. Full stop. Accordingly, WPA numbers such and such stand disposed of. This court appreciates the prompt steps taken by the learned additional advocate general in resolving the dispute.
The criminal cases
Had to
will
be-
be also dropped.
Yes, Your
It has been dropped.
No,
No,
to
no,
be
to
dropped
be
because
dropped.
they said that they don't
To
want
be
to part
quashed.
both the criminal cases.
Steps will be taken because
In view of this order, parties to take steps before the jurisdictional court.
parties will be at liberty to take appropriate steps before the jurisdictional court pursuant to this order.
Yes. Order and the report.
Pursuant to the order and the report
Grateful.
filed by the learned additional advocate.
Yes.
Please ask your.
I'm giving, because of the heavy rainfall.
No. That I appreciate because
I
this
will
is
hand
the
over to
original.
the court officer.
Yes, call the next matter.
For withdrawal.
Withdrawal. Yes, who is for the state? Yes, the learned, the learned advocate appearing for the petitioner submits that the petitioner is not willing to.
Oh, ওটা তো আমি ইয়ে করে দিয়েছি, হ্যাঁ। দেবাশিস হালদার।
The petitioner is not willing. The petitioner has instructed him to take steps for withdrawal of this writ petition. Stop the written communication addressed by the petitioner. The written communication addressed to the learned advocate on record of the petitioner is taken on record. To stop. In the light of the submissions made by the learned advocate for the petitioner and the request made by the petitioner, WPA number such and such stands dismissed as withdrawn. The written communication be taken on record.
Malab the report is original.
The earlier matter, ওই রিপোর্টটা আচ্ছা ওই কপিটা ওই অ্যাডভোকেটকে একটু দিয়ে দিন না, ওনার কাছে কপি না থাকলে মুশকিল হবে। যে কপিটা ছিল সেই অ্যাডভোকেটকে একটু। ইয়েস, কল দ্য নেক্সট ম্যাটার। আগের ম্যাটারটাতে। ইয়েস, কল দ্য নেক্সট ম্যাটার। Petitioner's name has gone down as respondent.
চার।
তারে আছেন?
চার।
তারে কি matter?
ওই যে শঙ্কর যে টাকা পেমেন্ট করে দিচ্ছে টেকস।
ওটা 4 নম্বরে।
হ্যাঁ।
For the respondent number 7. Oh, it should be Mr. Sujoy Paul. Paul or Pal?
Yes, very malad.
What is? PAL. The learned advocate appearing for the petitioner submits that through inadvertence, PAUL, the learned advocate appearing for the petitioner submits that through inadvertence, the name of the learned advocate representing the petitioner on October 27, 2025 has been recorded as Miss MS Stuti Bansal instead of Mr. Sujoy Paul, PAUL. First up, let such error be rectified. This order shall form part of the order dated October 27, 2025. Yes, next. You are led by?
Mr. Swaradip Majumdar is appearing virtually, Lord.
Yes, sir.
My
Why
lord,
for orders?
My lord, it was for order, my lord. My lord,
Why
your
for orders?
হ্যাঁ, right.
my lord, your lordship was asked the learned respondent counsel on the last occasion to take
Oh, yes,
instruction
yes,
on the point of recovery, my lord. 30% was recovered.
Of the value, appeal they can, they can intend.
So
to
there is
proceed.
no further
Or-
requirement to deposit the
Pre-deposit
pre-deposit.
amount is not
So appeal now can be decided.
decided.
Appeal you have not yet dismissed or you have dismissed.
Dismissed.
This first initially it was dismissed, madam.
All right. So now
the
since
audit-
after that you have recovered,
Yes, after that, after.
so I'm directing you, I'm setting aside that, I'm directing you to rehear the appeal.
Voluntary payment করেছে।
Where is the order of the appellate authority?
Madam, it is.
My lord, page 53, my lord.
না, বলছি
Page
না,
53.
আমরা বলে রিকভারি করছি, আমরা রিকভারি করি।
Page 53 is the impugned order.
Making payment.
আমাকে ওরা বলছে
It was dismissed only on the ground that the pre-deposit was not made.
Number two.
No, two grounds were delay and
And
deposit.
because it has not been more than the period of 4 months. And the second reason is the pre-deposit amount has not been paid. And the appeal
My
was
lord.
disposed of. Then, they have paid this amount, 20% of this.
Recovered, not paid.
Not recovered, paid.
paid.
Oh, paid.
Paid, voluntary, not.
Oh, he
No,
said
no, my
recovered.
lord, my lord, it is recovered, man.
No, no, no.
65, page
This is my
65, man.
instruction, they paid.
All right, paid or recovered,
But
that
the
amount
recovered,
is,
why would have recovered 20%?
yes, all right, deposited.
Yes.
Deposited, so I'm directing you to,
My lord, according to my calculation, it is 30%. They have recovered.
Thank you.
Page 65, man.
what is the pre-deposit amount? 10%,
10%.
10%
This-
of the amount of tax payable.
Of the amount of the tax paid.
Tax.
But this is the short instruction which they have. Original কোথায়?
আমাকে দেয়নি, এটাই বলছে।
And what do you have to say on the delay?
দিলে I leave it to your lordship.
%20 of the tax slab.
Yes.
All right. This application under Article 226 of the Constitution of India is directed against an order dated
Dated, my lord, 10 June 2025.
June 10,
June 10,
2025,
2025.
passed by the Senior Joint Commissioner of Revenue, State GST Jalpaiguri Circle, thereby rejecting the appeal on the ground of delay as well as non-deposit, as well as non-payment of the amount of pre-deposit. First up, the learned advocate appearing for the petitioner submits that after dismissal of the said appeal, an amount over and above 20%.
My lord,
of the-
30%, my lord.
No, no,
Acha.
20%, madam.
I'm recording his submission. An amount over and above 30% of the tax liability as determined as per the order for the financial year 2017-2018 has been recovered. So he therefore submits that since the said amount is in excess of the amount which an appellant is required to deposit as per the provisions of section 107,
Yes.
which subsection?
5 or
Six,
6.
six.
107, 6 of the WBGST Act 2017. The appellate authority may be directed to hear the appeal on merits. First up, pursuant to the earlier order dated October 27, 2025, the learned additional advocate general submits that on written instructions, that the total amount paid by the petitioner is equivalent to 20% of the tax liability determined by the impugned order for the financial year 2017-18. দেখি GST Act.
এক নম্বর
ওই তো উপরেরটা উপরেরটা উপরেরটা।
My lord, the order they have referred, my lord, maybe directed to serve, my lord.
You.
I have no copy of that order.
Which order? The
My lord,
instruction.
it's my lord, your lordship has mentioned order dated such and such, 27th October, something that.
27th October is the order passed by this court, last order.
There is an instruction to be
No, no,
served.
23rd April, my lord.
No, I have passed an order on 27th of October. It's available in the server, sir.
My lord.
কি হলো? Full stop. Section 107 within bracket C, 6 of the 2017 Act. Section 107 within brackets C, 6 states that no appeal shall be filed under subsection 1 unless the appellant has paid a sum equal to 10% of the remaining amount of tax in dispute arising from the said order, subject to a maximum of 25 crores in relation to which the appeal has been filed. Full stop. Since the learned, since it is the stand of the revenue that a sum equivalent to 20% of the tax liability has been paid, this court is of the considered view that the appeal filed by the petitioner should be decided on merits. Full stop. In view thereof, the order dated 10th June 2025 passed by the senior Joint Commissioner of Revenue, being the appellate authority, Joint Commissioner of Revenue being the which respondent?
Respondent. Number 2, my lord.
Respondent number 2 is set aside. Full stop. The appeal is restored to the file of the appellate authority. Full stop. The appellate authority, being the respondent number 2, is directed to consider the appeal on its merit and to dispose of the same by passing a reasoned order as expeditiously as possible, but positively within a period of
3 months.
3 months,
So 1 month.
4 weeks.
4 is 1 month.
within a period of 4 weeks from the date of receipt of a server copy of this order. Full stop. It is however made clear that since the amount of pre-deposit, since an amount more than the statutory pre-deposit has been deposited, the appellate authority shall not dismiss the appeal on the ground of limitation.
And on the ground of
And shall,
limitation.
on the ground of limitation, and shall consider the same on its merit.
affidavit of sorry.
Obviously.
আরেকটা লাইন লিখে দিন। It is however made clear that this court has not gone into the merits of the issues raised by the petitioner before the appellate authority, and the appellate authority shall be free to decide the same in accordance with law. Yes, next.
My lord, may the direction to consider the annual return be added?
No further direction. If
My-
annual return, anything, additional evidence, provisions
My
are there, you please invoke those. Yes.
My
What is
obligation.
the next matter?
So item number 5 and 6, I am for the respondent, Lordship.
Yes,
Yes,
Mr.
number
Ghosh, what
5.
is your instruction?
Let there be an order of the court
What?
that whatever that deals with taking the circumstances, let there be an order of it. I didn't get that confidence while interacting. I have to.
That is why I have kept it for today.
Undertaking will be Millard on the name of the on record advocate Millard.
No, why?
Millard by the client, but somehow our involvement will be
That
there.
is why, no, Mr. Ghosh, that will be not an undertaking by the advocate.
Yes, of course, by the client.
That
But-
will be by the client.
But Millard,
That will be-
while
That is why I have given you time to take instructions, because the affidavit is to be filed by the client.
yes, sir, definitely yes. But Millard, I
I
didn't.
will not go by the submissions made by you. That is why I asked you to take instructions whether your client is ready and willing to give.
Millard, I didn't get that confidence, Millard. Let there be an order of the court. Let there
All
be
right,
the-
so I'm keeping it as 4 orders on Monday.
Grateful, grateful.
Lordship, my humble submission is that,
Hardly-
Lordship, I am for the Panchayat, Lordship, the respondent
Yes,
number 5.
where is those orders? You have said that you have passed the order of demolition. Where is that?
The demolition order, Lordship, only that resolution I have taken, and I have forwarded the resolution to the SDO.
Where is that copy?
Lordship, it is annexed at page number of the writ petition at page number 61. It page 53 and 54.
Of which writ petition?
Sukhendunath Bonik.
Of
Sukhendunath
second writ petition.
Nath Bonik.
Oh, secondary. 2140.
2140. Yes.
Page.
Page 53 and 54. And subsequent is 57.
All right.
So my humble submission is that, Lordship, according to the terms of section 23 subclause 6 of the West Bengal Panchayat Act, the authority competent to demolish the unauthorized construction is solely the SDO. Lordship, this has been perhaps decided by the Honorable Division Bench in our High Court.
Show
in
me
first-
the order.
Lordship, my one colleague is there, Lordship, Falguni Mukherjee judgment.
Falguni Mukherjee, Millard, this has not been decided at all. Who is the authority?
No.
Which paragraph?
I'm citing, Lordship. The paragraph number, kindly see at page page 2, D.
D.
Yes. Lordship, kindly see D, where the Honorable Single Bench had directed the SDO particularly to demolish the order. That order was in verbatim affirmed by the Honorable Division Bench.
No, that is a different thing altogether. Show me that the issue that the authority mentioned under section 23(6) is the subdivisional officer and not the panchayat. Please show me a decision on that.
Lordship, if you kind enough to peruse the entire provision of section 23, that will be clear from the statute itself. Kindly see. Kindly see the section
So
23.
in this judgment, has it been held that it is the SDO?
No, not in
That was
not
not
in
an issue before
not in
the-
categorical terms. Not in categorical terms. But
You have
but-
said that it has been held by the
no,
division bench.
because I am relying upon
Millard,
because
in the
that
judgment, Millard, which I had relied upon, Millard, it is categorically held that authority means Gram Panchayat.
No,
under
no, no.
23(6).
Statute says so.
Yes.
no. That this particular division bench judgment that I
Mr.
am
Ghosh, you have submitted this
Vishwajit
Vishwajit
Noskar.
Noskar.
Vishwajit Noskar. Para 6, Millard, the 9th line of para 6.
Lordship, in my judgment, Lordship, I relied upon, Lordship, that in this particular judgment, the Honorable Single Bench had directed the SDO concerned to demolish the order, the unauthorized construction. That particular direction was upheld by the Honorable Division Bench, directing the SDO to carry out the demolition exercise upon the unauthorized construction. So it has been held that the SDO is the obligatory authority, is under obligation under the statute to carry out the demolition order, because there is a demolition exercise need to be carried out by the SDO itself, because the entire issue to be decided by the SDO. The statute does not provide any relegation of power, any delegation of power upon the panchayat. This is my humble submission.
All right.
If that be so, there should be an
Are
express
the learned advocates for the
provision.
parties list this matter
Lordship, one
under
more
the
thing,
heading
Lordship. Lordship, one
of-
more thing, Lordship.
for orders or Tuesday date? Tuesday.
Lordship, one more thing, Lordship. One more thing,
Yes.
Lordship. I have already handed over the our panchayat communication to the SDO concerned, citing this provision, that is to adhere to the terms of the order, because the competent authority, as a competent authority,
Where is that?
SDO. The one copy my learned junior friend is there. Lordship, that particular communication, that is 15th of September 2025. 15th of September 2025. That has already been, I have sent it by the panchayat, from the panchayat office to the SDO concerned. To carry out the-
And who is for the state?
But that is the communication that has been made in terms.
Yes, it is interdepartment communication.
No demolition order at all has been passed by the consent of under section 20. That is also of the view that Gram Panchayat is the. And the statute clearly says that the Gram Panchayat is the authority under section 23(6).
No.
Pass the demolition order. I respectfully disagree with the submissions made by my learned colleague here.
May I read out the relevant provision?
You are trying to protect an illegal
No,
construction.
I'm not, I'm of the view that it is to be demolished. It's an illegal construction after all. I'm not
So if it
protecting
is to be
anyone.
demolished and an order is staring at your face,
But the fact remains that the SDO is not even the authority to pass. the
you have not challenged that order also.
I am.
Could have challenged. You could have challenged because there was a direction against you. If you are a party, you could have preferred an appeal. If you are not a party, even then you could have preferred an appeal.
If your lordship directs, I
No,
can.
no, you are saying that the SDO is,
What I'm
has,
saying.
Panchayat has not passed an order.
what
You
I'm-
cannot say that unless you have preferred an
No,
appeal.
no, what I'm saying is what the statute says. That is
Sir,
what
an
it-
order is staring at your
No,
face.
sure, I'm
So you have to
vouching for that.
comply with that order
I
or
vouch for that.
face the
But I am
content
only-
proceedings.
What I am submitting for this honorable court is that what the statute says. That is the only submission.
Yes. Yes. Call the next matter.
Lordship, 7 to 9 is the learned advocate is appearing virtually.
Lordship, I appear.
Yes. It's
Chief,
extension
I
of
appear
interim
for-
order.
Yes, my lord. But I appear for the petitioners, my lord, in item number 7 to 9. Lordship would recall, my lord, it's the
7
same
to
set of
9 are
matters.
identical matters.
Yes, yes, your lordship.
What is the issue?
Yes, sir.
My lord, the issue is same, my lord, as in, my lord, the other
Where is
matters.
Mr.
my lord,
Pritam Das? Where is Mr.
Lordship,
Pritam
led by
Das?
Mr. Pritam Das. He is also online, Lordship.
Oh, Pritam Das is online. Yes.
Yes.
Yes. What do you say?
Lordship, this is the same set of matters wherein, my lord, wherein your lordship had earlier, my lord, on the last occasion, my lord, extended the interim orders, my lord. This is regarding, my lord, that, my lord, the ration dealers, my lord, it's in the same area, my lord, where we cater to, my lord, a notification has been issued, my lord, and our, my lord, DRCs, my lord, this is
A
Dismissal.
similar issue is pending
Yes,
before the
yes,
principal
yes,
bench.
yes,
I think I have passed an order on.
Yes, your lordship, my lord, my learned friend is
29th October, Lordship.
ওই তিনটেতেই একসঙ্গে করে দিয়ে দেবে।
Lordship, before your lordship starts dictating the order, my lord,
আপলোডিং এ অসুবিধা হবে না তো?
my lord, before your lordship starts dictating the order, my lord, the only difference, my lord, is that in, my lord, item number 7, the first interim order was passed on 27th of September, and in item numbers 8 and 9 on 4th of October.
The learned advocate appearing for the petitioner prays for extension of interim order. First up, since the issues involved in these writ petitions are same and identical, the same are taken up for hearing analogously. First up, the learned advocate appearing for the petition submits affidavit in opposition has not yet been filed.
Not
No,
filed,
my
Lordship.
lord, not
That
yet.
is up to the time.
That till date, the respondents have not filed any affidavit in opposition. Full stop. Time to file affidavit in opposition is extended by a period of 8 weeks from date, semicolon, reply thereto, comma, if any, comma, be filed within 2 weeks thereafter. Full stop. It has been uniformly submitted by the learned advocate for the respective parties that the issues involved in these writ petitions are also pending before the principal bench. Full stop. It is the learned it has also been uniformly submitted by the learned advocates for the parties that the issues involved in this writ petition is identical with the issues involved in a batch of writ petitions being the lead case being WPA number 2104 of 2024 in the case of Sunil Agarwala versus State of West Bengal and others. First up, the interim order is extended till the disposal of the writ petitions. First stop. This writ petition shall be heard analogously with the batch of writ petitions, the lead case being WPA number 2104 of 2024. Full stop. Parties will be at liberty to mention these matters after the period fixed for exchange of affidavits is over.
Grateful, Lordship.
Obliged, my lord, deeply obliged, deeply obliged.
Yes, call the next matter.
Lordship, I am appearing in item number 10.
10, yes. Yes, give your appearances, 7, 8, 9. Yes, who is appearing?
I am appearing for the petitioner in item number 10. Lordship.
is appearing virtually, my lord.
Yes, who is appearing for the state? Yes. Mr. Paul for the state? Yes. Yes, what is this matter?
Lordship, this writ petition 2061 is coming under West Bengal Public Land Eviction of Unauthorized Occupants Act 1962. There was a representation made to the authority, that is the respondent number 2, and also representation made to the other authorities who are the government representatives. And in spite of that, those representations were not considered. Though, if your lordship comes to page
Yes,
number
who is the
19 of-
authority?
My lord, the district magistrate, but my lord.
Oh, district magistrate, I think is the appellate authority.
No, section.
No, lordship,
my lord,
appellate authority is divisional commissioner.
No, who is
Lordship,
the
divisional
authority?
commissioner is the appellate
my lord,
authority.
he is not entitled of that, my lord, this, because of this, my lord, written instruction, my lord, kindly see. হ্যাঁ হ্যাঁ কোন অ্যাপ্লিকেশনটা কোথায় রেসপন্স যে করলাম আমরা
No, I could not follow your instruction. One thing is said that he is to state the provision of law. That is for you. He has made a representation, initiate a proceeding as per the appropriate provision.
I am for the private respondent. I have a twofold submission before your lordship in this respect.
Yes, yes.
Lordship, first of all, they had approached before the learned executive magistrate under section 144, which is still pending. Suppressing this particular factum, this writ petition has been filed. Number one. Number two, lordship, that 144 proceeding was challenged before the Honorable Sessions Court, and by taking cognizance of this order, by passing an order 24th of 9, 2025, the motion was admitted and direction was made upon the writ petitioner to appear before the court, which is fixed on 21st of November 2025. This entire factum has been suppressed here. Now the simultaneous proceeding is going on over the self-same cause of action. Number one. Number two, the petitioner has purportedly claimed that he is the owner of a particular land. That is absolutely contrary to the record, because his ownership has been disputed by the owner himself.
Petitioner, yes, the petitioner has filed this writ petition. The petitioner has paid for a direction upon the respondent authorities to take steps in terms of the representations submitted by him, praying for removal of encroachment on public land. First up, the learned advocate representing the private respondent submits that the petitioner has approached the learned executive magistrate under the provisions of section 144 of the Criminal Procedure Code, and such fact has been suppressed by the petitioner in this writ petition. First up, let affidavit in opposition be filed within 4 weeks from date, semicolon, reply thereto, comma, if any, comma, be filed within 2 weeks thereafter.
A direction will be given to decide the section 4 application by the
He
collector.
says another before the executive
My lord, if
magistrate.
you see Lordship page 19.
Lordship, that is in respect of my ownership land.
There was already
no.
Adjoining.
page 19.
Page 19 notice issued.
Yes, my lord.
Yes, Lordship. That is what I was
Irrigation
pointing
Department,
out
my
by annexure P3.
That is in 18th June 2025.
How can, Lordship, the self-same cause of action, how to
And the
simultaneous
executive
proceeding
magistrate
can
has
be?
nothing to do with
Cause of
that.
actions are totally different, Lordship.
Certainly not. Certainly
I
not.
have filed 144 in respect of my private land, Lordship. That has
No.
got nothing to do with the
That-
public land. I'm
that-
coming up over here for the
Such
public land,
fact has
Lordship.
been,
Lordship,
suppressed. ঠিক আছে? Affidavit in opposition টা কেটে দিন। The learned additional advocate general draws the attention of the court to the notice dated 18th of June 2025.
Yes, my lord.
18th of June 2025 issued by the subdivisional officer.
No, my lord. My lord, the irrigation department, my lord.
Irrigation department, Lordship.
Is the
My
subdivision.
lord, that is the designation, not SDO.
the
Actually, the
No, not the SDO.
Yes, yes.
The
my lord.
subdivisional officer, Mohananda Link, Canal
Canal.
Subdivision.
Yes, my lord.
Link cannot subdivision.
Subdivision number 4, Roman 4.
Lordship, may I,
Number
Lordship,
4.
I have a submission to that
Uh,
effect. Lordship, one
stop.
sub.
Since the notice has been issued by his which respondent?
Respondent number. Irrigation.
7, sorry, Lordship. Respondent
No,
number
no.
7.
Respondent number 5. Since the
Respondent
notice has been issued by the
5.
fifth respondent, comma,
Respondent number
WPA number such and such stands disposed of by directing the fifth respondent to conclude the
My lord,
proceed.
two will conclude. District magistrate. Collector. Section 4, my lord.
What happened?
No, my lord, nothing. Water, no.
By directing the district magistrate Jalpaiguri being the second respondent to conclude the proceeding initiated by notice dated 18th of June 2025
Yes.
in accordance with law, after giving an opportunity of hearing to the petitioner, comma, the private respondents or any other parties who may be affected by such decision.
Lordship, may I, Lordship, kindly, kindly hear me.
Present order
Before-
shall be communicated to the parties immediately thereafter. The entire exercise shall be completed
Your
as
Lordship, on day
expeditiously as
before,
possible, but positively within a period of 6 weeks
Lordship,
from
I
the
have-
date of communication of this order.
Lordship, day before yesterday, your Lordship has passed a direction in the over self-same cause of action in the same property to the Mohananda, to the executive magistrate, executive engineer Mohananda Link Canal Division to pass a necessary order upon hearing of all the parties in a particular writ petition. So that will be a conflicting one. Your Lordship has passed. That is in writ petition number
Executive-
WPA.
Which order? Where is that order?
Yes, the order is there. My friend is heading over the copy of the order 1772 of 2025.
Executive engineer.
Executive engineer Mohananda Link Canal Division.
So I'm directing the executive.
Well, can you see the provision of section 3?
But he
No.
says in the earlier matter the
No,
executive
no, earlier
engineer
one
has-
has required.
Lordship, there are other issue also. The petitioner
Eviction
claimed
Act,
his.
Lord. Public Premise Eviction Act, there is only the district magistrate collector is the competent authority to issue notice and to decide the matter.
But notice has not been issued by the district magistrate.
That's why, my lord,
Yes.
on the basis of
Then you have to issue a fresh notice.
yes, notice has not been issued. This is the reason, my lord, on the basis of a notice issued by the irrigation department, this section 3 application to be invoked.
How can the writ be maintainable? Because there is a parallel proceeding is going on. The title dispute is there. Suit
All
is
right,
pending.
Bring that order tomorrow.
To Monday.
wait করে দিন, কেটে দিয়ে লিখুন। The learned advocate appearing for the private respondent submits that concerning an identical issue, an order has been passed. When the order was passed?
27th of 10, 2025.
On 27/10/2025. Full stop. List this matter next Monday under the same heading. Please bring that order.
My lord, affidavit of.
Both the matters.
No.
This matter.
No, that order, I want to see that.
That order is there.
My lord, affidavit of service.
I'm keeping it on Monday.
Wait.
I think Lordship is asking for the 144 order.
No.
Affidavit of service.
This is with regard to the same.
Yes, same property. The where this writ petitioner is not the owner actually, and the original owner who himself has disowned his title.
But the allegation is same.
Not only that, Lordship, the petitioner.
Lordship, the property in schedule, if you honor, Lordship.
No.
Property in schedule, that is completely different.
No, absolutely not.
Respondents are trying to mislead this court.
No, absolutely not.
I have lodged the
Fight
144
amongst
proceedings
yourself.
in respect of my property, Lordship.
No, certainly not. Because Lordship, I am saying.
Let them show the schedule
Then
of that.
I will
144
use the
Lordship.
affidavit. I will use the affidavit. Then I may be granted liberty to file affidavit. Because there's
But
the
whatever they have to say, they can go and say before the collector.
No, because the very title is dispute. The very title is with the particular owner who the writ petitioner who
are there, they have to be referred before the collector.
they cannot the collector cannot decide the title.
Mr. Chaudhary, please give the statute.
Are the private respondent challenging the title of the property in question, Lordship?
Yes.
Are they claiming to be the owner of that?
No, I'm not that. The petitioner,
the petitioner, the owner of the property which is over challenge over here.
See, I have a specific contention and submission that the petitioner who claims as ownership over the plot of land, he is not the actual owner because the original owner, because the ownership.
I think he cannot understand what I'm submitting, Lordship.
My learned friend is saying that only because of a particular structure he is being aggrieved of, or he is being obstructed to get access.
The adjoining plot of land.
The writ petitioner said so.
The petitioner has paid for a direction upon the respondent authorities.
One more writ petition is also pending. Sahad Ali.
Lordship, in that I am not a party, neither have received any communication.
They have sought for addition of party.
Of the petitioner for removal of illegal encroachment from the public land. Full stop. Paragraph. The learned advocate appearing for the private respondent submits that the petitioner has approached the concerned executive magistrate under the provisions of section 144 of the Criminal Procedure Code for the self-same cause of action, and such fact has been suppressed in this writ petition. First up, the learned additional advocate general submits that in view of the provisions laid down under section 3 of the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, 1962. The collector is the appropriate authority to take steps for issuance of the show cause notice and to proceed thereafter in accordance with law. Full stop. He further submits that the petitioner has have you submitted any representation before the
Yes.
collector? Yes.
Yes, my lord.
Yes.
Lordship,
Full stop.
Page
The
22.
page 20.
22.
the
21.
20, Lordship.
in view thereof, the district magistrate, Jalpaiguri being the second respondent, is directed to consider the representation of the petitioner dated
13th July. 30.
July 30, 2025, and to take appropriate steps in accordance with law.
Lordship, my right of
Full
audience.
stop. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 8 weeks from the date of communication of a server
Lordship.
copy of this order.
Lordship, my right of audience, Lordship, before the magistrate, before the district magistrate, because I have
Giving an opportunity of hearing to the petitioner, the private, not in accordance with law, it will be open to the said respondent to issue notice upon the persons who may be affected by the action of the said authority.
Nice, Lordship.
Grateful.
Grateful, my lord.
obliged.
Yes, next, hey, take the mobile. Yes, call the next matter.
So next matter, I am for the petitioner, Lordship.
Your Lordship, I'm appearing for the National Highways Authority of India, respondent number 8.
Lordship, I am for the petitioner, Lordship. I have one problem, Lordship. It may be taken up on Monday. I'm my personal ground. So I'm not ready otherwise.
Your Lordship, this matter may be easily disposed of today itself. If Your Lordship takes a look at page number 37 of the petition, Your Lordship will see that this matter is pending before the competent authority for land acquisition. And as such, the writ petition itself is premature because an order has not been rendered by the competent authority.
Yes, what steps have you taken? Who is appearing in this matter?
Lordship, I am for the petitioner. So one day accommodation for my personal ground, Lordship.
Yes, nobody is appearing for this state.
No, sir.
Somebody is appearing.
Oh,
Sorry,
you are
sorry.
appearing. Who is appearing
Yes,
for the state?
I am for the petitioner.
He is for the. You are for the state.
Petitioner.
Petitioner state. Who is appearing for the state? Where is Mr. Shah? Additional Advocate General is here. He is not taking responsibility for the state.
Take it without brief. I can do it but without brief.
Yes.
What is the matter?
The land acquisition matter, National Highways. Notice has been issued by the Special Land Acquisition Officer, asking the petitioner to appear on 18th of June.
Yes, my lord.
So,
Thereafter,
what
no,
happened thereafter?
my lord, then I'll see instruction. my lord.
All right.
Your Lordship,
List
if I may.
Learned Additional
Lordship, if I may.
Advocate General appears for the state. Now, in spite of service, you have served upon the state.
Yes.
Every service filed in every service filed in court today is taken on record. In spite of service, none
DP service
appears
ko, sir.
for the state. The learned Additional Advocate General who is present in court appears for the state, appears and prays for time. You are appearing. I'm keeping it on Monday. Appears
Kindly keep it, my lord, Tuesday because the instruction
all right. Appears and prays for an accommodation to take instructions. Pustup as prayed for by the learned additional advocate general list this matter Tuesday date the other one under the same heading. Next.
So
call
instead of
the-
Tuesday, Lordship, it can be Thursday.
Mr. Shah, ask anyone of the state advocates to remain present.
See, it can be Thursday. Lordship, it can be fixed on Thursday instead of Tuesday. Lordship, it can be Thursday.
No. You may go to other court, ask any one of the state advocates to be present. So that in case the state is not represented, I can ask him to take instruction.
Kindly fix
Okay,
Thursday, my lord.
Thursday, Lordship, instead of
Thursday.
Tuesday.
Not Thursday. Then next circuit. Yes.
No, Lordship,
Next.
Monday.
The appropriate.
Yes, call the next matter.
Lordship, Monday.
Monday, not Monday, Tuesday. Yes. 12.
Lordship, item number 12, Mr. Das is appearing on virtually.
Your Lordship,
lord,
I
I'm
beg to appear
appearing on-
virtually.
No, CGST.
Before your Lordship, this is a GST matter regarding registration cancellation.
Cancellation
Your
of
Lordship-
registration. On what
Your
ground?
Lordship.
Non-filing of returns.
Non-filing of return, your
Where is
Lordship.
the order of cancellation?
Your Lordship, order of cancellation is page 21, your Lordship.
Annexure.
Yes.
And
Any appeal
thereafter,
preferred?
Your Lordship, appeal order is page 30 onwards, your Lordship. It was disposed on
Dismissed on what
technical
ground?
ground. Technical ground, your delay of filing of appeal. Your Lordship, on a similar matter, your Lordship, on 28.
Appeal dismissed on merit or on the ground of limitation?
On the ground of technicalities, your Lordship. Delay
On the
filing of
ground
appeal. Delay filing of appeal, your Lordship.
All right, limitations.
Limitation ground.
Yes. Where is the order of the division bench?
Your Lordship has passed an order.
Yes.
I am just to refer that order. It is item number 20 of 28 of this month. Your Lordship has pleased to pass an order. I am having similar pair in a similar case.
That's 639. That's 639 by 14. 24.
Yes.
Yes, that's 639.
Ashwin.
Division bench order is there.
Yes. Who are you? You are a supplier.
Contractor.
Your Lordship.
You are a supplier. What business you are carrying? Acha, go ahead. Every service filed in court today is taken on record. This,
I am a government contractor and general order supplier. Similar.
where have you stated?
Similar nature of business. Government order supplier.
I do not find.
Page 17.
Huh? I do not find. No. In the
The petitioner has
petition
prayed for the
is mentioned in the arts, but not in the petition.
now the petitioner has challenged the order dated August 28, 2025,
So what happened over there?
passed by the Joint Commissioner of Revenue Siliguri Appeal Commissioner, CGST and CX. Full stop. By the order impugned, the appeal filed by the petitioner was rejected, being time barred. Full stop. The petitioner claims to be a government contractor and general order supplier. Full stop. The petitioner is a registered taxable person under the Central Goods and Service Tax Act 2017, for short, the CGST Act 2017. Full stop. The registration of the petitioner was cancelled by an order dated November 9, by an order dated
12.
December 13, 2022, with effect from November 8, 2022, on the ground that the petitioner has failed to file the returns for consecutive period of 6 months. First up, the petitioner challenged the order of cancellation of registration by preferring an appeal under the provisions of CGST Act. First up, the appeal filed before the statutory authority was dismissed by the order dated August 28, 2025, on the ground that the appeal was filed belatedly beyond the condonable period. First up, the learned advocate appearing for the petitioner places reliance upon an order dated April 9, 2024, passed by the Honorable Division Bench in MAT 639 of 2024 in the case of Shubhankar Goldar versus Assistant Commissioner of State Tax, Srirampur Charge and others, in support of his contention that the petitioner may be afforded an opportunity to remedy the breach. Paragraph, the learned additional advocate general, Mr. Bonik, learned advocate, appearing appears for the WBGST authority.
Central.
CGST.
Appears for the CGST authority. First up, he submits that the appellate authority
Passed a reasoned order.
passed a reasoned order after considering the materials on record. ঠিক আছে, তারপরে না এইটাই করে all right, so you have to file your returns, pay your tax, interest within a period
Portal
of
to be open, your lordship, portal to be open, your lordship.
yes, everything portal will be open.
And the condition, the return is required to be filed.
Yeah, portal to be
yes,
open, your lordship, to be mentioned, your
Subject to the
lordship, in the
condition
order.
that you will file the
Yes,
returns
Yes.
and you will
Everything.
open the portal.
Everything. So open the portal, your lordship.
Yes.
Kindly be including the order there.
Yes, that will be included. Yes,
Grateful,
next.
grateful, obliged.
Petitioner lordship, the transfer matter lordship.
Transfer matter.
Inter-district from Kuchbihar to his home district Murshidabad. Lordship, I have made a representation before the secretary.
Yes, Mr. Goes for the board.
Page number 30 is pending consideration from the end of the board.
Yes.
Page number 30.
Yes, I think similar orders were passed. Where
Yes,
is that?
Yes.
You don't have a copy. ওই ট্রান্সফারের যেটা আছে না, board will consider. Where is your representation?
Yes, page number 30.
Page number
30.
30.
30. And it will be respondent number 2.
Respondent number 2.
Secretary.
Of the board.
লাস্টে একটা লাইন লিখে দিলাম, কমিউনিকেশনের ডিরেকশনটা নেই। The second respondent shall communicate the reason or shall communicate the order to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of
4 weeks.
4 weeks from the date of receipt of the copy of this order along with the copy of the application. Copy of the application or representation?
Representation.
Representation dated
Representation.
page 30.
Page 30.
Representation, what is the date of the representation? You have not given any date.
Postal receipt.
Yes.
Postal receipt says booked on 31st of December.
Copy of the representation which is annexed at page 30 করে দিন, which is annexed at page 30 of the representation. Please say করুন. Yes, next. Yes. 14, yes.
Petition, my lord.
The case for enhancement of the family pension contract
14.
and
My lord,
compensate ground service. What
uh,
happened?
General Manager BSNL, I am the counsel for General Manager BSNL, but no copy has been served upon the department. Yesterday, after going through the list, I contacted with the law officer. He told me that no copy has been received. In the morning, he told me.
Yes,
Because,
why do not?
my clerk said that he has served it yesterday.
No, no, no.
I don't know. He has said.
Already you consider what is your prayer?
Prayer, my lord, the husband of the petitioner has died during the service within 7 years. Now last quantum of maintenance is 29,000 something is the last pay. She used to get, she and her son.
50%.
No, she's getting 2,300.
He is entitled to 50% of the last drawn.
No, it was 29,000 something or the last drawn.
He is entitled to 50% of that. That is what I am saying. You are saying no.
And
So Bonik, please consider this.
Without going through the writ petition, at least
Already.
Monday or Tuesday, any day.
The learned advocate on record of the petitioner is directed to serve a copy of this writ petition upon Mr. Bonik, learned advocate, for the respondent authority in course of this day.
Fine.
Yes, when do you want?
Tuesday?
Tuesday under the same heading. Next.
Huh?
Birthday?
মঙ্গলবার বললাম তোমার সরকারি মঙ্গলবার বললাম
Lordship, in item number 15, I am praying for not this week, Lordship. Learned Senior, Mr. Bodhan Bhattacharya will be appearing physically. He is unavailable today. Lordship, kindly.
Will appear. Item number
And item 15,
Yes.
it is CGST matter, I am appearing on behalf of.
Kindly list the matter on Tuesday, Lordship. He will
15, file that-
physically appear. with
this-
Lordship.
15.
Yeah, insurance state or state.
He may be expired. He still expired. The vehicle was detained along the route.
64 hours delay. No?
Yes.
ওটাই তো 64 hours delay. দেখি আমরা কার পক্ষে
On the prayer of the learned advocate for the petitioner,
6 and 11.
list this matter
Tuesday.
on, when do you want?
Tuesday, Lordship.
On November 4th, 2025. Yes, call the next matter.
Machal.
Well, in this case, I am for the petitioner. Some document has not been annexed, which is required to be annexed. So if the permission is granted, they will annex it.
What is the document which you have not annexed?
That document is
What is the document which you have not annexed?
the ground on which the compensate ground appointment has been rejected. The ground paper has been annexed, that has been.
But you have not also challenged that order.
That order has challenged.
Where? When it was rejected.
It was cancelled.
July 2023 was cancelled.
Can-
That has not been challenged.
No, I have to look into it. I have to look into it. I have not gone through the brief thereafter, so that I require some time to, and some documents.
So I think it's better if you withdraw because those grounds are also not there. Only filing of those documents will not do.
Madam, kindly, shortly, I will review it and thereafter, yes, 2 days time to be granted.
The learned advocate appealing for the petitioner press for an accommodation. First up, list this matter in the next week. Next.
May I file the affidavit of service, madam?
No, I am for the opposite party, private opposite party.
Yes.
My lord, here the petitioner is aggrieved by the unauthorized construction which is being carried on by his neighbor who is the private respondent before your lordship. I have made, there are one ground is the unauthorized construction and second is the unauthorized commercial use of the garage, which is otherwise a
Who are you?
residential. I am the neighbor, immediate neighbor. This house, my lord, the private respondent's house
is adjacent to me.
What is the unauthorized construction made? Without plan or deviation?
Deviation. My lord,
Yes,
will-
who is for the private
my
respondent?
lord, kindly before your lordship,
And who is for the municipality?
My lord, may I?
my lord, before one, my lord, I had preferred a application of the under right to information. Now there, my lord, the municipality has replied.
Yes.
This kindly comes to page 47, my lord.
47, yes.
Yes, my lord, and the first point, my lord, at the end of that point is that I'm Manikpal Pita such and such. Manikpal is the private respondent. পৌরসভা অবস্থিত উক্ত জমিতে যে নির্মাণ কাজ করছে তার বিল্ডিং প্ল্যান আমার সীমানা থেকে কত ফুট দূরত্ব ছেড়ে নির্মাণ কাগজ
This is the RTI information you have sought for.
Yes, the reply is on the next page, my lord, that is 900 millimeter. And the next point is important, my lord. বর্তমানে যে নির্মাণ কাজটি চলছে তা কি তার প্ল্যান মোতাবেক ঠিকঠাক চলছে? The reply is no. না. At page 48, serial number 2.
All right, so I'm directing them to take
My lord,
step.
my lord,
Yes,
may
my-
I, my lord. My lord, this is a case, nothing but a jealous neighbor. The case is that I purchased the land from one Shushmita Seth.
No, you have made
May-
constructions in accordance with the plan.
In accordance.
Let
may I-
them
may I, my lord?
inspect.
May I, my lord? The petitioner make the construction by leaving 2 feet gap between the boundary wall and his house. My lord, as a, in the previous owner make a no objection to the present petitioner that you can construct a building by leaving 2 feet where the, my lord, the statute provide 3 feet. And my lord, upon
All right, so you place this before the municipality, let them consider.
There is no complaint, my lord, to my knowledge.
Let them
from the side of
consider.
the-
I will allow you also an opportunity of
But
hearing.
I also make a representation before the municipal authority, my lord, kindly see. My lord, let, my lord, both
That
the
is not on
represent-
record, my lord.
My lord, let, my lord, after,
That is not on record.
my lord, let,
Can they not file a representation at the time of hearing?
my lord,
If
let
your
both,
lordship directs, my lord, they can.
Yes.
my lord, let both
And
the
my lord, before your lordship passes the order, my lord, in the meantime, my lord, I am praying for an order of stay in the construction and my lord, use of the garage as a commercial
No, my lord.
place.
My lord, so far the garage is concerned, my lord, I rent the said premises and my lord, where one person, namely my
Kindly
lord,
seize the photographs, my lord, at page
All
50.
right. Where is your representation?
Representation, my lord, starts from page 33. There are series of representations, my lord.
Page 33.
Yes, my lord. 33, 34, 37, and the last representation, my lord, is at page 27. My lord will kindly direct consideration of the representation as page 41, my lord.
41.
Yes,
my lord,
41 is the comprehensive one.
yes, my lord. 27th of August, 2025.
Lordship can be near liberty to instate, my lord.
Yes, yes. The petitioner alleges that the private respondents are carrying on construction work in deviation of the sanctioned building plan.
As well as unauthorized commercial use, my lord.
First up, the petitioner alleges that there also has been unauthorized use of a portion of the premises by the private respondent dehorts the sanction plan. First up, the learned advocate appearing for the private respondent disputes the submission made by the learned advocate for the petitioner. First up, he submits that at the time of purchase of the property by the private respondent, his vendor provided him with a duly executed no objection notary affidavit and a declaration wherein it was clearly stated that during the construction of the neighboring building belonging to Sri Fotik Bormon, both the parties had mutually agreed to maintain a gap of 2 feet between their respective boundary walls in deviation of the minimum 3 feet as per the municipal rules, and the same was accepted by the municipality while revising the petitioner's building plan from 3 feet to 2 feet gap. Full stop. Since an allegation of unauthorized construction and unauthorized use of a premises has been made, this court is of the considered view that this court is has been made, comma, the municipality is duty bound to take steps in accordance with the provisions of the Municipal Act. Full stop. The municipality is duty bound to cause an inspection of the impugned premises and to take steps in accordance with law. Full stop. In the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of by directing the
Municipality responded.
Two and three.
by directing the
3 will be the proper matter, executive officer.
how can it be the executive officer? Municipality board of
Municipality,
councillors,
yes, through the
board
through
of
its tem-
councillors have to take steps by directing the competent authority of the municipality to depute officials for the purpose of inspection of the premises in question in order and to submit a report before the to cause an inspection of the premises in question and to take steps and to take further steps in accordance with law. Full stop. The competent authority of the municipality shall afford an opportunity of hearing to the petitioner, comma, the private respondent or their authorized representatives. Full stop. It will be open to the private respondent to produce materials in support of his contention that to produce materials in support of his contention that in support of his contention. Full stop. Paragraph. The reasoned order shall be passed by the competent authority of the municipality as expeditiously as possible, but positively within a period of 8 weeks. An inspection is to be carried out. 8 weeks from the date of receipt of a copy of the of this order. Full stop. In the event the municipality,
My lord, liberty may kindly be given to the petitioner also to produce additional documents, my lord, because we don't know what documents they will produce.
Petitioner will also be at liberty to produce materials in support of his contention at the time of hearing before the
In the meantime, my lord,
authority.
a stay of the
The municipal authorities shall take steps shall restrain the private respondents from carrying on any construction in deviation of the sanction plan. Yes, next.
18, I beg to appear for the petitioner, my lord. Very innocuous prayer, my lord. Here is my affidavit of service, my lord. My lord, the petitioner is the leaseholder of the, my lord, the Samobyong tea estate at Kalimpong, my lord. My lord, the tea estate belongs to the state government. The lease has been given for 99 years. Since then, the petitioner is running.
Who has encroached?
My lord, the private respondent has encroached, my lord. And my lord,
For the private respondent.
my lord, I have served upon them, my lord, video service with, but there is one difficulty, my lord. The server of the postal track report is not being available, my lord. Their
I
server
do
is
not
down.
know whether they have been served.
But I
or
have
not.
served before, my lord, the puja
You have
application.
sent, but you do not know whether.
My lord, because the postal
that-
service, they are not
well,
working.
What is to be done if there is an encroachment
Although, my lord,
on
my main
a
answer is,
leasehold property of a tea garden?
My lord, that cannot be allowed.
That cannot be allowed. And where is your representation?
my lord, my representation is at page number 53, my lord.
My lord, may I?
53.
Yes, 52, 53, my lord. And
But the
another,
officer in charge cannot decide the
my lord,
encroachment.
another BLRO at 51, my lord. And another fact which was after the writ petition, my lord, after the writ petition was filed, and in terms of section 3 of the West Bengal Public Land Eviction of Unauthorized Occupants, my lord, we have sent a notice to the district magistrate, my lord.
From the record, my lord,
That is not annexed with the writ petition, my lord.
It reveals that there was a, my lord, deed of conveyance even.
Yes, my lord, already it has been sold, my lord.
So, my lord,
that property has been sold. The
How it
TS
can be
part of
sold?
TS has been sold. That is the illegality that I'm trying to point out.
No. Look, here the scope is very limited.
My lord.
Here the scope is with regard to the encroachment.
Yes.
Officer in charge cannot decide the encroachment. So I'm giving you liberty to take steps in accordance with law. Officer in charge, no direction.
My lord,
The officer in charge cannot decide the issue.
May I suggest? No, he cannot. He is the police. May I suggest a report may be called for from the district magistrate and the.
But,
district magistrate
what
party,
can
my
be
lord.
done? The prayer is representation before the officer in charge. So I'm giving him liberty to take appropriate steps.
No, my lord, my prayer is, my lord, if my lord kindly comes to page number 16 to to take steps for removal of encroachment, my lord.
Upon whom?
My lord, the district magistrate is.
No, you have not made any representation
My
to
lord,
the district magistrate.
I have not. I shall be
So
candid.
make a representation that will be
I
considered.
have already sent a representation in terms of section 3 of the West Bengal, my lord, public land eviction of unauthorized. My lord, kindly
Is
dispose
to the
of to the district magistrate, my lord.
If that is there, the district magistrate.
That's why I said that a report. Otherwise, I do not know what representation he has made, or whether there is an encroachment or not, or on the basis of deed of conveyance. I do not know. It is there under the Khotian one, or it is a private land. So this is the short report. If he is called for, I will be able to address your lordship properly. This is the reason.
But that material is also because this is the writ petition is directed only against the officer in charge. Though you have made other parties, it's solely against the officer in charge.
Yes,
for
my lord, representation is against
that.
BLRO and officer in charge, my lord. I shall be.
So that
page
can be
number
decided.
51 is BLRO.
So if you have made, I will say that it will not. This
BLRO cannot do anything.
BLRO also cannot do anything. So I give you liberty to take steps. If you have already made, that is made.
My lord, kindly record that I have already made.
I will record that. Nothing. But no direction can be passed in this writ petition.
Kindly, let me have a record, because I didn't get
My
any.
research, I'm not passing any orders. I'm not passing any direction upon you. I will only record that he has made, but I will not direct consideration of that. The petitioner who claims to be a lessee of a tea garden have filed this writ petition alleging encroachment of the of a portion or entirety
Portion,
of a portion
not entirety
of the tea garden. First of the petitioner.
This is we are facing in entire Darjeeling district, Kalimpong, and even the Jalpaiguri, Alipurduar.
Why?
Encroachment of a tea garden.
And local people are selling this
You
property.
have to take steps because it's your, after all, it's your property.
Yes, my property. This is the this is the reason only I was very have to take steps in accordance to law.
So I will leave you free to take whatever steps, because he says that an application has been filed. So you can take steps even without an order passed by the court.
How my land can be executed a deed of conveyance if it's my land at all?
And
So you take once it comes to your knowledge.
Your writ petition even also you're doing fully well. There is a deed of conveyance. You also have made a party to the registering authority even.
The registering authority are parties, my lord.
Encroachment of a tea garden. full stop.
This point number 3 is addition of a register.
No, there is no such prayer in this regard.
Huh? Full stop. The petitioner further alleges that deed of conveyance have also been executed in favor of third parties in respect of portions of the entirety,
Portion, man.
portions of the tea garden. Full stop. Paragraph.
Total lease area 39.
The officer in charge is not vested with the power to decide as to whether a leasehold property has been encroached upon or not.
Or the BLLR.
Full stop. Neither the BLRO, no, BLRO can measure that.
Yes.
So BLRO, he has said fraudulent resale. I'm not going to, this is an encroachment. Full stop. BLRO likhben na. Full stop. Faced with such situation, the learned advocate appearing for the petitioner submits that in the meantime, the petitioner has also submitted a representation under Section 3 of the West Bengal Public Land.
West Bengal Public Land Eviction of Unauthorized Occupants Act 1962. Section 3 of 62.
Section 3 of the full stop. Paragraph. State is represented by the learned additional advocate general. Full stop. He submits that no copy of the representation filed under Section 3 of the 1962 Act has been disclosed in this
It is
writ
subsequent
petition.
to the writ petition.
Has been disclosed in this writ petition. Full stop. However, since the petitioner has submitted a representation before the officer in charge of the concerned police station for removal of encroachment, and this court has already observed that such authority do not have the power to decide on such issue. WPA number such and such stands disposed of by giving liberty to the petitioner to take appropriate steps in accordance with law. Full stop. It is, however, made clear that this order shall not preclude the competent authority of the state from initiating any steps in accordance with law.
My lord, the SPB directed there should not be any further encroachment. It's my property.
No, that
There
prayer
should
is
not be-
there, my lord.
Who is to be directed?
The local police should see.
How?
Otherwise, there
The-
is further
the,
encroachment, my land will go.
The learned addition at this stage, the learned additional advocate general submits that a direction be passed. Mr. Additional Advocate General, your officers, does it require the order of the court? He is bound.
That he is bound to do.
So
But
on your
on the strength
your
of-
submission, please appreciate this. I can record. I do not have any difficulty.
Because why I am making, because I can see there is a deed of conveyance.
I
That is my troubling me.
I appreciate that.
Any even if your lordship know, they are duty bound to do it. They have to-
Submits that a direction be passed upon the officer in charge. Which police station? Which you have said Goru Batan, and this is in the body you have made Lava police station a party.
Which police station?
The officer in charge of the concerned police station to keep a strict vigil at the locale and to maintain peace and tranquility at the locale.
Grateful, lordship.
I'm coming after 5 minutes.
23.
19 Millard, this petitioner Millard is a contractor Millard who has suffered 3 terminations. Termination of work order. Now, Millard, there are 3 writ petitions Millard filed. Millard, already in 1 writ petition, court has directed filing of affidavits because since it has been terminated, there is no scope of any interim order. I'll only pray Millard, let an order be passed for filing of their affidavits because we are questioning the termination on factual grounds.
Termination of
Work order.
contract.
What termination?
Where is the contract, Mr. Ghosh?
Millard, page 30, Millard is the.
The writ petition maintainable.
Millard, probably yes, Millard, because apart from this, I have no remedy.
Why?
Millard, civil suit is there, but
Not a civil suit. I think in this arbitration clause.
no, Millard,
Are
there is a dispute, not a, I won't say an arbitration clause as such. There is a dispute resolution clause in the contract, but that time period has expired.
That's for you. Why time period? Where is that clause?
Yes, Millard, kindly takes this, Millard.
Page?
Millard, I'll just place, Millard.
Millard, kindly cut 44, page 44, clause 25.
44, page 25. Yes.
Yes.
Settlement of disputes and arbitration.
And arbitration. Yes.
Both Millard there. Millard, it is said, except where otherwise provided in all the contract, all question and dispute relating to the meaning of the specification, designs, drawings.
Questions, claim, right?
Yes.
In any way arising out of the said contract. Termination is also.
Millard, all questions and disputes relating to the
Contract.
meaning of the specifications, designs,
Everything.
drawings.
Relating to contracts, designs also. It's
Yes,
very wide.
yes, but probably Millard
Whether arising during the progress or after completion or abandonment thereof, and shall be dealt with in the, as mentioned, if the contractor considers to be outside the requirements or disputes any drawings he shall be promptly within 15 days request in writing for thereafter the shall
give his written instruction decision within a period of 3 months from the date of receipt of the construction letter.
Yes.
Now, Millard,
that's-
Millard, now this period of 15 days, there is no power conferred upon the authority to extend this.
Then you lose it.
Millard, I have specifically stated that in my pleadings, that since there is no power conferred upon the authority to extend this period.
Mr. Ghosh, what is the ground on which you are challenging?
Millard, my ground is Millard threefold. Number 1, the initial design was absolutely faulty. That's why, Millard, I have also made the designing authority a party.
Yes. And what are the other issues?
Millard,
So faulty design.
Faulty design?
Yes.
Millard, several show causes.
Yes.
Millard would find in the record, Millard, there are.
Suppose can that be decided in a writ petition? Those are factual aspects.
No, Millard,
You can very well file a suit.
Millard, the procedure of termination. Millard, I am also on that you have served upon me at least 6 show causes without stating what was the reason prompted you to issue the subsequent show causes. So this itself is a procedural fallacy, not contemplated under the contract. The show cause has to be one show cause. The ground stipulated an opportunity of hearing or representation. Now, Millard, I will show Millard there are 6 show causes served upon me, one after another.
None of the show causes culminated into a final order.
Millard, I don't know what they mean by final order. If there are 6 show
Where is the
causes.
proceedings? Where is the provision for cancellation, termination?
Yes, Millard.
Suspension is 41 clause, page 49.
Suspension.
Proceeding for suspension and debarment.
Millard, Millard, I am aggrieved. Millard, I am aggrieved upon the invocation of clause 3. That is at page 34.
Page 34.
Yes.
So your contract has been terminated.
It has been terminated. Clause 3 has been invoked. And Millard, kindly seize Millard the impugned communication at 103.
imposition of
The time
clause 3.
limit to complete the work has lapsed.
They have allowed me several extensions. I have throughout I have communicated in writing what is prompting me or rather what is hindering me in progressing with the work. But no cognizance has been taken of those communications. But absolute mechanical exercise of power. And prior to clause 3, clause 2 has to be invoked. They have invoked clause 2, my lord, kindly cease, at least 6 times. Clause 2 has been invoked. Had I been so bad in progress with the work, they could have terminated me at the first instance. 5-6 show causes, 5-6 clause 2, then all of a sudden this termination.
Yes, file your affidavits. It's very difficult, Mr.
Well, I
Ghosh,
understand,
in this type of disputes, whether it's a faulty design or not a faulty design, writ court cannot go into those minute details because it's a difficult thing. It's better in a suit you could have, because as it appears, there is no arbitration clause.
Only that clause which your lordship
Not
has.
an arbitration clause, then the civil suit, because writ court, I do not know what.
There is a clause of arbitration, my lord.
Where?
Just because clause 25 said, my lord, settlement of disputes and arbitration.
Yes, but I could not
But,
find
my
that.
lord, I-
Where is that?
When this, my lord, dispute redressal committee, after giving a decision, if they are being agreed, then.
Where is that? Where is the
Well,
provision
I'll
for?
I'll-
I was searching for that, but I could not find that.
Yes, I just-
Because I was also the impression that first there are two tier.
Generally, that is what happens.
Two tier, first is the
Dispute,
in-house
reconciliation, mediation kind
Yes.
of a thing, then arbitration. But I
Here
could,
I do not
I
find
could
that.
not find any arbitration clause there. अरे वो तो है, clause 25 है, उसके बाद tier 2.
Is a GEC, my lord, general terms of contract.
I could not find that arbitration. Any other contract?
No, this is the only document which has been supplied to. Although belatedly, but this is the only document which has been supplied to. And according to the financial rules, Miller, this is the only consolidated contract.
The petitioner has challenged. Where is the order of termination?
Miller, 103.
103. So, Mr. Ghosh, you want a fresh design to be given to you?
No, Milord, my prayer is, Milord, recalling of this.
No, that
clause
is the,
3.
no, I was on the main dispute.
Yes, I want them to reconsider the
So you have
design.
not started the work?
No, it has started. It has started, Milord, initially, Milord,
When you detected this faulty design, Mr. Ghosh?
27% progress was achieved by way of, Milord, this shoulders and all. Once the main work was started, we detected that the lower water level, which was indicated in the drawing, is, Milord, unachievable, because that river does not go down to that level at any point of time in the year. And they have prepared a design considering the lower water level.
According to them, physical progress is 32%.
Yes.
Time elapsed is 385%.
Correct. That's right. Yes, this is the dispute. But Milord, several times we have done it, the main work, it gets washed away.
That's the, my lord.
The petitioner has challenged the letter of termination of contract dated June 20, 2025 in this writ petition. First up, in view thereof, there is no scope to pass any interim order. Full stop. The learned additional advocate general raises an objection as to the maintainability of this writ petition. Full stop. He submits that the contract contains a dispute resolution the contract provides for departmental dispute redressal committee to consider any dispute relating to the contract, whether arising during the progress of the work or after the completion or abandonment thereof. Full stop. He further submits that the contract also contains a an arbitration clause. Full stop. Mr. Ghosh Lanet, advocate appearing for the petitioner, disputes that the contract contains any arbitration clause. Full stop. Let affidavit in opposition be filed within a period of
3 weeks.
3 weeks, semicolon, reply thereto, comma, if any, within a period of 2 weeks thereafter, then 4-2 করে দিন. 4-2, parties will be at liberty to mention this matter for hearing after the period fixed for exchange of affidavits is over.
But even if arbitration clause is there, probably considering the recent judgments of the Supreme Court, my lord, that will also be questionable. Because person who cannot be an arbitrator cannot appoint an arbitrator also. So any internal, that TRF and
May not be,
Eastman-
Mr. Ghosh, here it does not say internal. Here it does not say internal.
Well, we haven't
There
seen
are-
the arbitration clause
No,
at
no,
the first place.
that is why I have recorded his
I
submission.
think he has not annexed the full sets of the contract below. Only
Yes,
CC
because that
has
apart merely because this purely a commercial contract.
Commercial contract.
So merely because one of the contracting parties is the state, writ petition is not maintainable. There is a series of judgments on that. Merely because one of the contracting party is state in a commercial contract, because this type of minute details that cannot be decided, factual aspect cannot be decided in a writ petition. Whether that design is a faulty or not.
Well, I am on the procedure also, because
procedure leads to.
Even if you succeed, Mr. Ghosh, on the procedure, even if it is set aside, then the ultimate thing boils to the default defective design.
well, that
That cannot be cured here.
Here it cannot be.
So
Well,
then again, you will say that I cannot perform.
No, well,
So what will be the use?
Well,
Ultimate relief, Mr. Ghosh, maybe you can succeed in this stage, but ultimately you will not get the final relief. Because that cannot be.
Until unless the clause 3 communication goes away, I cannot harp on that designing issue. That is my difficulty, because in clause 2 states.
But in a suit, you can challenge all. You will be getting a comprehensive relief there. Here, one, then again, same thing. So whether an infructuous order can be passed, that will also be an issue to be considered. If the ultimate relief cannot be granted, it will again be a standstill. Setting aside, you will say, yes, I cannot work again. Again, another termination.
Under the contract, they have the powers to modify the design. But until and unless the clause 3 communication is
Modification comes when it is detected, decided there is a fault. If they accept, yes, there is a faulty design.
From our end, there are communications, which they have not considered.
Yes.
Regarding this designing aspect.
Say, but the reply of the show cause ballot, we have specifically said, this reply cannot be sustained.
But we said, additional advocate general, can this not be solved if there is a defect? He has written to you unnecessarily. Even if accepting that his contract is terminated, then he will engage a fresh contractor.
Definitely.
Because you have to get the work done. Your idea is to get the work done. So you cannot also, if the design is faulty, you cannot also get the work done by another contractor. Same thing will happen.
True, my lord, but that has to be decided. that there is a faulty design or not.
No, I'm not saying that a decision of the court. I'm asking you because you have a body of experts in that. He has pointed out some defects.
That will be
Can
the,
you not take a
that will be the
decision on
best
that?
thing, my lord,
We
if-
have taken a decision, there is no faulty design, my lord.
You have communicated to him.
My lord.
Then it's
We have communicated, series of letter.
no. He says that we
No,
have
no,
communicated.
that's why I say the
My lord,
reply which was
regarding-
given
Lord-
as rejected because on the ground that these are the not defects as per the, my lord, the engineering, from the engineering aspects. my lord.
All right. Then, all right. Call the next matter.
22 to 3 is same matter, my lord. 22.
Same matter.
Your lordship can also can take a 22, same matter.
20 and 22 same.
Yes,
Same, my lord, 19 and 22.
19 and 22
yes.
is the same. Parties are same.
Parties are same, my lord,
Different contract.
only different.
Two
contracts.
concepts.
Tale-
My lord, in a, both the, my lord, the work, the faulty design can be, and we are executing the work, my lord.
Acha, 19 and 22 the same order.
On a separate order, but not.
Separate order but same order. Yes. Yes. Call the next.
My lord, in item number 20, I am appearing virtually, my lord. I am taking a leave to appear virtually.
Yes.
My lord, this matter is regarding a GST where the same liability or same point was raised by two wings of the same department. My lord, it is against the CGST department. My lord, where first there was an
Who
audit
is
under
appearing
section.
for the CGST?
Lordship, we have not received the copy.
You have not received.
Yes, Lordship. So kindly,
My lord, which-
my junior is there.
All right. Petition is directed. Mr. Agarwal, learned advocate, appears for the respondent authorities and submits that no copy of the writ petition has been served upon him. The learned advocate on record of the petition is directed to serve a copy of the writ petition upon Mr. Agarwal, learned advocate. How soon can you serve?
My lord, by today, my lord, let it be fixed on Tuesday, my lord. If it's
By today, in course of this day, list this matter on 6th. Yes, call the next matter.
21, my lord.
Yes. Yes. What is this?
The matter releasing the interest in revise. Interest on gratuity and arrear pension under revised ROPA 2009.
Interest on gratuity under revised?
Revised ROPA 2019. Lord.
Yes. We made all the corrections. Disposed of. Yes, next. 22 হয়ে গেল 19 is
23, my lord. Sorry, interest on gratuity, my lord. Here, my lord, petitioner is the widow husband.
widow husband. দেখি
23 millers, I'm appearing for the state. I'm being led by Mr. Das.
Yes. আসুন disposed of next.
Grateful millers.
24, my lord, same.
24.
Here, petitioner husband. Claim.
Disposed of next.
25.
My lord, I am for the petitioner, my lord.
Yes.
Petitioner pair for transfer on distance ground, my lord.
Transfer
Petitioner
on?
made on distance ground, my lord. Inter-district
ground.
transfer. Yes, my lord. Page 17, my application.
Yes. Who will consider?
My lord, DPSC, Chairman DPSC Coach VR. Respondent number, my lord.
6.
Respondent number 6, my lord.
Say transfer. Where is your representation?
Page 17, my lord.
No, this is intra-district. Then the
Inter-district
board has
transfer.
to consider.
No, my lord. Inter within same district.
But you have mentioned intra. In the representation, you have said intra, not inter.
Within same district, my lord.
Where is the representation? What is the
Page 17, my lord, my representation.
representation dated October 8, 2025. ঠিক আছে? The respondent number 6, chairman, Kuchbihar District Primary School to consider. ঠিক আছে? ওই the reasoned order যেটা বলা আছে না ওইটা বোধহয় অনেক কটাতে করা নেই। দেখুন the 6th respondent shall communicate the reasoned order to the petitioner immediately thereafter. The entire exercise shall be completed within a period of ওই দেখে নেবেন 4 weeks না 6 weeks যা করা আছে আগে করে দেখবেন transfer. Yes, next.
All same.
Same.
Same,
Where
my
is the
lord.
representation?
Page 17.
Transfer.
Page 17, my lord.
Where is the
Same.
representation page?
Page 17, my lord. 17.
Page number is also same.
Same, my lord.
Page 17 representation, September 18, 2025. ঠিক আছে? এটা হচ্ছে চেয়ারম্যান
DPSC. Respondent number 6.
Kuchbihar District Primary School
Yes.
Council being the 6th respondent. ঠিক আছে? আর ওইটা হচ্ছে communicate. The reasoned order shall be communicated immediately thereafter. যা টাইম limit আছে তাই। Yes, disposed of next.
Grateful, my lords.
Seven Lordship, I'm
Yes.
appealing for the Kuchbihar municipality.
Which municipality?
Kuchbihar municipality.
Kuchbihar, yes. Yes, what do you want?
Tender was invited by the Kuchbihar municipality for Kuchbihar Ras Mela, my lord. There is a criteria for the applicant for amusement and expo right, circus engagement, something. I for amusement and expo right. There is a eligibility criteria. Must be for 3 years experience. And another thing is that they must
Selection has been made.
Yes, Lordship, they have been disqualified in the financial beat, my lord. The person.
Have you
who has been
implemented the
chosen-
successful part?
At that time, my lord, I have no information that they have
They all-
cleared the bid, my lord.
No, no,
Without-
your pair B says for selecting, cancel the order for selecting.
My lord,
You are very much aware.
all
that-
present, they all knew, my lord.
That's the
this-
pair B, you know who has been selected.
My lord,
And my lord,
lord,
the deposition of 50% has been made, and my lord, work has already been
but I
started.
also made 3 lakhs.
This-
Since when the Rashmala is to start?
6th of November.
6th, Lordship.
6th of
So,
November.
it is almost done.
Kindly
So
appreciate me,
nothing
my
is
lord.
there.
There must be first, my lord, eligibility technical bid. Thereafter the final step. Technical bid, they did not qualify. But they did not.
My lord,
Any
these
person
alleg-
last time,
At the successful party,
my lord, last occasion, my lord,
work order has been issued.
Yes, your lord.
The
last
Work is
occasion,
almost done because
last
from
occasion,
6th is going on.
kindly show my learned friend, Samit, whether the candidate, selecting candidate passed the technical bid or not, my lord. They did not 3 years
My-
qualification, my lord.
All
My
have been
instruction, my
done,
lord.
all have been videographed, the allegations made by the
when the
no supporting
when the
documents,
technical
Lordship.
bid was evaluated,
My lord, they did not disclose, my lord. I don't have any
you
knowledge.
did not participate.
I participate on the.
So when? What is the date
My lord, last.
for opening of the technical bid?
My lord, my lord, my lord. My lord, submission was, my lord, on 17th.
Not the
date.
submission,
My lord.
opening of the technical bid. Technical bid, you are successful. Yes,
There is no disclosure when it will be opened, my lord. In the.
but
my lord, in
you
the-
said you are present,
my lord,
so you know the date.
My lord, there is a, my lord, there is a procedure for submission, my lord. I submitted with application. Thereafter, my lord,
Where is the notification? Show me.
my lord, annexure Fion, my lord, kindly see this is the notification. My lord.
You are on these amusement and expo rights.
Yes, ma'am.
My lord, in this context, my lord, I want to submit before your lordship, there is a suppression with regards to there was an agreement in the earlier occasion because at that time, earlier year, 2020.
Last date of submission was 17th of
Yes,
October.
ma'am.
So when the technical bid was opened?
But that I will have to take in.
And when the work order was issued?
My lord, let me, my lord, come on Monday.
I did not specify anything, my lord. Last year I participated.
My lord, that is what, my lord, what I am submitting. Last year, there was no, my lord, process of tender. My lord, there was an agreement between the petitioner and the municipality. And the petitioner was given the work, my lord, work order, my lord, at the amount of rupees 95 lakhs. My lord, that amount, lordship is, my lord, 15 lakhs is, my lord, still due, lordship. That has not been, my lord, that is not been, my lord, but here, my lord, in the petition.
They will say that my Mela will run for 25 days.
Petitioner
Last time Mela
has
ran
challenged
15 days, my lord.
the selection process of expression of interest for Rush Mela 2025. First of the petitioner has paid for setting aside, paid for cancellation of the order selecting the order selecting the highest bidder. First up, paragraph. The learned advocate appearing for the municipality submits that the work order has already been issued in favor of the successful bidder. First up, work has also been started in the successful bidder has also commenced the work, and the same is nearing completion as the Rush Mela is scheduled to commence on and from November 6, 2025. First up, the petitioner is directed to implead the successful bidder as a party in this writ petition. First up, let copy of the state is not a party. State is not a necessary party. Petitioner is directed to serve a copy of the writ petition upon the added respondent. First up, let affidavit in opposition be filed within 3 weeks from date. Reply thereto, if any, be filed within a period of 2 weeks thereafter. First up, there is no scope to pass any interim order at this stage. Parties will be at liberty to mention this matter for hearing after the time limit fixed for exchange of affidavit is over.
I'm
Yes,
grateful,
next.
your lordship.
Lordship, I am appearing for respondent, Lordship, and today only I have received the writ, Lordship. And it is a very huge writ containing 405 pages. So I have to take the instruction, Lordship.
Seeking for a short passover. My senior is on his way. We have challenged the show cause notice in this. And when we were in custody, your lordship, the DRC 01 was issued to us.
All right, so he wants time because he could not, only
Your lordship-
yesterday he has received the copy.
Yes, your
Good
lordship, but
morning,
only
Lordship.
short passover, your lordship, he'll address.
I'm making it
Your lordship, on Monday, we have to appear for the personal hearing. While the writ petition we have filed, we have received
appear, nothing will happen.
some
The
urgency.
learned advocate
At
appearing
2
for the
PM.
Mr. Agarwal, learned advocate appearing for the respondent submits that he has received the copy of the writ petition only yesterday. First up, in view thereof, list this matter under the same heading next Monday. Yes, call the next matter.
My lords, not Monday. My lords, Monday,
lord,
closed tomorrow and tomorrow. We'll have to take instructions, my lords.
Your lordship, on
Monday
Monday.
office is closed.
No, today and tomorrow office is closed. We have to take instructions.
Then Tuesday.
Your lordship,
Yes,
on
Lordship.
Monday, we have to appear for the personal, some urgency, your lordship, on Monday.
Appear, nothing will happen.
Today-
You know what steps to be taken.
my lord, in item number 29, I am for the state, my lord.
Yes.
My lord, the returnable date was on 4th of
Fourth, my lord. The matter is appearing today, my lord. The instruction is awaited.
Fourth.
Yes, my lord. Kindly see the returnable date, my lord, on the.
No, returnable date is 31st of October.
No, my lord. The copy was served to us day before yesterday.
Here is the date for.
In that.
Sir, what have you done? In the presentation form, you are mentioning the date of listing 31st of October. In the service copy on 4th of November. So this is not expected.
What happened, my lord? We normally instruct the client to clerk to file the same day. What?
Then give the presentation listing date accordingly.
Yes, I will do, my lord. Kindly fix on court, my lord. Paying apology, my lord.
The learned advocate appearing for the petitioner submits that through inadvertence in the notice issued to the respondents, the date of listing of this matter has been mentioned on November 4, 2025. First up, list this matter on November 4, 2025 under the subcommittee. Yes, next.
Deploy, my lord.
I'm for the petitioner, your lordship, in this matter. Your lordship has heard this type of matter on previous day, your lordship. Where is the show cause notice? We could not file our reply, and your lordship was pleased to direct us to the adjudicating authority to.
You could not file because it was uploaded in the additional notice.
Your lordship.
In this case, the additional notice and order tab was rectified, and it was rectified on, my lord, first for 16 January 2024, my lord. I have a judgment to that score, my lord. And the show cause notice in this case has been given on page 45.
Page
45, my lord. It had been given on 12/3/2024, 41. 41 page.
That is the show cause notice. Show cause notice is dated 12th of March 2024.
2024.
Yes.
So the additional notice and order tab was rectified on 16 January 2024.
So according to you, this was available in the normal tab also.
The thing has, what has happened, my lord? I am coming.
Though it was in the additional tab, but they could, while opening the normal tab, they can also view this.
View this because it was side by side.
Yes.
And in the notes itself, it is stated what notices are to be found in the additional notice and order tab. So now this excuse can no more be taken after 16 January 2024, my
Your lordship, we're relying on a decision of a division bench wherein the adjudicating authority, we were relied back only on the ground that no, we could not file any reply, and the your lordship, para number 6, the appellate is granted the liberty to file an application for lifting the ban. Not this one, your lordship, I apologize. Para number 4, your lordship, setting aside the order of the writ court wherein the direction to the appellate to submit his reply to the show cause notice dated 25 within a period of 3 weeks. Your lordship, only on the ground that.
But madam, they did not, could not or did not, whatever expression.
Appeal, my lord, they have an alternative remedy in this case.
Like
They can
the-
easily file an appeal, my lord.
What is the appeal? Nothing can be said because appeal, they cannot improve upon their case because the reply to the show cause notice is not there. That's the very basis of adjudication. If that is the very basis of adjudication, let them file a report, let them file a reply to the show cause notice, you decide it afresh.
Yes.
Otherwise, going to the appellate authority, they cannot improve because there is no reply to the show cause notice. They do not have their defense. They do not have their defense. You may be right that additional tab
That has been rectified. They have
that has been rectified, but the fact remains, reply they could not file.
Now, one thing I have to say, my lord, they are filing returns every year, my lord. They're seeing the people every year.
I'm not on that. So merely because they did not file, I'm giving them an apple.
Same petitioner files four writ petition with same allegation that they don't have the knowledge, my lord.
Your lordship,
This is purposely done, my lord. And that is why I'm saying nothing more, my lord.
your lordship, 4 orders are passed, we have.
But
There is an alternative remedy, my lord. Otherwise, they have an alternative remedy, my lord.
Your lordship, that order was passed in the month of January 2024, your lordship. If we go further, they will They will dismiss our appeal on the ground that the limitation and they could not have the ground to condone
It will
the.
be dismissed
Yes,
also.
only on the ground of limitation. They could not.
They can show all documents in the appellate protocol also, madam.
Will you allow?
Your
Yeah,
lordship,
earlier,
not go
in
into
one
the
of the
merits.
matters, I think, no, you did not appear. That was Mr. Agarwal appeared. Additional documents were not allowed, not
Yes,
taken.
your
Has to
lordship.
be, my lord,
That is-
actually is a continuation of the trial, my lord.
But that was rejected. So
Yes.
if it is rejected,
That
again he
is
has to come.
already doing, my lord.
Your lordship, on
I'm not
SGST,
saying-
we will not, they will not get into the
Direction in that
merits.
case, my lord, that
Unless, look, the documents will come unless there's a reply.
my lord.
Unless the reply is not there, there is a very, that is the very basis.
But this additional notice and order tab, my lord. This,
No, I'm
this-
not going into
That has
that.
to be stopped somewhere, my lord.
No,
If
no.
someone is coming
I'm
to
not on
take
that.
plea, my
Yes,
lord.
I will not go into that. I will not go into the communication part, but I will say that since this was not, reply was not given, I will give them an opportunity to decide it afresh.
I'm grateful, your lordship.
My lord, but they, even in the show cause notice, my lord, they were given the time, date and everything. That's in page number 45. The plea which they are taking, that they were not given the time and date.
No, page 40.
Your lordship,
All is
nay,
NA.
the
This is
TRC
page
0.
45, page 40, my lord.
Page 40, that is all NA.
Yes, your
My
lordship.
lord, kindly see the date of page 39, my lord. It's 12/3/2024.
Yes,
This is a summary show cause notice. It's written summary show cause notice.
yes.
Now, if your lordship comes to 41, this is a detailed show cause notice where the date, time, and everything is given in page number 45. My lord. The second paragraph. In the light of the, you are hereby given an opportunity to appear with the undersigned at 2:45 p.m. on 11/4/2024 to show cause as to why you shall not pay the amount of tax. It is not so that that
So
date.
which was uploaded in the additional tab?
My lord, both will be
Both.
uploaded in the additional notice and.
Your lordship,
But
no,
when-
actually, the
So
actual.
why are you in this, page
Yes.
40, why have you mentioned NA? A person may look at this and see, yes, he may take advantage. It's confusing. It's confusing.
My lord.
So if it is confusing,
Detailed show cause notice to answer the show cause notice.
if
my
it
lord.
is confusing and they
Benefit.
did not appear, so benefit of doubt has to go to them.
My lord,
I'm grateful,
supposedly
Your Lordship.
a person has to go through the detailed show cause notice in order to understand what reply they have to go. My lord,
He will not. He will not, because the advocate will say, yes, from
Sure,
this, no opportunity, this is a very good ground, it's sit tight. He did not go into the details.
the division bench, my lord, I've raised the same point, my lord, and division bench has allowed, because in the show cause notice, my lord, this date, time, everything.
Where is
was
that?
and I take it out.
Yeah.
All right, I'm not going to that, giving
My
an opportunity.
This one, I tried my best. my lord.
Yes. No, I'm also not going into those issues.
My lord.
I will consider that in another matter,
My lord.
which you are saying.
My lord.
So I'm not going into that NA issue.
My lord. But this petitioner, my lord, he's purposely doing it, my lord. It's purposely not giving the return in a proper manner.
Yes, from the name I find, yes, I remember. I think one of the matters I have.
Yes.
This in this writ petition, the petitioner has, where is the order of the where is the order?
Your lordship, order of the
Adjudication?
order dated 9/5/2025.
That's page 50.
50. So where is the show cause notice?
Show cause notice in page
12.
page 41, the detailed one. The summary is 39.
What is the ground on which the show cause was issued?
There was a pre-audit was due to some discrepancy, and after that,
Short payment of tax on outward supply and tax payable on higher charge receipt. Discrepancy is interest payable for the late filing of SGR.
So this is on the basis of an audit objection.
My lord.
my,
My lord.
On the basis
My
of
lord.
an audit objection.
yes, sir.
So this is the discrepancy notice was issued initially.
The show cause notice.
Show cause notice, DRC 01.
Stating about the.
So in the order at page 50,
My lord.
uh, this in this writ petition, the petitioner has challenged the order dated May 9, 2024, passed by the Joint Commissioner of Revenue, Jalpaiguri Circle, Jalpaiguri. Full stop. A show cause notice under section 73 was issued 73 of the WBGST Act. WBGST Act 2017 was issued stating that certain discrepancies were found by the concerned audit officer. First of all, no reply to the show cause was filed, and the adjudication under section 73 of the WBGST Act was made, determining the tax, interest and penalty.
Interest and penalty.
Determining the tax, interest and penalty for which period?
2020.
Where do I find that?
My lord, page 41.
For the financial year 2019-20. First off, the learned advocate appearing for the petitioner submits that the show cause notice was uploaded only on the additional notices and orders, put a double inverted comma moddhe tab, and not under the normal tab. First up, since the petitioner was not aware of uploading of such show cause notice in the additional notice and orders tab, petitioner could not file any reply to such show cause notice, and the order of adjudication was passed exparty. And then exparty order of adjudication was passed. And an exparty order of adjudication was passed. The Sarkar learned advocate appearing for the revenue submits that though initially there were certain defects in the portal, but subsequently the same was rectified. Where do I find that?
My lord, page number 11 of judgment, my lord.
Of this judgment?
Yes. Page, para 11, sorry, ma'am. Para 11.
She submits that after January 16, 2024, changes have been made to the GST portal, and the additional notice tab, double inverted comma, has been made visible. Full stop. She further submits that the show cause notice, comma, in the case on hand has been issued after January 16. Now, has been issued on March, I think.
12th March.
On 12th March 2024. And for such reason, the petitioner cannot, and for such reason, the show cause notice, and for such reason, it cannot be contended by the petitioner that that he was not aware of the show cause notice. First up, paragraph. Without entering into such dispute, this court finds that the petitioner finds that no reply to the show cause notice was submitted, and resulting in an exparty adjudication order being passed. First up, since no reply to the show cause notice was filed by the petitioner, this court is of the view that the interest of justice would be subserved if a last opportunity is granted to the petitioner to submit his reply to the show cause notice dated 12th of March.
Yeah.
Dated 12th of March 2024, so that the adjudicating authority can pass orders on merit and in accordance with law. First up, in view thereof, the order impugned dated September, order impugned dated 9/5/2024, 9th of May 2024, passed by the Joint Commissioner of Revenue, Jalpaiguri Circle, Jalpaiguri, is set aside with the direction upon the petitioner to submit his reply to the show cause notice dated 12th of March 2024 within a period of
4 weeks?
No,
3 weeks.
3 weeks from the date of receipt of a server copy of this order. On receipt of the reply to the show cause notice, the adjudicating authority shall afford an opportunity of personal hearing to the petitioner or his authorized representative and pass a reasoned order on merits and in accordance with law. To stop with the above observations and directions, WP number such and such stands disposed of.
I'm grateful, Your Lordship. Your Lordship, item number 28, Your Lordship has fixed, please to fixed on Thursday, Tuesday. Your Lordship, can it be fixed on Thursday because due to personal, my senior was not available on Tuesday, Your Lordship.
Thursday?
Yes, Your Lordship. I'll inform the other party, Your Lordship.
28 Mongolbar bolecho to Thursday.
Thursday. Your
Or I
Lordship.
can keep it in the next circuit bench.
No, Your Lordship, we have this, we were arrested, then the show cause notice was issued, a lot of
Thursday
things
for the-
Thursday.
Yes,
I'm
for the
grateful,
next
Your
matter.
My lord, in this matter, I am appearing on behalf of the Siliguri Municipal Corporation, my lord.
My lord, I am for the private respondent in item number 31, Lordship.
Who is for the petitioner?
Sutopa Saint Paul.
My lord, may I?
Reasoned order of demolition.
Lordship.
My lord, this is the third round of
May I-
litigation.
Oh, you are for
May
the
I-
petitioner?
No,
No,
my lord, I am for the private respondent, my lord. And
Yes.
initially, I instituted writ petition against this petitioner for their illegal construction, Lordship. Just two things to show, my lord.
None appears for the petitioner at the time of call. No accommodation has been sought for either. The private respondent and the municipal corporation are represented by their respective learned advocates. Since the petitioner is not represented, the petition stands dismissed for default. Yes, next.
Obliged, Lordship.
Yes, who is appearing for the petitioner?
My lord, I am appearing for the petitioner. I seek accommodation for Monday, my lord. Kindly keep this, take this matter on Monday because I cannot, I am not carrying the brief. It is in my chamber and due to
You are
water
for
logging,
the-
I cannot. I am for the petitioner, my lord.
When do you want?
Monday, my lord.
On the prayer of the learned advocate for the petitioner, list this matter on Monday. Yes, call the
Thank you,
next
obliged,
matter.
my lord.
I'm for the petitioner, your
Yes,
lordship.
again, Dotin Sikdar.
Yes, your lordship. Last matter, your lordship.
Last matter.
Last matter.
Yes.
Your lordship, on yesterday, Wednesday, your lordship has passed a similar order. We have.
Where is Miss Sarkar? Where is Miss Sarkar? What is the similar order?
On Wednesday's list, item number 30, item number 30.
What order was passed?
We were relegated back to the adjudicating authority to file a reply within 3
What is
weeks.
this issue? What is this issue?
Same, your lordship. However, in this matter, the show cause was issued in the year 2022, and the order was also issued in the year 2022. We could not file a reply.
Oh, this is the additional tab.
Yes,
Where
your
is
lordship.
Miss Sarkar? Ask her to come. Where is she? Pass over. Yes.
For the petitioner, my lord.
State's Primary School Council. Oh, you have to appear. You will get in. All right.
Yes, my lord. Monday.
Not today, Kodin. Yes, call the next matter.
Lord, I am for the petitioner led by Mr. Roy Chaudhary.
My lord, I am for the petitioner, my lord. My lord, this is the matter, my lord, pertains to reappointment of a trustee in a religious trust named the Jalpaiguri Temple Committee. But the second round of it.
Yes, yes, please give me a minute.
The second round of writ application on that issue. If your lordship kindly, my lord, may I submit, my lord?
Today intervening into the matter. Earlier, another writ petition was.
My lord, may I submit, my lord?
Filed and some orders were passed. That was not complied. And now this writ petition has been filed. And all the trustees are in charge. His writ petition is not at all maintainable and local standing to be questioned.
All right, what do you want?
I like to intervene into the matter. Let them serve a copy. I will.
Lord, they are not made a
My lord, may I submit?
Here's of Mr. Roy Chaudhary, my lord.
They are not parties. They want to intervene. They may have some right. They are some of the trustees.
My lord, may I have a very innocuous prayer in this matter, my lord? I think my prayer will not hamper their interest as well, my lord. If your lordship kindly come to page 90, this is the first round of writ application filed on this issue. The entire facts has been narrated and my lord, some direction has been issued in this matter. But may I place the order, my lord?
What do you want now?
My lord, the direction was if your lordship kindly come to page 92 of the order. My lord, I need to place the order, my lord, because the facts of this case is required to be appreciated, my lord. Your lordship kindly come to page 90, the order. The Jalpaiguri Temple Committee, my lord, and its secretary are petitioners of the instant writ application. The petitioners are challenging the order number 488, dated such and 489.
So you want quashing of the report of the search committee.
Presently, though that was my prayer, I'm modifying my prayer to the extent, my lord. I filed an application on that regard with the District Judge that your lordship will find in page 101 I want this application may be heard out expeditiously. That
Which
is my error
application?
first. My page 101. The liberty was given to me to file exception to the report of the search committee. Your lordship will, if your lordship come to page 100, your lordship will find that the search committee, my lord, filed the report in complete reverse to the direction passed by this honorable court. So, my lord, on that ground, my lord, on page 101, I filed.
Sir, this is a suit. In the suit, you have filed an application.
It is not a suit, my lord. The suit was decreed in 1941. A committee was
No,
formed.
I appreciate that, but you have filed an application in that disposed of suit.
In the execution proceeding. Well,
November matter is fixed for
it
hearing.
was going on for the purpose of, my lord,
So why don't you, why are you approaching the read court?
Because of the reason, my lord, because of the reason here the district judge is not.
Sir, you can approach the civil divisional court.
No,
if you want
lordship,
a direction.
because of this, my lord, district judge here in this case is not, my lord, district judge is not acting, my lord, the court under the Bengal Agra Assam Civil Courts Act. Here the district
But
judge
you have filed an application in connection with a suit.
So
the suit was pending before the district judge. So why are you not filing an application under 227?
May I submit? This suit, my lord, was not this suit has already been disposed of, my lord. Here, my lord, that this suit is no more in existence. It is, my lord, the district judge is exercising his power under the rules, my lord, framed in this matter, my lord, because of only for the purpose of keeping surveillance over the act of the, my lord, trust body. That the rules has been annexed, my lord. Your lordship will find the rules, the decree, page 62. Suit has been disposed of, my lord. By that suit, my lord, a committee has been formed, the trust body has been formed, and, my lord, by that decree, my lord, a rules has been framed. And by that rules, my lord, the district judge has been given power, my lord, to keep surveillance over the work of the trust body. My lord, by virtue of that rules, the district judge was exercising power. My lord, district judge in this case, my lord, is not exercising his power in view of as a civil court under the Bengal Agra Assam Civil Courts Act.
Yes.
So, I was also under hesitation whether 227 is the forum or 226 is the forum. But yes, I found that the district judge here, my lord, writ petition was entertained in the earlier occasion by the coordinate bench of this honorable court. On that understanding, my lord, that was, my lord, also the, my lord, the thing.
Show me that order that this point was decided with regard to the maintenance.
That is not. But lordship, the thing
now
is,
please satisfy me with regard to the maintenance of the 226.
Here in page 62, your lordship will find that Jalpaiguri Temple Committee Administration and Management of Trust Properties rules. These rules was framed, my lord.
Actually, why don't you serve a copy upon the trustees? Why have you not implemented the trustees?
My lord, trustee, my lord, the secretary has filed this application under the capacity which has been, my lord, kindly come to the affidavit part, my lord.
Sir, if there is a trust.
When district judge is filing in view of, my lord, rule 44 of the Jalpaiguri Temple Committee Administrative and Management Trust Properties rules. So, my lord, if your lordship takes the rule 44, the secretary has been given power, my lord, to represent the committee. And, my lord, if your lordship kindly page 52, the affidavit. The paragraph 1. Page 42, my lord. And, my lord, here the issue is reappointment of 2 trustees. They have been made party, my lord, that perform respondent.
No, since you have made 2 trustees, implement the other trustees.
I have
implemented only trustees.
No, my lord, I have implemented them because they are reappointed.
Sir, why are you afraid of implementing the other trustees?
No, man, I am not, man.
Please implement the other trustees, serve them a copy, I will hear you. Please implement the other trustees.
What is disturbing, my lord, the thing is, since they have now the appointment issue is already, my lord, the district judge is session over the issue. The committee is not presently is not in a position to function. That's why the matter has some urgency.
Please implement the other trustees. Ashun, Mr. Such and such learned advocate appears and submits that that all the trustees have not been implemented in this writ petition, and he has instructions to implement some of such trustees.
Five trustees.
Not my lord, some of the.
There are only 5 trustees.
7 trustees in total, out of which 5 trustees.
So
have
you are
appeared.
5. You are representing 5.
No, my lord, one has expired. So, my lord,
Lordship.
two
You are
trustees have
representing the
been
other
passed.
2.
Remaining
Yes,
is
I am
four.
pro
All right.
forma respondent,
All right.
implicated as a part.
So you are supporting the case of the petitioner.
Yes, Lordship.
Kyola, he has instructions to represent the 5 trustees of the
Remaining 4, my lord,
trust.
one has expired. 4, remaining 4.
5 trustees of the said trust. Mr. Petitioner is directed to implead the said trustees and serve a copy of the writ petition upon the learned advocate, said learned advocate. Full stop, paragraph. Yes, how soon can you implead us?
My point regards to maintainability.
Yes, the learned additional advocate general raises a point, raises an objection as to the maintainability of this application under Article 226 of the Constitution of India. Full stop.
The in view of the learned district decision of the matter and the application made to the learned district judge with regards to the appointment of such.
Full stop. List this matter. Yes, how soon can you serve? List this matter on.
Lord, may I point out one thing, my lord? My lord, may I point out only one thing?
Yes.
Out of 7, 2 have been made party, 1 has expired. So remaining is 4, not 5, my lord.
No. We are for 5.
He is saying he is for 5. Yes.
Well, let
let's
the
call the
copy
next
of the
matter.
addition of party application may be served upon me, my lord, so that I can implement them accordingly.
So
Copy
if
of the
you want,
governing
I am
application.
submitting Bhogalatnama.
no, if you want, I will direct them to file an application for addition of party. Then
But
their
have
application will come up. Then this writ petition cannot come up on Monday. Because
my
that
lord,
is to be allowed, then copy. And if you implead them, I can direct serving copies. Choice is yours.
my
If
lord,
you want, I will direct them to apply under.
let the name and the particulars of the parties whom he is representing.
Please, sir, please supply the names of the trustees so that he can implead. Yes. Call,
I'm grateful.
service technology.
I'm grateful.
Yes, call the next matter.
Lord, in 36, I appear for
My lord, can the matter be listed in the top of the matter so that I can present physically and appear, my lord? Physically. Madam, can the matter be fixed at the top so that I can physically appear?
No, that cannot be done.
So that I can go from Calcutta and physically
For
appear.
that, it cannot be fixed at top, sir. Everybody will come and say, I will come, fix at the top.
This is my folded hand, I'm praying so that I can physically come. Otherwise, the matter.
Your choice. Please come, appear virtually or physically, subject to your convenience. Will be taken up in its turn.
I'm grateful.
Yes.
I am supplying the name.
Yes, please supply the name. Yes, call the next matter.
My Lord, I'm for the petitioner.
Yes. What is
My Lord,
this
this petition is one of police in action. My Lord, a civil suit was filed by the petitioner and his family members.
Yes.
Now, my Lord, originally an order of ad interim injunction of status quo was passed, and my Lord, which culminated into an order under section 151 of the CP. Which
Show me the order of status quo.
My Lord, the first order of status quo is at page, my Lord, 23.
23.
23. 23, the relevant page is 24.
What is the suit for?
Not declaration and injunction.
Declaration and injunction.
Yes.
So who is in possession?
My Lord, the possession is disputed as of now. Possession is
So
in
how
dispute.
can that be implemented by the police authorities?
No, my Lord, I am not asking for that. Kindly takes up the order under section 151 at page, my Lord, 25.
25?
Yes, my Lord. 25. I'm sorry, my Lord.
28.
28. 20.
Yes, 28, yes.
28. My Lord, the last two lines, last two paragraphs.
Last two paragraphs.
At page 28.
28.
Yes.
Yes.
Therefore, I have no hesitation to hold that the petition so filed by the plaintiff has got merit, and at this stage and accordingly I allow the same on contest without costs. The officer in charge, Bhaktinagar PS, is directed to comply this order and also further directed to look into the matter for which the court's order will not be violated in any manner causing any serious breach of peace there.
Yes.
This was, my lord, the order essentially. Now, my lord, what happened thereafter is from page 51 onwards.
Yes.
51 onwards, my lord, this
Yes.
demonstrates the, my lord, construction that is being carried out by the defendants over the property. I have, my lord, approached the police authorities repeatedly. There are altogether, my lord, 10 numbers of complaints lodged with the police authorities. After this order, my lord, nothing has been done. I'm only praying for, all I'm praying for is, my lord, the police should keep strict vigil because, my lord, the intention of this order was not to, my lord, take the complaints and not lodge any and lodge sporadic FIRs or not take any action. The spirit of the order was constant vigil has to be on the property so that the order of the, my lord, learned civil court is not violated. That is all I'm praying for, my lord. The police has essentially not done anything. I'm praying for a direction on the police authorities.
Yes.
Four specific cases have been registered, out of which two have been who are pending. Vigilance is being.
No, any construction work is being carried on
Was
now.
arrested, now it has been stopped.
Yes.
Vigil is being made on the.
So four FIR has been launched by them.
No, are you making construction or you are not?
Yes, so now, in today, no construction is doing over, but lordship, is there admission that I am in the position, when they come to the page?
Sir, maybe you are in possession, nobody is disturbing your possession, but there is an order of status quo with regard to nature and character. So you cannot make any construction there.
Just there is no contract, but lordship, whatever the tin shed and the gate is concerned, that has been already been existed from the.
That
No,
is
that is
what it existed, it existed. Don't carry on any further construction work.
Lordship, that four, out of them, one available section that has been arrested.
That is a different. Yes, give me your report.
This is slightly marked.
This is the FIR. I have the.
How many cases you have registered?
Four lots.
4 cases and it has ended in charge sheet.
Investigation pending.
Is pending.
Lordship, in 2 matters, charge sheet has been filed, Lordship, and in 2 matters, cases pending, and Lordship, come to the second paragraph of this report, Lordship, in the last page, that
Yes.
we have arrested one person who had violated the order of the civil court, Lordship.
Yes.
And
Yes.
already police made the close vigil in the suit plot of land.
The petitioner alleges 30. Yes.
Last part. On such and such day.
Yes.
I again visited our land. I saw brick and this road inside the boundary wall, and one such and such who was present at that time told me that he was taken possession of the land in the rent of from the someone, but he could not show any document support of the state.
No, this is an admitted position. This I'm not disputing.
Divided provided information there. Lordship. Therefore, I am in the position.
All right. I'm not saying anything with regard to
Lord,
the
they are
position.
asserting their
Remain
claim.
in possession.
They have been no declaration because without position.
So that is a different thing altogether, but you cannot change the nature and character of the suit property. Alleges that in spite of an order passed by the civil court directing the police authorities to comply with the order of status quo passed by the civil court, no steps have been taken by the police authorities. Full stop. The learned advocate appearing for the state disputes such submission. He submits that on the basis of the complaints lodged by the petitioner, 4 cases have been registered, and out of the 4 cases, in 2 of those cases have ended in charge sheet and investigations in connection with the other two cases are proceeding. Full stop. The learned advocate appearing for the private respondent submits that the private respondents are in possession of the suit property and no construction work is being carried on by the private respondents in the suit property at present. Just a paragraph.
Street picture over the area and
All right. Record reveals that the learned civil judge, Junior Division Jalpaiguri, by an order being number 1 within bracket LATER letter bracket closed dated February 20, 2024, passed an order directing both the parties, passed an ad interim order directing both the parties to maintain status quo over the suit property in respect of nature, character and possession of the same as on the date of passing of the order till for a limited period. That order has been extended.
From time to time.
Order is continuing.
Yes, yes, yes.
It is not in dispute that the said ad interim order of status quo is being extended from time to time and the same is still subsisting. Full stop. It further appears from the record that the learned civil judge, by an order dated August 27, 2024, directed the officer in charge, Bhaktinagar Police Station, to comply with the order of status quo and to look into the matter and to look into the matter and see that the order of the civil court is not violated in any manner, causing any serious breach of peace there. Full stop. It appears from the order of status quo passed on February 20, 2024 that the learned civil judge, apart from directing status quo to be maintained in respect of possession, also directed status quo in respect of nature and character of the property in question. Thus, though there may be the learned advocates for the respective parties submit that their clients are in possession of the suit property. Be that as it may, the police authority is directed to be that as it may, the order of be that as it may, there is also an order of status quo with regard to the nature and character of the property in question. Thus, the police authorities are duty bound to comply with the order passed by the learned civil judge and to ensure that there is no violation and to ensure that the nature and character of the property in question is not altered. And to ensure that status quo in respect of the nature and character of the property is also maintained by the parties. Full stop. The police authorities are the respondent police authorities are directed to see that no breach of peace takes place at the locale and to keep a strict vigil at the locality, locale. Full stop. The concerned investigating officer is directed to complete the investigation as expeditiously as possible. Full stop. With the above observations and directions, the writ petition stands disposed.
Complete pleasure.
Grateful Lordship.
Not by this court. Approach the 227 court.
May I make a submission, my lord? In item number 1 today, I was a little late. So
Item number?
1, I was a little late. I got caught up in the rain.
What happened?
Well, I was in the matter. My name has not come up.
Your name has not been recorded. What order has been passed?
Well, it was disposed of on because matter has
Disposed
been-
of?
Yes,
Your
matter-
absence. Who appeared?
No, Mr. Learned AAG had appeared because it was resolved from both sides.
Oh, Namta, they got good. Please give your appearances.
Grateful, Lord.
জিৎ আমার নামটাও দিয়ে দাও। জিৎ আমার নামটাও দিয়ে দিও।
at the night, the IO comes, he says that part with 5 decimals of land in favor of his client. Else, I will arrest you. I will, and if you
Show me that statements made
Yes.
in this writ petition. Show me
Yes.
wherever you made those statements.
Paragraph number 20, 21. Paragraph number 20, may I read it for your lordship? To utter surprise of the petitioner number 1 on 11/8/2025 at about 6:30 p.m. at Pradhannagar near the town of Courtyard by Marriott, the police officials of Pradhannagar police station made him sign an arrest memo and took him to Pradhannagar police station and made him sit till night 1 a.m. However, the petitioner was asked to come to the police station.
No,
again.
with regard to the signing of the arrest memo,
Yes.
so that is in connection with that
This last FIR.
that FIR.
Last FIR.
So you can approach the jurisdictional court for that. You can
No, no,
approach
no.
the why?
No,
Why not?
No, for bail, for I'm not
Not for bail.
Not for
That-
quashing also.
Yes.
Not for quashing also.
No, for this illegal action, why can't you approach the jurisdictional court for that?
Now
That illegally an arrest memo
now-
was signed.
subsequently on the next day again I was made to asked to come to the police station along with my father. Paragraph number 21. I came there with my father. They made me sit in the police station.
Yes.
Now, Lordship, they made me sign in an agreement. The agreement is at page 12. Annexer P12.
Annexure P12.
P12, Lordship, it's at
Page.
page 98. Mutual agreement. Here, this is agreement between the petitioner number 1 and the private respondent, Shabnam Parveen.
Where is the signature?
Yes, signature, Lordship, it has been jumbled. Page 96. Habibullah Sheikh, the first party, and Shabnam Parveen. This agreement I was coerced to sign. I was made to sit in the police station. Now my point is, Lordship, that if you have to arrest me, if you have to make any investigation, you make investigation. You're staying within the 4 corners of the FIR. Why are you traveling beyond the FIR? And you're making me and my father sit in the police station and coercing me to sign on an agreement, asking me to part with my land, which was gifted to me by my mother. And if I don't do, they will further arrest. But however, I did not accept. I filed a writ petition. Subsequently,
Is which police station?
Pradhannagar police station.
Yes, Mr. Shah.
Subsequently, I have
that
been-
police station has the CCTV footage. CCTV is there. Report is a different thing altogether. Whether the CCTV is available,
Yes,
is
I was
installed in that.
sign in front of the. I have categorically made in paragraph number 21.
Please take instructions and come whether the CCTV has been installed. Please, 2:30. Come at 2:30. Please take instructions from from that police whether the CCTV is there. Mr. Shah, that is, I can keep it on the next day, but this is a serious allegation made against the police. So it has been specifically stated that it has been captured in the CCTV footage. Please take instructions, please make a call, please take instructions whether the CCTV is installed in that police station. Over phone call, you need not have to go. Whether the CCTV, or if you say so, I will direct the production of the CCTV footages. Because as per the orders passed in the public interest litigation, all police stations must have to have the CCTV installed there. So that is why I'm asking you, please.
Regarding covering this, let my instruction come on Monday. Let the matter be taken on in the instruction.
And the copy after this.
The petitioner has
My lord, only one
leveled.
Can you direct them to preserve the footages?
Has leveled serious allegations against the police officials of your allegation is against whom?
My allegation is against the IO lordship, the respondent number.
The investigating officer.
No, the IO.
IO is the investigating officer.
Respondent number 4. Inspector in charge, Pradhannagar Police Station.
Inspector in charge, Pradhannagar Police Station. কি বললাম? Serious allegations against the inspector in charge, Pradhannagar Police Station. Pradhannagar Police Station number 1.
One.
Please see. Number 1.
That's a typographical mistake.
Pradhannagar Police Station.
Pradhannagar Police Station.
Police Station.
Full stop.
One, that means the road.
Pradhannagar Police Station.
What?
Full stop. It has been alleged that the inspector in charge of Pradhannagar Police Station, being the 4th respondent, forced the petitioner number 2 to sign an agreement.
Petitioner number 1.
Paragraph 10.
Yes.
You have said paragraph petitioner number 2.
Petitioner number 2 is the confusing. Fathers, the Habibullah Khalifullah confuses.
You have stated petitioner number 2. I am reading from your petition,
Yes,
sir.
petitioner number 2.
Petitioner number 2 to sign an agreement in front of the room of the IO, and the entire incident has been captured in the CCTV of the concerned police station. Full stop. It has been further alleged in the writ petition that the
Seven.
petitioner was forced to sign an arrest memo and was taken to Pradhannagar Police Station on August 11, 2025, and was made to sit till 1 AM there. Full stop. It has been further alleged in the writ petition that the petitioner number 1 was asked to come to the police station again on the next day, along with his father, that is the petitioner number 2, and the petitioner number 1 was made to sign on a bond paper and was thereafter released. Full stop. The inspector in charge, Pradhannagar Police Station, is directed to file a report in the form of an affidavit. Yes, how soon can you file a report in the form of an affidavit?
Wednesday.
Wednesday. Wednesday is a holiday, so Thursday.
Thursday.
On or before November 6, 2025. Full stop. The authorities of the Pradhannagar Police, the Commissioner of Police, Siliguri Police Commissionerate, being the 3rd respondent, is directed to ensure that the
Let the report come and the
CCTV footages are to be preserved.
Yes.
with that,
Uh,
in that aspect, the report will come by.
No. Report, let the report come. CCTV footages are to be preserved. The Commissioner of Police, Siliguri Police Commissionerate, being the 3rd respondent, is directed to ensure that the CCTV footages of the Pradhannagar Police Station on and from August 11, 2025. No, these are the 2 dates.
2 dates.
10th,
The FIR was registered. 10th, on 10th August, the FIR was.
So you are called on 11th and 12th.
11th and 12th.
The CCTV are directed to ensure.
On and from.
Now, for the period from August 11, 2025 till August 12, 2025 be preserved. Full stop. List this matter. 6th.
Lordship, I'll be playing for one interim order, Lordship. in my, I've specifically stated that they coerced me to such extent that they said that if you are going to take any legal recourse, we will take further action. Sir, please.
What interim order you want?
Now I filed the writ petition. The petitioner number 1 has been arrested. I am only praying for no coercive step against the petitioner number 2.
Arrested, what coercive steps? That
Against the-
cannot be.
Against the petitioner number
No,
2,
if
3,
you
and
apprehend anything, approach. the
against the
competent
2, 3, 4.
If you apprehend anything, approach the concerned court. Yes.
Well, I'm appearing on behalf of the Siliguri Municipal Corporation.
Your Lord-
I am for the private.
Your Lordship,
Yes, yes.
My lord, this is against illegal construction, my lord. And if
You are for the petitioner.
petitioner, if you also kindly comes to page 96, my lord, this is my complaint, my lord. Based on this complaint, page 98, my lord, inspection notice was issued, my lord,
Yes,
wherein the date for inspection was scheduled on 13th May.
yes.
Thereafter, the date was rescheduled to 10th June, which is at page 99.
Yes.
And on receiving this inspection notice, I made a request that on such date, I'll be out of station for the treatment of my son. So kindly prepone the inspection. That was not considered. The inspection was held. If you also kindly comes to page 106 then.
Yes.
Notice of hearing was issued. Date was fixed for hearing on 30th June 2025. If you also kindly sees in the
Date of
notice,
hearing on?
30th June 2025.
Yes, you attended the hearing.
No, I made a prayer for adjournment. It was not, hearing was not held. My lord,
Yes.
if you also kindly sees that they have given some 5 points to 6 points indicating the anomalies, my lord,
Yes.
the illegalities. But there were other illegalities also, which your lordship will find at page 117, wherein I have requested for fresh inspection. Page 118 are these are the points which required to be inspected, which has not yet been considered till date. 118.
No, any order has been passed?
No, not yet.
My lord,
Hearing-
till date, no order has been passed. My lord, there was a subsequent notice, my lord, for hearing that was passed on 20th of September 2025. The hearing date was fixed on 25th of September 2025. But because of the ensuing puja holidays, my lord, the
Could not
hearing
be
could
taken.
not be taken up. My lord, so in that event, my lord, my most respectful submission before your lordship would be, my lord, they have made 6 points, that those 6 points were not being considered during the time of investigation, my lord.
Inspection.
During the time of inspection, my lord. Out of those 6 points, I find that 1 point has been considered. That is point number 2.
Where are his points?
These points are at page number 118.
118.
Point number 2 has been considered, my lord.
Point number 2 considered.
My lord.
So point number
1 to 6.
1, 3, 4, 5, 6.
My lord. Let there be a fresh investigation.
Who is for the private respondent?
Lordship.
Yes.
Lordship, all of these are covered if your lordship comes to.
Look, now the no order has been passed. Now, unless if an order is passed one way or the other way, and if it goes against him, he will again come and say, I was not given a notice, I was not there, I paid for an adjournment. According to you, there is no illegality. So I direct them to conduct an inspection in presence of both of you. Let them inspect, submit a report, give copies to both of you, and then attend the hearing. It will be considered.
Lordship,
What is the difficulty?
Lordship, one more thing, Lordship.
Because the authority is saying that other points have not been, because they are the best person to say whether all the points have been covered or not.
Officer of my court.
At the time, you can say because they were not present, it was an exparty inspection.
Well.
So let a fresh inspection be held. So
Lordship,
once for all,
One
that will be an end.
One thing I
to the
just
matter.
want to bring to consideration of this board, Lordship, that the building plan is not lying with my clients, Lordship. Neither it is lying with the petitioner.
No, it has not been handed over. I made specifically.
No, who are you?
I'm the owner of the land, my lord. Upon
And
which
who is he?
He is the developer. He is also residing here.
You are also residing
Yes,
there.
yes.
So, he has obtained the plan.
Yes.
because
You have obtained the plan or he has obtained the
He
plan?
has obtained the plan on my
So
behalf.
it has to be with you.
Lordship, it
Yes.
has lost and I have lodged a GD against it. In the
Say
month
so
of-
it has been lost.
This has been lost, Lordship.
So you have not given it to him.
There,
You have
Just
not
now he
given
said
it to him.
contradictory statement, my lord.
Lordship, thereafter, I have given a representation to give me a copy of that. Moreover, I have made a RTI application to the commissioner also.
Municipality is
No, my
having the
lord,
copy
no
of the.
representation has been made,
Lordship,
only a right
You are,
to in-
sir, all right.
Lordship, it is-
Let us not go into that. You are having the copy of the plan. In your municipality, will have the records.
Well, let him apply, my lord.
Lordship, it has been.
I'm not asking, not asking for that present. I'm not asking you to give them the copy. But I am saying that you are having the copy of the sanction plan.
My lord, has to be, my lord.
Has to be with you. So make an inspection because
My lord, an AIR number has to be provided along with the application for certified copy of the building.
that is for the certified copy.
Yes, ma'am.
Let us for the moment keep aside the certified copy. But for the purpose of inspection, you have the sanction plan, copy of the sanction plan in your office.
My lord, until and unless, my lord, to subject to correction of your lordship, my lord. Until and unless the number is being provided, my lord, it's very difficult because there are a number of plans, my lord. So it's very difficult to point out that this plan is for this particular building, my lord. So they,
Yes, sir.
they are-
You don't have any copy, any
Lordship,
reference
I think
number
the
also.
Number itself in the.
Where is that number?
Lordship, it is here at page number P10, Lordship. Annexure P10, page number 130.
113. Where is the number?
Lordship.
Plan number is given.
Yes, Lordship.
Plan number is given 529/in and the date of sanction has also
My
been
lord,
given.
deeply obliged, my lord. We shall.
Then you have the copy of the
My
plan. And with regard to this copy of the building sanction plan, I am directing you to consider
Deeply
upon compliance of all formalities, you can supply
deeply
them.
obliged. We will.
We have also asked for a copy of the plan.
Where is your application?
Yes. That hearing was conducted yesterday. my lord. With
For
regard to
that?
Yes.
So
yes.
well, we will be getting that.
Yes.
No difficulty. Where was your initial
Initial.
complaint?
On that page 96, annexure P4.
Illegal parking, encroachment, unlawful construction. The petitioner who claims to be the owner of the land in question states that states that pursuant to an agreement entered into between the petitioner and the private respondent, comma, the private respondent constructed a multi-storied building. Constructed a multi-storied building. Full stop. The petitioner further states that the private respondent and the petitioner are residing in separate flats in the said multi-storied building. Full stop. Alleging that the private respondent have illegally encroached the parking space and have made illegal construction at the premises in question, comma, he or she, petitioner is he or she?
He represented
She.
by he. Means the husband is not well, as a result of which the wife is being represented.
No, the who is the
Petitioner
owner?
She. Petitioner.
She.
The-
Petitioner is she.
My son and daughters are the owner. I'm representing them.
The petitioners, he or she, the petitioner lodged a complaint before the municipal authority. No, not the petitioner. The husband of the petitioner lodged the complaint.
Complaint.
The husband of the petitioner.
No. Petitioner lodged the complaint. Santosh.
Who is Santosh
Santosh
Poddar?
Poddar is a petitioner.
Santosh Poddar is.
Yes.
Oh, you have said Srimati Santosh Poddar.
Why?
Santosh Poddar to why?
Santosh or Santoshi?
No. Malad the property was later on gifted to the
Santosh is he or she?
she.
Santosh?
Yes. She.
ঠিক আছে। কি হলো?
Satisfaction, Santosh.
Not the police, my lord. Illegal construction and the
Yes.
first in question, the petitioner lodged a complaint before the municipal authority.
First up. Mr. Paul, learned advocate, appearing for the petitioner submits that pursuant to the said complaint, a notice for inspection was served upon the petitioner. So he further submits that since the petitioner, he further submits that the petitioner prayed for preponing the date of such inspection as the petitioner would not be available at the time mentioned in the notice for inspection. To stop, however, such prayer for preponement of the inspection was rejected and the inspection was carried out behind the back of the petitioner. Full stop. You have got the copy of the report.
No.
How do you know which on
In
which
the
points?
notice it has been reflected.
Yes, where?
Notice of hearing, it has been reflected.
Oh,
Page 106.
he further submits that the petitioner, he further submits that from the hearing notice dated June 25, 2025, the petitioner came to know that the inspection report only detected the inspection report states that there were only 6 within bracket numbers, NOS, 6 numbers of violation. Full stop.
Well, the report was handed over to her, my lord, that your lordship will find from page number 117 and except P12, last line. Our report has been handed over to me.
Oh, yes.
This is the memo number.
Yes, basically.
This is the memo number. Instead of
Careful,
this one.
all right.
Yes.
I'm recording his submission.
এটাই তো নোটিশ এটাই ওটা রিপোর্ট বলে লিখে দিয়েছি
The petitioner,
তো পেয়েছে
Mr. Pal further submits that since the petitioner was not present during the time of inspection, he could, Mr. Pal, please hear this. Mr. Pal submits that since the petitioner could not remain present at the time of such inspection, he could not point out certain other deviations in the impugned construction. First up, the petitioner thereafter filed a representation before the authorities of the municipality or municipal corporation, before the authorities of the municipal corporation, requesting the said authorities to conduct a further inspection on the points as mentioned in the representation dated August 14, 2025. First up, Mr. Pal submits that no steps pursuant to the said representation has been taken till date. Paragraph. The learned advocate representing the private respondent submits that the inspection was carried out after serving due notice to the respective parties. First up, the petitioner chose not to appear at the time of such inspection. First up, he further submits that all the points on which the petitioner has prayed for a further inspection are covered in the inspection report duly the inspection report pursuant to the inspection conducted on the inspection report dated inspection report dated June 25, 2025.
inspection করানো 10 জুন মানে
No, report is 25th of June.
Yes, madam. In the report, means in the office memo itself, the report is.
All right, 25th of June report dated. Full stop.
No separate report has been handed over. No separate report has been.
The contents of the report are.
The learned advocate appearing for the municipal corporation submits that in the representation dated August 14, 2025, the petitioner has referred to 6 points, and out of the 6 points, point number 2 is covered in the inspection report dated June 25, 2025, and the other points under serial numbers 1, 3, 4, 5, and 6 of the representation dated August 14, 2025 are not covered in the said inspection report. So, he however submits that the inspection report, the copy of the inspection report has been.
It is not included in the report, my lord. This has not been covered, my lord.
Which?
The point number 2, my lord.
His
This is
submission,
different.
I have recorded his
But I
submission.
record my submission, it is different.
কি বললাম?
Now.
Duly supplied to the petitioner. First paragraph. Mr. Pal, learned advocate appearing for the petitioner, disputes the submission of the learned advocate for the municipal corporation that point number 2 in the representation dated August 14, 2025 is covered in the inspection report dated 25th of June, 2025. Paragraph, it has been uniformly submitted by the learned advocates for the respective parties that no hearing pursuant to the hearing notice issued by the municipal corporation has taken place as yet. After considering the nature of the allegations made in the complaint, this court is of the considered nature of allegations made in the complaint, and also that the petitioner claims that he was not present at the time of inspection, and a prayer for adjournment was made prior to the date of inspection. This court is of the considered view that the interest of justice would be subserved if the municipal authority is directed to depute competent officials for a fresh inspection. Paragraph. WPA number such and such stands disposed of by directing the municipality to by directing the municipal corporation to depute competent officials and conduct for the purpose of inspection of the property in question after serving prior notice to the petitioner and the private respondents. At the time of inspection, the petitioner and the private respondents will be at liberty to point out, make their raise their respective contentions before the inspection team. Paragraph. After such inspection is such inspection shall be carried out as expeditiously as possible
within a period of 6 weeks.
But within a period of why 6 weeks? Within a period of 6 weeks from the date of receipt of a server copy of this order. The municipal authority is directed to needless to mention that the inspection report shall be served upon the respective parties. The municipal authorities are directed to pass a reasoned order after hearing the petitioner, the private respondents, or any other party who may be affected by such decision by reasoned order বলেছি? And such order shall be duly communicated to the parties immediately thereafter. The entire exercise shall be completed within a period of 8 weeks.
6 weeks too.
Within a period of 4 weeks after the completion of inspection.
Sorry, one more indulgence, my lord. My lord, if your lordships kindly point out that the individuals will be going for the inspection, carry the building plan along with them. My lord.
Who will? They do not have the copy of.
No, we will be carrying the building plan. Because let that be indicated in the order.
একটা line লিখে দিন. The learned advocate appearing for the petitioner submits that the sanctioned building
plan.
that the sanctioned building plan
Number.
is at present misplaced, and for such reason the private respondents have applied for obtaining a certified copy of the sanctioned building plan. Full stop. The learned advocate appearing for the petitioner also submits that the petitioner has prayed for supply of a certified copy of the sanctioned building plan. Full stop. The learned advocate appearing for the municipal corporation, however, submits that the sanctioned building plan is in the custody of the municipal corporation. Full stop. At the time of inspection, the inspection team shall carry the sanctioned building plan. Full stop. In the event the municipal corporation shall supply the certified copies of the sanctioned plan to the respective parties upon compliance of requisite formalities.
Deeply authorized.
Your Lordship.
Yes.
Your Lordship.
Record. Yes, call the next matter.
Your Lordship has passed over a matter, item number 33. Miss Sarkar is here, Your Lordship.
Item number?
33, Your
Who
Lordship.
is your other side?
Miss Sarkar is here, Your Lordship.
Where is she?
She was here, Your Lordship.
She has left. Next, call the next matter. Item number
39. And I am for the state.
Yeah, I am for the petitioner. Hey, briefly.
Yes, Mr. Dhar. Please keep a watch on your brief. Someone is taking away your briefs. That is the difficulty. Having so many briefs, that is the difficulty. Yes. Overaction, inaction at the same time cannot happen by the same police authority.
No, this is.
Already a probate case is pending. They have filed an FIR challenging that bill, my lord.
An FIR has been registered, my lord. As per their allegation, FIR has been registered.
To arrest the accused persons.
Yes.
To take the complete the investigation.
Notice has been served upon us.
To conclude the investigation.
Notice has been served upon us. We have complied that notice, my lord. What else? What are the?
Who are you?
I am the private respondent.
And who is for the state?
My lord, I am for the
We are
state.
for
To
the
conclude
state.
the
Lordship.
investigation.
Why? Now, wife is challenging the will of the husband, my lord.
Wife is?
A destitute wife is now coming to challenge the will of the husband.
My lord, to conclude the investigation, we have to seize the, my lord, the deed. But my lord, it is pending, it is already lying with the, my lord, civil just senior division.
Where is the complaint?
That is the difficulty.
Have you lodged an FIR?
Yes, my lord. Page 19, my lord, kindly see.
Page 19.
Yes,
FIR
ma'am.
has been annexed.
Yes, my lord. Last portion of the FIR, it is
Page 15 is the formal.
registered at a Siliguri PS case number 1047 of 2024, my lord.
The petitioner alleges
How it can be
that
interpreted now, my lord.
At this point,
no
my lord, let the police.
effective steps have been taken by the police authorities apart from registering a first information report on the basis of the complaint lodged by the petitioner. First up, the learned advocate appearing for the state submits that FIR has been registered and the investigation is in progress.
Also, my lord, 41
So,
notice has been issued to the private.
And notices and appropriate notices have also been issued. First up, Mr. Pal, learned advocate, appears for the private respondent. First up, he submits that the you are the wife. Submits that a probate proceeding is pending.
Yes, ma'am.
Submits that a probate proceeding is pending before the competent court and the dispute between the parties is purely civil in nature. First up, however, considering the fact that the complaint has been lodged and an FIR has been registered on the basis of such complaint, WPA number such and such stands disposed of by directing the concerned investigating officer to conclude the investigation as expeditiously as possible and in accordance with law. Next.
Lordship, item number 40, I am praying not today, Lordship.
Why?
Because the-
Infructuous, Lordship, I am for the private respondent.
Lordship,
Both are saying infructuous.
Lordship, I have
You
no
are
idea.
trying to prolong this.
Kindly see,
What is this? What is
kindly
this?
see the
petition?
prayer, Lordship.
Lordship,
From organizing Durga Puja.
Yes,
Yes.
Durga Puja is over.
And for the state, Lordship kindly sees this order. This has been totally suppressed.
Lordship, I am not in the.
Become infructuous due to a flux of
So
time.
the civil court has already
Asun,
granted
asun, asun, asun.
permission to hold the puja man. Kindly see.
All right, all right. In this writ petition, the petitioner has paid for issuance of a writ of mandamus directing the respondent authorities to stop the sixth respondent from organizing the Durga Puja. Full stop. Due to passage of time, the instant writ petition has become infructuous and the same is accordingly stands disposed of as infructuous.
Kindly records that they have suppressed the material fact. Civil
তার
court has
আগে
already granted
Granted us
permission.
permission to.
Mr. Paul, learned advocate appearing for the private respondent.
No, for the state.
Oh, you are for the private
I am for
respondent.
the private
Mr.
respondent.
Dhol, learned advocate appearing for the private respondent submits that the respondent number 6 organized performed the Durga Puja pursuant to the permission granted by the civil court in a pending title suit. In a pending
135 or
title suit number 135
of 25.
of 2025. Full stop. ঠিক আছে এটা উপরে দিয়ে দেবো তারপরে ডিউ টু প্যাসেজ অফ টাইম yes next
Your Lordships, I am for the petitioner, Your Lordships.
yes
Your Lordship, this matter pertains to seizure of goods and conveyance under the GST Act. Your Lordships, the very thing is this matter is appealable, but Your Lordships, what the fact is that I have not been given an opportunity to pay my penalty as per the provisions of section 129. Lordships, may kindly come to section 129 of the
but who
GST
is
Act.
appearing for the respondent? No one is appearing for the respondent.
Lordships, the matter has been served. It was listed in the list prior to the vacation as well, Your Lordships.
but
But
nobody is appearing not to
Your Lordships, the affidavit of
Previous
service is
service
there, Your
filed in
Lordships.
court today is taken on record. None appears for the respondents. So the petitioner is directed to intimate the next date of hearing to the respondents. Full stop. List this matter on Tuesday. Yes, next.
Grateful, Your Lordships.
Yes.
I'm for the state.
Who is for the petitioner? None appears for the petition at the time of call. No accommodation has been sought for either. The state is represented by its learned advocate. So since the petitioner is not represented, WPA number against us stands this for default. Next.
Wait, please, Your Lordship. Sir, I'm appearing for the petitioner in this case.
Yes.
My lord, I'm assailing the impugned transfer order on health ground.
Yes, you are challenging what?
My lord, the impugned transfer order, my lord, on health ground, my lord.
Transfer order?
My lord.
Lordship, I am for the respondents in this case.
You are for the bank?
Yes, Lordship.
Yes, transfer order on what ground? Order
Not on
challenging
health ground, my lord.
transfer
I've made a representation, my lord, giving a detailed explanation as to why the transfer should be reversed. My lord, that was rejected by the bank, my lord, in a very cryptic manner, my lord. Whereas their own guidelines, my lord, provide when a my lord, representation is to be dealt with, my lord, it has to be considered in a detailed way, and a reason order has to be passed. That was not done in my case, my lord.
Where is the order of transfer?
My lord, may kindly have the impugned order, my lord, page 121. Your Lordship will find page 122 onwards, my lord, my representation to the various authorities, my lord, as provided in their own guidelines, my lord. 121, my lord, onwards, it's the representation that I filed requesting reversal of my transfer order.
Sir, it's a transferable job.
It is a transferable job, no doubt, my lord. It is a transferable job, my lord. Here, my lord, the only grievance, my lord, that I have is, my lord, I am in such a health condition, my lord, that does not permit me to travel anywhere. And my lord,
Where is that?
my lord,
Where is the doctor certificate?
My lord, I have annexed my medical certificate from page, my lord, may kindly see from page 95 onwards. My lord, I have been transferred almost 9 times in a span of five years, my lord. I am also saying, my lord, the transfer is nothing but an act of vengeance, my lord, because I refuse to toe the line of my superior, my lord. That's why, my lord, I have been rampantly transferred from one place to another.
So no interim order can be passed. I can direct only exchange of affidavits.
My lord, my lord, I think for now, my lord, if your lordship, I am only making a very innocuous prayer. My lord may direct them to, my lord, in terms of their own guidelines, my lord may direct them to consider my representation.
Show me the guidelines.
My lord, my friend is there.
Yes, but Lordship, yes, Lordship.
Yes.
He can help you. My friend is there. My lord, may kindly see this guideline. This is guideline dated 31/3. I'll take your lordship straight to guideline number 19.
31/3 of?
31/3 to 2025. There's a internal guidelines dated on transfer policy for officers in scale 1, 2, and 3. My lord,
This is only a guideline, sir.
My lord, that is their
only
own
a guideline.
I appreciate, my lord, but that is their own guidelines, my lord. They ought to have to follow this. These are made, my lord, for the purposes of streamlining the process in the bank.
Lordship, may I be allowed?
Yes.
Lordship, first of all, the petitioner is in a habitual conduct of not joining any transfers which has been offered to him. This, since it is a transferable job. From way back 3-4 years down the line, he is not joining any of the branches. There have been lots of pecuniary proceedings against the petitioner, and it has been addressed. Lastly, he was suspended again on the request of petitioner. We have reconsidered and taken him back, and this order was given for transfer, because this place, Uttar Pradesh, there all the facilities, whatever he is asking for, is available. So that is what was the last order, but still he have not joined there, and again he have moved this writ before Lordship.
When the transfer order was passed?
But the transfer order was passed on 30th, my lord.
30th.
Of
30th
July.
of?
Lordship,
30th of
we
July.
can come up with affidavit
Before
with
the
all the
vacation.
required proceedings, transfer orders, his non-compliance, and rules and regulations where we can transfer again, because he is not joining anywhere. It is not a question that again and again he is transferred. He is
No, no,
transferred,
my
but
lord,
nowhere he is joining.
my
So
lord,
we
if
can
I may
come up with
kindly
the
interject
affidavit.
here.
Affidavits may be exchanged, and hearing can be done on that.
My lord, may kindly interject, if I may kindly interject here, my lord.
The petitioner has challenged the order of transfer dated July 30, 2025, issued by the third respondent. First up, the learned advocate appearing for the petitioner submits that the petitioner submitted representations against the transfer order, but the same were not dealt with in accordance with the guidelines of the Canara Bank. Full stop, paragraph. The learned advocate appearing for the respondent bank submits that the petitioner is in the habit of not joining the transferred place of posting. Full stop. The petitioner was previously suspended. Thereafter, the order of suspension was withdrawn and the petitioner was allowed to join. Full stop. Since the service of the petitioner is a transferable one, this court is not inclined to pass any interim order on the order of transfer. Full stop. Let affidavit in opposition be filed within 3 weeks from date. Reply thereto, if any, be filed within a week thereafter. Parties will be at liberty to mention this matter parties will be at liberty to mention this matter for hearing after the period fixed for exchange of affidavits is over.
One small indulgence, my lord.
Yes.
My lord, my lord may kindly observe that the pendency of this writ petition will not be, my lord, any
No, sir. I've refused your
impediment for my lord, for disposal of my representation at least.
No.
In terms of their own guidelines, my lord.
Yes, I will consider that. Yes, next, call the next matter.
I am for the state.
44,
Led by learned AG.
redress necessary order may be passed.
The learned advocate appearing for the petitioner submits that during the pendency of the writ petition, the grievance of the petitioner has been redressed. Full stop. The petitioner does not want to proceed any further in this writ petition. Full stop. In view thereof, the grievance of the petitioner has been redressed, and the instant writ petition has become infructuous. The instant writ petition has become infructuous. First up, in view of the submission made by the learned advocate for the petitioner, WPA number such and such stands disposed of as infructuous. You are for the state.
No, I am for the state led by
State is
learned AG.
represented by the learned advocate. Yes, next, call the next matter.
Item number 45.
I'm praying for a day's accommodation.
Why?
Mr. Vikramaditta Ghosh had to rush for Alipurduar, my lords. His father is unwell.
Father is unwell. All right.
In that case, can it be kept on Tuesday? My lord, I am for the state, my lord. Can it be kept on Tuesday?
On?
Tuesday, my lord, on 4th.
4th,
Yes,
many
ma'am.
matters have been fixed. 6th, on the prayer of the
My
Lord,
lord, my lord.
list this matter on 6th.
Deeply obliged, my lord.
Yes, next. 6 November tell you the yes, next.
My lord, I am praying for not to pay.
Why?
Because my lord, advocate on record, Ms. Dalia is not present and he has instructed me to take an.
Advocate on record is not present. You are here. You are the arguing counsel.
My lord, there was a train accident, my lord. And my lord, some postmortem report was there, my lord, that we need to take instructions also from the railway that whether she has received it or not. My lord, kindly fix on Monday, I will do with the matter.
On the prayer of the land.
Copy has not been served.
With the service the near.
On the prayer of the learned advocate appealing for the respondent submits that no copy of the writ petition has been served upon him. First of the learned advocate on record of the petitioner is directed to serve a copy of this writ petition upon the learned advocate representing the respondents by Monday Kodin to establish this matter on 4th.
Right.
Next call the next matter.
My lord, upon him I will start.
Others you have said you have served. Yes. 47.
47 Milords, I appear for the state.
Yes.
My lord, I am appearing for the DPSC Kuch Bihar, my lord.
Yes, what is this?
My lord, transfer application, my lord. Yes, my lord, inter-district transfer.
So school council is the effective respondent.
Yes, my lord.
Respondent number 6.
Yes, my lord, respondent number 6.
Where is the representation?
Presentation.
Page 25.
Page 26 onwards, Milords.
25 or 26?
Milords,
So where is
26
before
is
this?
before the DPSC.
Primary school council is the 27. Primary school council. You got page 27 is the prayer for transfer on medical ground. Page 27. ঠিক আছে? ওই chairman, Kuchbihar District Primary School Council, being the 6th respondent shall consider.
Lordship,
ঠিক আছে?
as well as the distance, medical ground as well as the distance.
Distance. It is also distance. Where have you stated?
Lordship, in the second para of
Yes,
the.
as well as distance. Correct.
Grateful, Milords.
Grateful, Lordship.
Next, disposed of. Next.
Item number 48, Lordship, I am for the petitioner, Lordship.
Yes.
Lordship, previous occasion, Mr. Paul will appear in this case.
Yes, Mr. Paul. Why are you not appearing?
No, this is the fresh new matter, Lordship.
No copy has been
Challenging the rezoning order, previous writ petition and mandamus appeal, Mr. Paul will.
Previously, I appeared, my lord, in the first round of litigation, my lord. No copy has been served upon the copy of the AGP.
Post করা হয়ে গেছে।
All right, I'm making note today.
Lordship.
Next. Call the next matter. 49.
49, my lord, again, I'm praying for not today.
Why?
Mr. Ghosh.
Oh, Mr. Ghosh. All right, not today. Next.
50.
I'm for the petitioner, my lord. এটা তো এটা প্রশান্ত
Yes.
আমার petitioner If you also kindly comes to page.
What do you want?
12, my lord, notional benefit, my lord.
Notional benefit.
Under
Why?
2.19, my lord. If you also kindly comes to page 22, my lord. My lord, this is the recommendation.
Who is for the state?
My lord, copy has been served, my lord.
Who is appearing? You appear for the state also. You are in the panel of the state. Appointing you as an amicus.
My lord, this has been settled, my lord, if you also by the division bench also, my lord.
Page 22.
No, 22. My lord, this is the recommendation, my lord. If you also kindly sees the post in which selected, my lord, the column, my lord.
Yes, what is the
assistant teacher
for the state
level, upper primary, English, UP, and the
English, yes.
Yes, and the vacancy code is SC, vacancy roster number 7.
Vacancy roster number, yes, 7. Yes.
Now, if you also kindly come turns to next page, the school where I was recommended does not have that vacancy, my lord.
Yes.
My lord, accordingly, I made a representation. Accordingly, the next page, my lord, the DI of school has requested the chairman, secretary, West Bengal Central School Service Commission to recommend, there is an alternative vacancy. Kushiabari, Haleshwar.
Yes, that is the alternative
Yes,
vacancy.
Yes. Thereafter, further recommendation has been issued.
By the
Page
commission?
25, yes.
In that school?
No, yes, Kushiari school, next school. Malad.
Yes.
Malad, thereafter, I joined, appointment letter was issued and I've joined. Malad.
Yes, now what
if-
happened? What is the problem?
Now, yes, Malad, if you also kindly see the first recommendation.
Oh, you want effect from that date?
Yes.
Initial date?
Yes, that is the judgment by the division bench. Malad, page 51, Malad. Wherein this effect was given, Malad. Effective portion is at page 7, Malad. Yeah, 57. Effective.
Effective is page 57.
57. And as per ROPA rules, I have to complete 6 months before July of the year, of that year.
So you could complete how
yes,
much?
Yes, I could have completed if the recommendation was
No, how much time you completed?
4 months up, approx.
2 months deficit.
Deficit.
So if the first recommendation was
Yes,
there,
yes, more than 6 months. It was in the month of November.
yes, who will appear for the state?
My lord, I am for the state, my lord.
Yes, what do you say?
My lord, I have sought for instruction, my lord. The instruction is to arrive on Monday, my lord. Let it be not today, my lord. I'll come back with instruction on Monday.
Well,
Not today, next.
Get from them.
everything you know.
Next.
51 नहीं तो.
Lordship, this matter already conclude last day, Lordship, Monday ka.
Already?
I am for the state, my lord, in this matter.
Item number 51 disposed of?
No, my lord. It was not disposed of. It was transferred.
Not
Placed before
transfer for the principal bench.
Before the principal bench, yes.
Oh. আচ্ছা 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 না এটা কিন্তু
Manrega
এসএসটি
scheme.
বলছো তো ও ফাইল
51. 51.
Two 2039 52
51, my lord.
52 is same as 50. So I'm making it not. You are here.
My lord, I am for the state.
You have instructions.
No, my lord, not instruct. I have no instruction.
You have heard and now you are saying you have not instructions.
When the division bench has already decided, there is no scope for instruction.
Representation is holding pending. Let the representation be considered.
Why is that?
Right of the
issue has been decided by the division bench.
Yes.
Please go to the judgment of the division bench. Come on Monday, please
Yes.
go to the judgment.
Yes.
Yes, next.
So 53, I am for the petitioner.
Yes.
53, I am for the state led by MS Bedasruti Basu.
Affidavit of service was been made, Lordship.
Yes.
There are two private respondents, Lordship. One was been served, other has been returned due to some services. So the main crux of
Yes,
the
police help.
Lordship, police help. One, Lordship, only one for the implementation of the order, Lordship. Because already one learned court has passed an order regarding for the police authority to keep whether there is to keep police and
Show me the order of injunction. Ad
Lordship.
interim or final?
ad interim was been made, Lordship.
Show me.
Lordship,
Status quo.
uh,
Status
def-
quo order.
No, restraining the defendant not to disturb the peaceful possession of the plaintiff.
Show me that.
Lordship, at page number 23.
Page number 23 is the application.
Lordship,
Where is the order?
30, Lordship.
30.
Lordship.
Yes. And where is the order passed on 151?
Lordship, 151 order is Lordship at
Oh,
Page
2nd of May, the ad interim order, 16th of May.
they are regularly violating the said order, Lordship.
Lord, yes.
In spite of, Lordship, I have went to the police authority also.
Observation, your lordship have heard the matter. Your lordship asked the petitioner whether after the injunction they have been served the opposite party or not.
Lordship, it was been served, and as per his
Where is the
instruction,
evidence? Have you served here? Where is the private response?
Lordship, I have served, Lordship. But I have served, one has been duly received, other due to it has been written as per as the instruction of the adversary, it has came to me. And in respect of one, Lordship, it has been duly served.
In respect of one, who is one?
Lordship, private respondent number 6.
One of the private respondents.
One of the
have
private
received.
respondent. Lordship. There are two private respondent, Lordship. One has been duly served, and other one, as per as the status, it has been stated that the adversary instruction of the adversary. Lordship, the 151 police health order is at page 34.
This was allowed exparty.
This was
This
although
16th of May was also
Lordship,
exparty.
although at the continuance of
It shows that you are not in possession.
No, Lordship. I mean,
This shows you are not
Lordship,
in possession.
if it would have been the prima facie my injunction
Please
application.
protect your possession. Don't take the help
Lordship,
of police.
Lordship.
You know best how to protect your possession.
Lordship, the matter is that prima facie case, it appears that the injunction was been allowed by pursuing the documents which has been placed before the.
What are the
trial
documents to show that there is violation? Show me. What
Lordship,
steps have been taken? Nothing, no document,
Lordship,
no
151
material to show that there is
Lordship, the
violation.
order speaks, Lordship, kindly see the order of the injunction, Lordship. The said at the time of the plaintiff have supported its contention by filing the following documents, Lordship. These are the documents which has been filed by
There is
the.
already an order directing the police authorities to comply.
Yes, Lordship. I want that only, Lordship, to let
Why?
the police.
There is order passed. No order is necessary.
Lordship, kindly just to maintain peace and tranquility in respect of the said order, Lordship. Already the police.
No breach of peace. Yes, that
Yes,
time.
Lordship.
That order
That would be done because the police are sitting tight over the said order.
All right.
It is not less than a contempt, Lordship.
Lordship, already 126 of BNS has already initiated for
Yes.
breach of peace of
What is
the-
your instruction? Who
That
is
is
in
the
possession?
107, my lord. 107 case already been started, my lord.
I guess me also, that means.
Yes, yes. This shows that you are also not
Parties,
in
my
possession.
lord.
You are also violating, trying to take possession.
Lordship, let it be peace and tranquility in respect of the said order.
Breach of peace.
Breach of peace in respect.
All right.
That
Thank
is
you.
always.
That you will get. Kyolo, the petitioner alleges that in spite of an order passed by the civil court directing the police authorities to comply with the order of ad interim order of injunction passed by the civil court, the police authorities are not taking any steps in this matter. First of the learned advocate appearing for the state submits that the police authorities have issued notices upon the respective parties and appropriate proceedings have under section 107.
That is 126 BNS now.
107 has been renumbered as 126.
126 BNS.
And appropriate proceedings under section proceeding or prosecution.
That is a non-FIR PR number 861
Yes,
2020.
prosecution. An appropriate
Prosecution case.
Prosecution case under section 126 BNSS has been initiated. First up, since the civil court has already passed an order directing the inspector in charge to comply with the order of injunction passed by the civil court, there is no necessity to pass a further order directing implementation of the order passed by the civil court. First up, however, the police authorities are directed to maintain peace and tranquility at the locale. With the above observations, WPA number such and such stands disposed of. Evidence service filed in court today is taken on record. The learned advocate appearing for the petitioner submits. Which private respondent has been served?
Both the private respondents, 6 and 7 of the.
No, you said one have been.
One has been duly served.
Who has been duly served?
In respect of the lawyer, respondent number 6.
The respondent number 6 has been duly served. None appears for the private respondents. Yes, next. Next, call the next matter.
My lord, I appear on behalf of the petition.
Yes.
My lord, my affidavit of service, my lord. My lord, I am only praying for the notional benefit, my lord, nothing more than
Notional
that.
benefit for what?
My lord, my lord, according to the order of the honorable court, my lord, this present petitioner has been appointed as assistant teacher, my lord, page number 20. After that, my lord, joining letter, page number 40, my lord, given on 12/5/2023, my lord. And appointment has been given on 13/1/2024 after 8 months. My lord, I am wanting only after 8 months notional benefits, my lord. My lord, my representation, my lord, page number 39.
That has not been disposed of.
No, my lord.
Yes, you are appealing for the state.
Yes, Lordship.
What do you say?
Lordship, answering this one is the DPSC, Lordship.
DPSC. Oh,
Jalpaiguri.
who is appealing for the DPSC Jalpaiguri?
Yeah, Lordship, Saurabh Ganguly.
Saurabh Ganguly, where is he? No, 12th of May 2023, what happened? Why are you claiming notional benefit from that date?
My lord,
What happened on 12th of May 2023?
my lord, kindly come to page number 40, my lord.
Page
40.
40, yes.
My lord, on that day, my lord, that joining should be given. That has been directed, my lord.
Oh, Commissioner directed.
Yes, my lord. And my lord, on page number 41, my lord, after 8 months, my lord, appointment has been given.
The petitioner claims to be a land loser. Full stop. He or she,
He
was appointed as a primary teacher. Primary teacher.
primary.
He was appointed as a teacher in a primary school on
On my lord, 13/1/2024.
he was by appointment letter dated January 10, 2024, and he joined the said service on January 13, 2024. Full stop. The petitioner states that the Commissioner of School Education, by a letter dated May 12, 2023, directed the chairman, Jalpaiguri District Primary School Council, to give appointment with effect from to give appointment in compliance with the judgment dated 4/7/2012 passed in WP number 6339 within bracket W of 2006, read with the order dated 15/2/2019 in WP CRC 28 within bracket W of 2017. Mr. The learned advocate appealing for the petitioner submits that the petitioner submits that the respondent authorities are responsible for the delay in the appointment of the petitioner, and for such reason the petitioner was deprived of the benefits for a period of about 8 months. First up, the petitioner claims to have submitted a representation before the chairman, Jalpaiguri Primary School Council, dated, what is the date?
My lord,
Which was received by the office of the primary school, district primary school council on March 17, 2025. First of the grievance of the petitioner is that till date, no decision on such representation has been communicated to the petitioner till date. First up, the learned advocate appearing for the state submits that the district primary school council is the answering respondent. Have you served them? Everyday service filed in court today is taken on record. The learned advocate appearing for the petitioner submits that the respondents have been duly served. First up, in spite of service, none appears for the district primary school council. First up, WPA number such and such stands disposed of by the directing the chairman district primary school council being the
This one.
3.
being the third respondent to consider the representation of the petitioner which was duly received by the office of the district primary school council on March 17, 2025 and to pass a reasoned order after giving an opportunity appearing to the petitioner or his authorized representative and communicate the reasoned order to the petitioner immediately thereafter. First of the entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy of this order along with a copy of the representation which was received by the council on March 17, 2025. Question. Next. Yes. None appears for the petitioner at the time of call. No accommodation has been sought for either. In view thereof, CO number, WPA number such and such stands dismissed for default. Next.
This is item number 56 to 60. I'm trying for next circuit.
Why?
Lord, this matter, Mr. Day is appearing, Lord. 56.
Mr.
Shubinoy Day is appearing, Lord.
Yes, you are here.
Lord, I do not have the brief, Lord.
I'm giving you the brief. Let me see.
Lord, I am not prepared today.
How much time you require? I'm giving the brief to you. Please go through the brief, get prepared. Yes, what is this matter?
We are seeking
Yes, Mr. Pal, what is this
We are
matter?
seeking compensation. Where the railway is the requiring body, my lord.
Compensation for acquisition.
Yes, madam.
It has been acquired.
According to them, but we have to take.
According to you?
Madam, we have to take instruction, madam. These are all lab case of 2008 and 9, madam.
2008, 9.
Yes, madam.
Praying for next circuit, Lord.
We have to take instruction, madam.
No award has yet been passed.
Definitely award has been passed. But why they are claiming after for more than 13 years? That has 13 on this year. More than 18 months, 18 years.
Oh, this is with regard to the factor.
Factor 2.
Factor 2.
I think.
Factor 2. I think a wrong factor was applied.
Calculation sheet, my lord, we have challenged.
Compensation will be recalculated with the multiplication factor 2. Now, what happened after that?
My lord, we have challenged the calculation sheet, my lord. We have obtained the calculation sheet, my lord. After that, the calculation sheet, in the calculation sheet, factor 1 was calculated instead of factor 2.
So you know the facts, Mr. Das. You are saying I do not know the facts.
So, my lord, thereafter, my lord.
Yes.
We have come
yes, Mr. Pal.
We have to take instruction.
On the prayer of the learned advocate for the petitioner, list this matter before the next available circuit bench.
Lord.
Yes.
And 64, my lord.
Lordship, item number 60 is a different issue.
56?
60. 55, 56 to 60.
56 to 60?
Yes,
60 is a different issue.
and 64, my lord.
All right.
60 is a different issue.
Next circuit. Next.
And 64 also, my lord.
And 64 also.
Yes, next circuit.
Same matter.
Lordship, 60 is a different issue.
Only 60 is different as submitted by my lord.
And 64?
64 is different now. 58 is different.
Mr. Das, what are you saying? Say why you are saying same matter?
My lord, I do not have any instructions, my lord. My lord, I-
পরপর একটা একটা করে ডাকুন 57 yes. Yes, next circuit. Yes, next.
58.
Yes, 58. What is this matter?
Compensation, but not the.
Not the factor.
Not
This is the highways.
Yes. Not including factor.
All right. Next circuit. Next. 58 তো হলো বোধহয়। Next. Next circuit. Next.
60 is regarding North Bengal State Transport Corporation employee. He is asking for a consolidated
He's asking
pay
for
for consolidated pay that had been reduced. That had been reduced and he asks for an enhancement. in
Mr. Vikramaditya
consolidated.
Ghosh is.
Now, the answering respondent is the North Bengal State Transport Corporation.
Vikramaditya Ghosh is appearing. I shall
all
inform.
right. Next circuit. Yes, next.
And my lord, 64. My lord, kindly post the matter. Next circuit. 64.
Please wait. It will be called on. I've reached up to 60.
Item number 60, Lordship.
Next circuit.
Yes, 61.
My lord, item number 61, I am paying for next side.
Yes. What is this matter?
Basically,
My-
they're asking for stoppage of a.
Your Lordship, I appear for the private respondent.
My lord, I am for
My
the
lord, there is a
petitioner
civil suit which
hearing,
is
my lord.
pending, which my lord, my learned friend had absolutely suppressed before this honorable court. On the self-same issue, there is a civil suit pending from 2019, wherein my lord, they have filed their written objection, written statement, and my lord, an ad interim order as on date is subsisting. My lord, to maintain status quo on the nature and character of the suit property.
Mr.
My
Mondal,
lord,
will you
suppressing
allow
all
the
those facts, my
petitioner
lord,
to
they have
speak?
preferred this writ petition.
There is no suppression. Kindly go through the petition. You will find every
Absolute
documents
suppression,
and
my lord,
every
I'll show.
detail. There is
I
no
will show there
suppression,
are
Mr.
suppression.
Mondal. Let the petitioner first speak up. Let the petitioner to speak. You are always in a hurry. Let the petitioner to speak
I am
first.
always in a hurry because
My
you have
lord,
suppressed the matters before this
today I
court.
am not carrying
Kindly
the
come
brief,
to,
my
there
lord.
is a
My
title
lord,
suit
I am not.
237 of
Yes, who is
I am not
2019.
carrying the brief today, my lord.
Who is for the petitioner?
My lord, I am for the petitioner, my lord.
He is appearing virtually.
Yes, yes, yes.
My lord, I am appealing for the petitioner, my lord. I am not carrying the brief today due to my, I am not unable to open my chamber, my lord, due to water logging. So
What
kindly
do you
keep it
want?
on, kindly keep it on Tuesday, my lord.
On the prayer of the learned advocate for the petitioner, list this matter on 6th. Yes, next.
Deeply obliged, my lord.
Deeply obliged.
62.
62.
I want
Yes.
the estate.
Lordship, I am for the petitioner. Lordship, the petitioners are the legal heirs of the deceased land loser. And in this matter, Lordship, respondent number 3, the representation consideration has not been done yet. Page number 21.
Representative has not been considered as yet.
No. Page number.
Yes, special land acquisition officer.
Yes, page number 21 of the writ petition is annexed. That may be considered my humble submission.
21.
Page 21.
Next.
But my lord,
Yes.
presentation copy being complete. That could cover.
Yes, it's incomplete. You are right.
Understand it was genuine or not?
It's not genuine.
As it is, then why?
Page 1, yes.
It was received, your lordship. It was received.
Yes, receipt,
But where is the complete copy? This is not the complete copy of the representation.
How to understand from this?
Yes,
You have to give
he's
it
right.
up.
You make a fresh representation, I will direct them to
Lordship,
consider.
Lordship.
The petitioner
Lordship.
alleges that the property of the petitioner has been acquired, but the compensation amount, but no compensation has been paid to the petitioner till date. First of the petitioner claims to have submitted a representation before the Special Land Acquisition Officer, Kuch Bihar. First up, the learned advocate appearing for the petitioner submits that till date, no decision on such representation has been communicated to the petitioner. First up, the state and the National Highway Authority are represented. First up, the learned advocate appearing for the respondent authority submits that the representation, that the complete copy of the representation has not been annexed. First up, WPA number such and such stands disposed of by giving liberty to the petitioner to file an appropriate representation before the concerned authority. First of, if such representation is made, the concerned respondent authority shall consider the same and proceed in accordance with law as expeditiously as possible.
Grateful, Lord.
The above observations, WPA number such as disposed of. Call the next matter.
Your
My lord, I am
Lordship, kindly, may I permit to just mention one? Actually, your Lordship, item number 55. Item number 55, your Lordship, I was in courtroom number 3. It was dismissed for default, your Lordship.
55 dismissed for default.
Yes.
All right, wait. File ta onion. You are ready with the matter? Yes, I will take up after this. Yes, 55 file ta onion. Yes. Yes, who is appearing in this matter?
Led by Mr. Kumar Santanu.
Yes.
My lord, same my lord, kindly keep it on Tuesday. I could not.
Water logging.
Water logging where?
My lord, in front of my house, my lord.
Here.
Yes, ma'am.
Yes, my lord. Jalpaiguri.
There has been water logging. All right. When do you want?
Tuesday, my lord.
Next circuit. On the pair of the learned advocate for the petition list is better before the next available circuit. Yes, next.
Deputy of like,
My Lord, 65 also same, right?
65 same order. Next.
To 55, I am for the petitioner. Day before yesterday, this matter was taken up. I had prayed for not this week because service is not complete.
55. 55 not this week. Yes, next. Call the next matter.
64. But praying for next circuit. Lord, praying for the next circuit. Next circuit.
Which item?
64.
64. 64 next circuit. Yes, next. Call the next matter.
66.
66.
My Lords, item number 66, I'm appearing for the petitioner. My Lord, this matter pertains to period 1920, wherein I'm assailing the order in original dated 22nd August 2024.
Yes, what is the order?
My Lord, the order pertains to, my Lord, discrepancies of alleged short payment of tax on outward supplies based on reconciliation of GSTR 1 and GSTR 9 and excess availment of ITC as per reconciliation of 3B and, my Lord, 2A. My Lords will have the order on page 35, my Lord.
Page 35.
Yes, my Lord.
What do you want? To condone delay?
No, my lords, I am on the violation of section 75(4), wherein, my lords, the opportunity of being heard should not be a mere formality and it should be an effective opportunity of being heard. If my lords will see, there has been no reply and, my lords, no personal hearing. And, my lords, this is due to the inaction or conduct of the consultant. So, my lords, I am a 65-year-old man, wherein, my lord, during the relevant period, firstly my wife and then my mother had passed away. So, my lord, I was in extreme difficulty during that time. I had completely relied on the services of the consultant. And my lords, I have also attached that I've informed the consultant. I've shared the documents with the consultant who failed to act. I was shocked when I had
What
received
steps have
the
you
order.
taken against the consultant?
My lords,
What steps have you taken against the consultant?
my lords, now I've changed the consultant. I've changed.
That's one thing. What steps have you taken against the consultant?
I've changed the now a new consultant is dealing
So, but
with
you
my
have not
affairs.
taken any steps against that consultant. You have
Because
only
I've
changed that.
I have changed the consultant, my lord. And my lord,
That apart, you have not done anything.
my lord, that'll I have to take instructions, my lord. I am not aware. I have, so my lords, I have
The
advised.
consultant is a professional.
Yes,
From
my
which profession he comes?
Yeah, my lords, he's a chartered accountant based in Malda. On the
Yes.
advice of my supplier, I had appointed
So that
this
institute
consultant.
is a very strict institute.
My lords,
What steps have you taken against that consultant?
my lords, I have
It's
changed
very
the
easy to make an allegation against a consultant, a professional.
My lords,
Very easy, sir.
Yes, my lords. My lords, firstly, I have communicated the show cause notice and the order to the consultant, who, my lords, then failed to take any steps. And then, my lord, I've changed the consultant. My lords, I'm relying on an order of this honorable court only, wherein this honorable court has held that the petitioner should not suffer due to, my lords, the conduct of the consultant. They have relied on a Supreme Court judgment also. If my lords may have, my lords, page.
There is a
page
provisional
68.
copy.
But I have not replied to my lords. I did not participate in the proceedings. No reply. No. My lords, even the email address is of the consultant. On the same date that I have received the show cause notice and my lord, therefore, thereafter the order, I've immediately communicated the same, my lord. So, my lords, my limited prayer is that I'm seeking an opportunity to address my contentions, my lord, before the adjudicating authority, if my lords may permit so. If my lords may please have fee.
You say.
And my lords have a 65-year-old man.
Let him exhaust the, what is the provision of law?
Mr. Additional Advocate General, nothing will help, even if he applies.
My lord, these are all
Even if
documentary
he
evidence.
prefers an appeal. Now, he has not given a reply to the show cause.
In the appeal.
So that's the basic thing. So unless there is no defense, he has not given his defense to the show cause.
Yes.
And if there is no defense to the show cause, it's only the tax interest will be determined as per the that no reply has been submitted. So the appellate authority also cannot decide, because only the materials is the show cause notice will be before the appellate authority. He cannot decide it on merits because he cannot make a new case before the appellate authority.
The appeal, my lord, he can ventilate the grievances, and also, my lord, what are the document he chooses to rely upon, he can.
Additional documents, then
no documents as of now.
yes. So now, so only the power before the appellate authority, the law is 112, rule 112. It's akin to order 41, rule 27.
Yes, my lord, my
So
suggestion,
now, yes.
my suggestion, my lord, let us show cause reply, he may be given. But in the meantime, there will be no stay of the operation of the order which the, my lord, the adjudicating authority had passed.
What will happen if then it will be a useless exercise. If the
let-
reply is allowed to be filed, but that adjudication order remains, can it be done?
Hastily adjudication order may be passed. Till the adjudication order is being passed, till then this order, this will be will survive, my lord.
What is the
Otherwise,
necessity?
he is going back the, my lord, in the initial state.
Yes.
Because he has chosen, it was the opportunity was given.
I will fix a short time limit. I will direct him to file a reply.
Yes,
because Mr. Chaudhary, keeping that adjudication will serve no purpose. Giving me an opportunity to file a reply, keeping that adjudication order intact, it's a useless order. So, and if you are allowed to recover that amount, then also the purpose will be frustrated. So either way, instead of staying that,
After 11 months, he has thought that
I appreciate that. I appreciate that, but it has to end.
Because this is one of the bypass mechanism, my lord. Because he knows.
No, I'm not allowing him to bypass. He has to have to go to the first adjudicating authority.
Yes, my lord. Yes, my lord.
Cannot bypass, because appellate authority without the reply to the show cause,
and my lords will also
the scope will be very limited. And after all, he says he relied upon a professional. The email address.
Everyone relies upon. Even we, my lord, rely upon the professionals, my lord.
I must be diligent. Being a client, I must be diligent. I must know at least. What is the turnover? Can he say that I'm not diligent? I do not know the law. Or whatever the turnover, can you see?
My lords, this is also the period 1920. My lords, I'm dealing with the passing of my wife and then, my lords, my mother.
It was
That is the emotional attachment, my lord.
during the COVID period.
And, my lords, thereafter only the COVID period happened.
Period,
And, my lords,
Not during COVID period.
he's saying 20.
the relevant period is 1920.
No, when this 1920.
20 is the relevant
No, the
period.
show cause notice is of 2020.
I'm only saying of the relevant period, my lord.
Definitely it will be determined that.
My lord, that period.
Show cause notice is of 2024.
I had completely relied on the consultant, my lord, that time because, my lords, I'm a 65-year-old man. I do not know how to operate the portal. I don't have access. Even, my lords, will see the.
You have brought AIR 81 Supreme Court.
No, my lord. My lords, I'm relying on a judgment.
Lawyer's fault.
No, I'm relying on a judgment of this honorable court only, my lords. Jai Shri. My lords will have that.
Where is it?
Yes, my lords. My lords will have that at, my lords, page 112. P12, page 75.
Page 75. Page 12, page 7.
P12, annexure P12, my lord. Page
Yes,
75.
show me.
Yes, my lord.
Jayashree Bhardwaj.
Bhardwaj.
Yes.
This honorable court, my lord. My lords, placing relying.
This is the self-same CA.
Huh? No, my lord. This is a different CA. This is one based in Malda, whom I had communicated on the very same date, but not that I received the show cause notice. I had communicated the.
Yes, kindly come to page 77.
Yes, my lord.
77. AIR 81 Supreme Court was relied upon.
Yeah, Rafiq.
I've told you that,
Rafiq.
and you are.
Rafiq, may I remember the name?
79.
My lord, I understand this matter came up after appeal, which I understand. My lord.
79, what happened?
First paragraph.
So that is the submission, but after all, the court passed an order in their favor.
And, my lord, 75-4 also no effective opportunity, my lord. I did not submit any reply. So, my lords, my only contention is. In that matter.
Where?
79 last paragraph.
So in that matter,
respondent is directed to reconsider the appeal.
In that matter,
definitely you are relying on that matter. I am only referring that matter only.
My lords,
contention. You must be very candid, Mr. I do not know.
Unpick.
You must be very.
No, this is the matter. No, this is the matter on.
Mr. Chaudhary, one thing. Appeal, nothing can be done because unless there's a reply to the show cause. If there is no reply to the show cause, so then that demand in the show cause has to be confirmed. Because there is nothing to contradict the show cause notice. So that is to be confirmed. So if that remains at that stage, no useful purpose will be served in directing the rehearing of the appeal. Same order.
There will be a floodgate then.
My lords, 75-4, I'm also relying.
Yes, repeatedly floods are coming now. So gates cannot stop. You are seeing.
So we must strengthen the gates.
Yes, that you have not yet done. That you have not yet done. Ashwin. Where is the order of the? Where is the order of?
35, my lords. Page number 35. Annexure P1.
35 is the adjudication order.
Adjudication order, my lord. Yes, my lord.
What was the show cause?
Show cause, my lord.
What was the ground?
My lord, ground is discrepancies of alleged short payment or, my lord, difference of reconciliation difference between GSTR 1 and 9. And then, my lord, excess availment of ITC based on reconciliation as per 3B and 2A.
Where is that? Where is that fact?
Yes, my lords, in the table only they have
In
ensured.
the table.
Yes, my lords. So tax short paid on outward supply. And then below the ITC availed in excess. Page 35.
Page
35, my lord.
There
The
are three discrepancies, my lord.
and interest payable.
Yes, tax short pay.
where do you find? Where is that?
My lord, the table, page 35.
Page 35, yes.
My lord, the table, tax short paid on outward supply.
Yes.
This is based on reconciliation of, my lord, GSTR 1 and 9.
Then ITC availed in excess.
Based on
And then thereafter interest and there are penalty.
Yes.
In the summary of the order, my lord, can you see?
Yes, yes.
Total is 16,77,504.5.
16 lakh, page.
page 31.
Yes,
my lord.
page 38. 38 is the summary.
Yes.
That is the final determination
Yes, my lord.
by
Yes,
the
my lord.
adjudicating authority.
Yes, my lord. Yes, my lord.
That is the two, my lord, the deficiencies and then the interest. and
Interest.
penalty.
Show cause the date was fixed in the show cause notice.
Yes, my lord.
Yes, my lord.
Specific date was given.
Where is that?
On 15/6, they are supposed to appear.
Where do I
15/6,
find which
2024.
page? Which page?
My lord,
This is not that one of the show cause notices where everything has been mentioned as
No,
NA.
no.
Date, time, venue, all NA.
No, my lord. My lord,
date was given.
this is 63, my lords. Page number 63, you would find, my lords, that 15/6, 14/6, 14/6 that has been given.
Page 63.
But my lords, the reply has been submitted, the date by which reply has to be submitted, that is 15th. Date of personal hearing is fixed before that. So, my lord, this is another discrepancy.
What?
In the show cause notice.
In
My
the show
lord-
cause notice
My lords, date by which reply has to be submitted
is 15th of
15/6.
June.
And my lords, the date of personal hearing is before that.
Yes, Mr. Chaudhary. How can it be done?
This is
Date
before
of
that.
filing the reply is 15th of June. Date of personal hearing is 14th of June.
One day, my lord.
One day, even 1 hour, Mr. Chaudhary. There's no opportunity at all. Thank you.
And my lords, the show cause notice records the email ID of the consultant. I only came to know.
So I'm-
I was trying to find some.
So I'm not going into that consultant part at all. So this is the only ground on which it has to go. Yola? This is for this that period.
Yes.
Please check up. Factually, is it correct or not? How are you issuing show cause notices, Mr. Chaudhary?
Sorry.
How are you issuing these show cause notices? And when the hearing when the order was passed, what is the date of the order?
My lords, order in original is 22nd August 2024, my lord.
22nd of August.
Yes, my lord, but I received the order at my residential address because the email ID pertained to the consultant. I received the order, my lord, on
22nd of August 2024.
2024.
Order passed and you received on?
3rd of October 2024.
Where have you stated?
Yes, my lords.
So this takes care of the delay. This takes care of the delay. Where? Which paragraph?
Yes, my lords. My lords, I just.
This application under Article 227 of the Constitution of India is directed against an order of the Assistant Commissioner State Tax Jalpaiguri charge.
He said that on 22nd August when he received the order. There's paragraph 20.
কি বললাম জলপাইগুড়ি চার্জ under section 73 within bracket 9 of the WBGST Act 2017 dated on August 22, 2024. First time. The petitioner, who are you?
Lord, I'm in the business of supply of solar panels, my lord.
Where have you stated?
So, Lords, that would be para 6, my lord, page 6.
The petitioner is a registered person under the West Bengal Goods and Service Tax Act 2017, engaged in the business of installation services of solar panels. A show cause notice under section 73 within bracket 1 of the WBGST Act has been issued
16th May.
Dated করে দিন, dated
16th
of May 2024 has been issued alleging that upon scrutiny of the data furnished by the registered taxpayer in GSTR-3 capital B vis-a-vis GSTR-1/GSTR-9 and claim and utilization of income tax input tax credit within bracket ITC in respect of supply shown by its suppliers in GSTR-1, few discrepancies revealed. Full stop. The petitioner was directed to show cause as to why the petitioner should not make the payment of the amount, payment of tax, interest and penalty as indicated in the show cause notice. The show cause notice was followed by an order passed under section 73, by an order passed under section 73 within bracket 9, thereby determining the amount of tax, interest and penalty for the financial year
1920, my lord. 2019-2020.
from 2019 for the financial year 2019-2020. Yes.
Page 67. What the date? Can you just for I'm sorry, just correction.
67.
Yes. The detailed show cause notice. That was the summary and detailed show cause notice. Page 67. Last paragraph.
Yes.
Last paragraph, it is said that 15/6/24 is show cause to be given.
Yes.
Second line, and the last line, the date of hearing is also at 15/6/24 at 11:30.
How can it be?
15/6.
Yes, 15/6.
Show cause.
Yes,
Reply
show
to
cause
show cause.
reply has to be online. You have not specified the time limit, so it has to be the entire day. And how can you fix within 11:30? Even if that is first part.
No, within 15/6, it is
Yes.
not through online even. When the personal hearing is given, he can also place the such reply at the time of hearing event. This is the
Confusing. Confusing in the one show cause in one place you are saying 14, another you are saying 15. Summary.
But details.
If one goes by the summary.
This is my officers has definitely, but
ask your officers to be careful.
That is very.
Ask your officers to be careful. Because
Because they
for
do a
this
copy paste.
technical grounds, many adjudication orders are being set aside. I'm telling you.
Yes.
At least
Because
three
it
or
proves-
four adjudication orders I have set aside.
They are doing mechanically without applying the money.
Cut, copy, paste.
But if you say detail, it is written absolutely clear.
That is also vague. 15th, no time, and hearing is 11:30.
It is suppose now.
Entire day.
I can put it in other way, my lord. Suppose today's list is published. I don't know more, my lord. I will leave it.
List is, Mr. Chaudhary, list is published
Just
for
lighter-
hearing,
with a lighter
and this
board.
is submission. No, no, no. That is, I'm also on a lighter board. So this is for the hearing, which will be taking place, and you are specifying a date for submission. So they can take it, and this reply is filed online. Provision is there for online.
Is there online? When the personal hearing is given and date is fixed, suppose now they have not uploaded it.
They can also file.
Yes, hard copy.
And also, Mr. Chaudhary, in some cases, when you have to rectify, you have to do something, you are saying portal is not working, so we will not accept physical.
True.
In some cases, you are saying, no, we will not accept physical filing. Everything is online. And in some cases, you are saying, all right, why are you going online? Please come and file
But the
physical.
only thing is that the taxpayer must be very diligent. That is required. Because, my lord, ultimately, this to some extent can be said the evasion of tax.
No, I'm participating in the, if my lords may direct me to file a reply now. That I was leaving.
কি হলো? কোন পর্যন্ত হলো? 2019, 2020 বোধহয় না?
1920, 1920. 1920, relevant.
Was followed by the impugned order. By the impugned order passed under 17. ঠিক আছে? So paragraph. The learned advocate appearing for the petitioner submits that no effective opportunity to give a reply to the show cause was afforded to the petitioner. First of, he further submits that the petitioner handed over all papers and documents to his consultant and requesting the consultant to take steps. First up, however, the said consultant, however, the erstwhile consultant, করে দেবেন, ঠিক আছে? However, the erstwhile consultant did not take any steps in the matter and for which
Or participate in the proceedings.
did not take any steps in the matter and also did not participate in the proceedings. First up, the learned advocate further submits that thereafter the petitioner has taken a change from the erstwhile consultant and have engaged the present consultant. First up. He therefore submits that since the petitioner did not get any opportunity to file any reply to the show cause, an opportunity be given to the petitioner to contest the proceeding from the stage of filing reply to the show cause notice. First a paragraph. The learned additional advocate general seriously opposes the prayer made by the petitioner. First up, he submits that the petitioner is carrying on a business as a proprietor, as a sole proprietor. As a sole proprietor, full stop. Even though the petitioner may have handed over papers and documents. Now, even if the contention of the petitioner is accepted that he has handed over papers and documents to the consultant, the petitioner ought to have been more diligent in dealing with financial aspects of the business, and it is not believable that the petitioner only relied upon a chartered accountant entirely without caring to keep a vigil on the activities of the accountant. Full stop. Paragraph. Heard the learned advocates for the parties and peruse the materials placed. Full stop. Section 73 within bracket 9 of the WBGST Act states that the proper officers shall, comma, after considering the representation, comma, if any, comma, made by the person chargeable with tax, comma, determine the amount of tax, interest and penalty equivalent to 10% of tax or 10,000 rupees, whichever is higher, due from such person, and issue an order. Section 75 of the WBGST Act lays down the provisions relating to determination of tax. Subrule subsection 4 of section 75 states that an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. Full stop. From a bare paragraph. From a bare reading of the provisions laid down. From a bare reading. From a conjoint reading of the provisions laid down under section 73 and 75 of the WBGST Act, this court is of the considered view that where an adverse decision is contemplated against the person, an opportunity of hearing shall be given to the person, to such person. Full stop. Paragraph. After going through the show cause notice, this court is of the considered view that an adverse decision was contemplated against the person. Full stop. Thus, the proper officer was under a statutory obligation to afford an opportunity of hearing. Full stop. Paragraph. It is well settled that such an opportunity of hearing should not be an idle formality, but the same has to be an effective one. Full stop. After going through the show cause notice dated May 16, 2024, which is annexed at Mr. Chaudhary, this is the summary show cause notice. 64 is the
Summary show cause notice.
After going through the show cause notice dated 16th of May 2024, which is annexed at pages 63-64 of the writ petition, it appears that the date by which the reply to the show cause notice is to be submitted was fixed on June 15, 2024, and the date of personal hearing was fixed on June 14, 2024. At about the date and time of personal hearing was fixed on June 14, 2024 at about 11:30 a.m. Judgment format. At about 11:30 a.m. Full stop. Thus, it is from the said show cause notice, it appears that the date and time of personal hearing was fixed prior to the date permitting filing of the reply to the show cause notice. Full stop. The learned additional advocate general would contend that the show cause notice annexed at pages 63-64 of the writ petition is a summary show cause notice, and in the detailed show cause notice, the date and time has been specifically mentioned, and there is no infirmity in fixation of dates in the said show cause notice. Full stop. However, after going through the detailed show cause notice, it appears that the time limit for filing reply to the show cause notice was within June 15, 2024, and the date of hearing was fixed
On same day.
at about 11:30 a.m. on 15th of June 2024. Full stop. Upon going through the dates mentioned in the detailed summary in the detailed show cause notice, it appears that the time was given to file reply to the show cause notice during the entire period of 15th of June 2024, and the hearing was fixed at 11:30 a.m. on 15th of June 2024. Full stop. There is a discrepancy in the summary show cause notice as well as the detailed show cause notice with regard to the fixation of dates for filing the reply to the show cause notice as well and the date of personal hearing. Full stop. Thus, there was a confusion. That's the full stop. Be that as it may, the reply to the show cause notice was not filed.
No reply has been filed and no hearing has been.
No reply to the show cause notice has been filed. Full stop. The petitioner would, the learned advocate for the petitioner would contend that the petitioner should not suffer due to the laches and negligence of the consultant.
They did not appear on 15/6.
Full stop.
Even
At
after
this
not the same
stage, it would be relevant to take note of the decision of the Honorable Supreme Court in the case of Rafiq and another versus Munshilal and another, reported at AIR 1981 SC 1400, wherein it has been held that the petitioner should not be made to suffer due to the laches and negligence on the part of the learned advocate. Full stop. Though the since the petitioner had engaged a consultant for dealing with the financial matters, this court is of the considered view that it has been alleged that the erstwhile consultant did not take any steps in this matter. This court is inclined to grant a last opportunity to the petitioner to contest the proceeding from the stage of filing the reply to the show cause notice. Full stop. As already observed herein before, that no effective opportunity of hearing was passed, as there was discrepancy in the dates fixed for filing the reply to the show cause notice and the date of personal hearing, as would be evident from the summary show cause notice. Full stop. For all the reasons as aforesaid, the writ petition stands allowed. Full stop. The petitioner is directed to file reply to the show cause notice dated 16th of May.
16th of May 2024.
16th of May 2024, within a period of 2 weeks from the receipt of a server copy. Acha, writ petition, কি বললাম প্রথমটা যেটা বললাম writ petition
Disposed of.
As there are experiencing the date fixed for filing the reply to the super notice and the date of personality as will be evident from the combined super notice. For all the reasons that are posted, the petition stands allowed.
The full stop, the impugned order dated
22nd August 2024.
22nd of August 2024 is set aside. তারপরে ওইটা
I retract the super. From the date of the
full stop. If the reply to the show cause notice is filed within the time limit mentioned herein before, the appellate authority being the
Adjudicating authority.
the adjudicating authority being the which respondent?
Huh?
Lord, respondent number 2.
Being the
Assistant
second
Commissioner.
respondent shall fix a date, time, and venue of personal hearing.
After expiry of the period of 2 weeks.
Shall if that within that time we will fix a date,
time and venue of
by issuing appropriate notice in that regard. Full stop. The said respondent authority is directed to conclude the directed to dispose of the proceeding. আচ্ছা তার আগে লিখুন is directed to dispose of the proceeding by passing a reasoned order after affording a reasonable opportunity of hearing to the petitioner or his authorized representative and communicate the said order to the petitioner immediately thereafter. First of the entire exercise shall be completed within a period of from the date of hearing within how much period? Within a period of 4 weeks from the date of from the date of
Hearing.
from the date of
Hearing to be fixed.
from the hearing date fixed by the said respondent.
Grateful.
But learned advocate, additional advocate, please ask your officers to be very careful.
What I am trying to.
In this way, this should not be. Yes, call the next matter.
Lordship, in this item, Learned Senior Mr. Bodhan Bhattacharya will be appearing.
What do you want? Next circuit?
Kindly fix it on Tuesday, Your Lordship.
All matters cannot be fixed on Tuesday.
He'll be appearing physically, Your Lordship.
Maybe. All matters.
6th, Your Lordship.
Yes.
I'm for CGST.
Yes.
State is done.
List this matter as paid for by the learned advocate for the petition. List this matter on 6th. Yes, next. 68, who is appearing? You are appearing? Oh, you will do the matter, all right. Yes.
Toll matter. That's our objection for. So issues have been settled.
Issues have been. What issue?
Oh.
What? Yes.
My lord, I'm for the petitioner, my lord. We have challenged the control order here. Since it is restricting my fundamental right of livelihood. This is regarding the FL shops.
The AO direction without AO, other matters also AO is there. Not let affidavit.
Affidavit has to be filed, and I think there is an interim order.
Interim order.
What is the interim order?
My lord, there is an interim order. If my lord.
Because this issue, I think, is pending before the principal
bench, my lord.
Page 95.
Page 95, my lord, it says, under the above observation, it is ordered that the state authority concerned may proceed with the impugned vacancy notification, but so far the grant of license to any individual applicant is concerned, the same shall not be issued till the final decision of the instant matter.
No, I think thereafter division bench has passed an order. I have passed a different order on this.
Age restriction. Age restriction, 45 years.
This is of 2024. That is of 2024.
Yes, Mr. Additional Advocate General, what do you say? This interim order?
Yes, the last order.
Last order is
page 95.
95, my lord. My lord, even page 92, this is relevant because it
says the leave of the honorable court, the appointment, the consideration cannot leave. With the leave of the court. They can process.
The state authorities may proceed with the impugned vacancy notification, grant of license, till the decision, till the final decision of the instant matter.
That would be the leave of the court. Whatever the
These
decision.
issues are pending. Unless these are decided, how can it be done? Leave means with the leave cannot be granted, Sir Jalpaiguri, because these writ petitions are pending. Unless this issue is decided, how can it be done? Leave also, it will be an infructuous. Leave also cannot be granted in that.
Definitely, honorable judge will not grant leave if such pending.
What? One order is there, let me follow that. Because different interim order, because the issue is same as in this matter.
On page 79, several matters were heard together.
Yes.
And this order was.
There were multiple petitions regarding the same, with the same cause of action.
Yes.
Only
The
age criteria.
Age criteria,
Age criteria.
45 years.
the learned advocate appearing for the petitioner. Now, the petitioner, you have challenged the virus of clause 11.5.
Clause 11.5,
The
my lord,
petitioner has challenged the virus of clause 11,
which is in page number 36, the control order.
has challenged the virus of clause 11 within bracket V of the West Bengal targeted public distribution system within bracket maintenance and control bracket closed order 2024. First up, a batch of writ petitions have been filed. The lead case being WPS 6533 of 2025 in the case of Sudeep Sarkar versus State of West Bengal and others. The learned advocate appearing for the petitioner draws the attention of the court to the order dated April 7, 2025, passed in the said batch, and submits that a coordinate bench has passed an interim order. First up, the state is heard the learned additional advocate general. First up, he prays for leave to file affidavit in opposition. First up, let affidavit in opposition be filed within a period of 4 weeks. 6 weeks from date, reply thereto if any be filed within 3 weeks thereafter. First up, parties will be at liberty to mention this matter for hearing after the expiry of the period fixed for exchange of affidavits. First up, this court finds that a coordinate bench passed an interim order to the following effect. Bole, page 95 under the procedure is ordered that the state authority concerned, page 95 ঠিক আছে? First up, it is ordered that the state authorities may proceed with the impugned vacancy notifications, but so far as the grant of license to any individual applicant is concerned, the same shall not be issued till the final decision of this writ petition.
Grateful.
Of
The public distribution would be affected.
all these writ petitions are filed
Well,
pending.
if you see-
Another batch is also
The
pending.
state has the power to set its own guideline.
Get these matters disposed of. Principal bench also is
That's
there.
why difficulties because once the affidavit direction is given, it's very difficult to matter to be heard.
These matters cannot be
Not
decided
generally.
without.
I am talking about the principle.
Cannot be decided without affidavits
Without
also.
affidavit also.
Yes, call the next matter.
Grateful.
There are some 60. No. 60. Next matter, there are some capital errors and some documents have been missed out. I would like to withdraw the matter and file out.
The learned advocate appearing for the petitioner submits that there are certain inadvertent errors in the writ petition. So he prays for leave to withdraw this writ petition with liberty to file afresh on the self-same cause of action. First up, in view thereof, WPA number such and such stands dismissed as withdrawn with liberty to the petitioner to file afresh on the said cause of action. Call the next matter.
Lordship, I am praying for not today.
Why not today?
Mr. Vikramaditya Ghosh is appearing in this matter, and he used to leave for Alipurdwar urgently because his father is unwell.
Not today, next. 71. Who is for
My
the
lord,
petitioner?
My lord, I am appearing for the petitioner in item number 71. My lord, this is a hearing matter and it is a covered matter. It's just that, my lord, the affidavit in reply is with me in Calcutta and I'll be coming to the Jalpaiguri
All right,
along with my...
affidavit in opposition has been filed.
My lord,
Yes.
my lord,
Uh,
even the affidavit in reply has been filed back in the year 2024 April. However, the judge's copy, original copy is with me in Calcutta. I will be
All right.
personally
Affidavit in
appearing.
opposition filed in court today is taken on record. The learned advocate appearing for the petitioner pays for
My lord, 2
extension
days
of time to file the affidavit in reply. First of all, let such affidavit in reply be filed when?
My lord, the affidavit in reply has been filed, but the original copy is with me in
So how can you
Calcutta.
file if the original is with you, madam? That is why I'm asking you, when can you file?
My lord, by Tuesday. On Wednesday, the matter can be kept.
Within a week from date. First up, list this matter under the heading hearing. Yes, next.
Grateful, my lord.
Next.
My lord, for item number 72, I am for the petitioner.
Yes.
My lord, in terms of the last order of the coordinate bench, I'd like to submit the affidavit in reply, lordship. My learned friend is there.
Affidavit in reply you want to file?
Lordship.
Opposition has been filed.
Lordship.
The learned advocate appearing for the petitioner prays for extension of time to file the reply. Yes, how?
Lordship,
when can you file?
today I'm filing this. The affidavit in reply is ready.
All right. The learned, the affidavit in reply filed in court today is taken on record. First up, list this matter under the heading hearing. Yes, next. There will be
My lord, in item number 73, the CGST, the central respondents were supposed to file a report in form of an affidavit. However, it is very unfortunate to say, my lord, thrice
Mr.
repeated.
Bonik? Where is Mr. Bonik?
My lord, here the petitioner's RC has been cancelled under GST and they have not filed the report for the past 1 year.
Yes. Where is Mr. Bonik? Why have you not filed the report?
My lord, 1 week time maybe.
On the prayer of the learned advocate for the respondents, time to file report is extended by a week from date. First up, exceptions, if any, be filed within a week thereafter. First up, list this matter under the heading hearing after expiry of the period fixed for exchange of the report and the exception. Yes, call the next matter.
One indulgence, my lord, in item number 73 is that the RC of the petitioner has been cancelled. My lord, we kindly fix a date.
Yes.
It has been penned.
Yes, who is appearing? Mr. Mishro.
Mr. Mishra will argue this case, Lordship. I am praying for not today.
Not today, next.
75, Your Lordship, analogous matter has already been mentioned. If both the matter can be fixed any day subject to Your Lordship's convenience, Mr. Arijit Chakravarti, he is appearing in this matter, Your Lordship. I'm late by him. So, if any day convenient to Your Lordship, let the matter be fixed because an analogous matter has already been mentioned before Your Lordship on an earlier occasion and today again, Your Lordship.
When do you want?
Any day subject to your lordship's convenience, your lordship. On Tuesday, maybe your lordship.
On Tuesday. On the prayer of the learned advocate for the petition, list this matter on November 6th. Yes, call the next matter.
My lord, from the previous order, it is reflecting that the state has filed a report, my lord. My lord, that may be served upon us. We want to file
Yes, we have
exception.
already served you, madam. Because this has been filed way back. This was filed in the month of July 2025 with a copy to the.
Please give him another copy. The learned advocate appearing for the petitioner submits that no copy of the report filed by the state has been served upon her. Full stop. A copy of such report has been served upon the learned advocate for the petitioner in court today. You want to file an exception?
My lord.
Petitioner will be at liberty to file an exception to such report within a period of 1 week to establish this matter before the next available circuit bench.
Great.
Call the next matter. Yes, yes. Who is for the petitioner? Yes, where is he? Where is he? None appears for the petition at the time of call. State is represented by his learned advocate. List this matter before the next available circuit bench. Yes, call the next matter. Yes. Yes.
My lords, I in item number 78. I'm appearing for the petitioner.
Yes, yes. What do you want?
My lord, it's a matter of unauthorized construction.
Unauthorized construction. Yes. You are for the petitioner. Yes, yes. What do you want? Please place your case.
My lord, the conducting lawyer is.
Conducting lawyer, it seems that the petitioner is not willing. Repeated occasions it was
My lord,
adjourned.
no.
Next circuit.
No, my lord, in 15th in the year 15th last page in 15th of July 2024 we had sent a representation for taking action against the illegal construction, but it has
whom? To whom?
To the Panchayat Pradhan.
Where is that?
In page 39.
That is the SGDA within the jurisdiction of it has to carry out the demolition.
Who is appearing for SJDA?
Mr. Raja Saha used to appear earlier.
Mr.
Raja Saha used to appear for SGDA.
Where is the affidavit of service? Have you served upon the respondents?
So
Private respondent is there.
Fixed on Monday. I have the.
Where is the affidavit of service? You have not filed.
My lord, the conducting here it is with the conducting lawyer.
An accommodation has been sought for on the ground of the learned arguing counsel for the petitioner. Full stop. No affidavit of service has been filed till date. Full stop. Petitioner is directed to serve a copy of this writ petition upon the respondent number 7 and file an affidavit of service on the next date. To establish this matter before the next available second bench. Yes, call the next matter.
Lordship, I'm praying for not today.
Why?
Lordship, Mr. Mishra will argue this case. That's fine.
Not today, next.
My lord, small indulgence, my lord. I have served I will put my affidavit on service on Monday, my lords, if my lords can.
Yes, let's call the next matter.
For the petitioner, my lord, there was direction to file a reply. My lord, kindly gives us 1 week's time and we will file the reply, my lord.
মোশনে অ্যাপিয়ার করছে কেন? হিয়ারিং লিস্টে থাকার কথা, মোশনে অ্যাপিয়ার করে দিন। The learned advocate appearing for the petitioner prays for extension of time
1
to
week.
file the affidavit in reply. Let such affidavit in reply be filed on or before November 13, 2024. Full stop. Parties will be at liberty to mention this matter for inclusion in the list under the heading hearing after expiry of the period fixed for filing of the affidavit in reply.
Grateful.
Yes, next.
Lordship, I am praying for not today.
Why?
Because Mr. Vikramaditya Ghosh is.
All matters, Mr. Vikramaditya Ghosh.
Yes, Lordship.
Exception request to be filed. Report has already been filed in the form of an affidavit. They are required to file an exception.
Have you filed exceptions to the report?
Lordship, I don't have any direction from my senior.
So Ghosh is not here. I'm making not. Yes, next. Call the next matter. 82 yes. Yes, Mr. Bormon, where is Mr. Bormon? Where is the report? Report is to be filed. No report has been filed.
Yes, Lordship, there is a direction to file the report, but all report is lying with the Mr. Barman, Lordship.
So file the report. When?
Lordship, Monday.
None appears for the petition at the time of call. No accommodation has been sought for either. To serve the learned advocate appearing for the state prays for extension of time to file the report. Full stop. Let such report be filed on or before. When 6th November, list this matter before the next available circuit bench. Yes, next. No,
Direction
Mr.
to file report, my lord.
My lord, we will file exception. My
You
lord,
file
state-
exception. Report.
Report.
Where is the report?
My lord, yes.
The report filed by the state is taken on record. The learned advocate appearing for the petitioner prays for time to file exceptions to the said report. Let exceptions to the report be
Copy.
filed. Yes, how soon?
Within 1 week, 2 week.
Within 2 weeks from date. Full stop. List this matter under the heading hearing after expiry of the time fixed for filing the exceptions to the said report.
Great.
Yes, call the next matter.
Could your lordship note for T4 now?
Why, Mr. Chatterjee?
For getting.
You thought that it will not be taken up.
I was very apprehensive.
Don't misapprehend.
I was very apprehensive, but I don't think I was too wrong. Looking at the clock, my lord, I don't think I was too wrong. But grateful to your
Still
lordship.
2 minutes left, Mr. Chatterjee.
Yes, sir. And your lordship may dispose it of within that,
1 minute.
within that.
1 minute your submission and the order would be
I'll
1
tell
minute.
your lordship, and it looks to my lord's last order. And that would be, my lord, your lordship would probably recollect, my lord, whatever, my lord, I had submitted. Very well. My lord, I was given, I have a land. which
Where is my?
Your
Mr.
lord-
Chatterjee, after that, several orders were passed.
Several. Every time I was here, my lord, every time. But this is a hearing matter, this needed continuation. So not, this needs continuation. None of the honorable judges had time, my lord, to hear me. My lord, it was my bad luck that the matter used to be taken up, my lord, in the second week of the, my lord, the circuit. And my lord, all the time, my
Now
lord,
it has been taken up in the first.
the first week. So I am a little, my lord,
It starts,
but it started with your lordship. It started with your lordship. I hope it ends.
Should
with your
end with
lordship.
someone else.
I hope it ends with your lordship also. My lord, I'll tell your lordship, do not look into the papers. Gives me 2 minutes time. I'll
I
tell-
think I directed some
Yes,
report or
I'll
something.
tell
to
your
the-
lordship. I'll tell your lordship. Give
That
me,
report is filed, my lord.
That has been
By the
filed.
pollution control.
give me 2 minutes time. Your lordship would recollect. I have a land which is bordering the Baksa, my lord, Tiger Reserve. My lord, I had to establish a rice mill.
Circuit bench, Mr. Chatterjee, after 4:30, everyone will cast.
Lord, your lordship fixes a date.
kindly keeps it, on Monday or whenever your lordship. I'm at your lordship mercy.
Whether you will get another chance or.
Lord, I
See,
need
that's
another
the-
chance. I don't know, my lord, whether if your lordship hears it out today, I don't have a problem. My flight is at 6:50. 6:50. So I'm safe.
It is
Because-
delayed today.
আবার ডিলেট করে অশুভ কথাবার্তা বলে কেন আমি ঠিক বুঝতে পারি So
You came today.
I
You
came
are-
today in the morning. I had 2 matters before Justice Basu. And this was also there, so I took a chance, if possible.
Yes.
So, my lord, I have a land which borders the Baksa Tiger Reserve. I applied, land is mine, recorded in my name, rice mill is recorded, my lord, as in the porcha, in the record of rights. I go to the Pollution Control Board. I tell them, please give me consent to establish. The Pollution Control Board gives me, my lord, every aspect, looks into every aspect of the matter, gives me a consent to establish. With riders, tells me that you have to do this, you have to do that, and you have to do all that.
You have complied with
I
that.
complied with everything. Then, my lord, I went, my lord, to Mr. My learned senior friend's client's office, saying that I have already established. Now give me your permission so that I can start
Who
operating.
will give permission?
Both of them.
No, which
Both of
authority?
them. Now, which authority? Both authority. Now, this also, my lord,
What are the authorities?
I'll tell you, Lordship, the forest authorities and the pollution control board authority. My learned senior friend told your lordship on the last occasion, since it is outside the forest reserve area, the forest authorities I do not need the forest authorities permission at all. And your lordship wanted an affidavit from them as well.
What is the stand in the affidavit?
Stand is a little different. I'll tell your lordship on that. I'll come to that on the second stage. Now, when I go to the pollution control board, they say I will not give you consent to establish because it is within the
No, consent to establish is there.
consent to operate because it is within the SEZ, which is the special economic zone. Now, my lord, I'm sorry, ESZ, ecologically sensitive zone. SEZ is special economic zone. Now, I will not give you that. So they don't tell me that, plot on my face. They tell your lordship that through my learned senior friend before your lordship that they will not give. Now, your lordship wanted to know from them, how did they give a consent to establish? Your lordship wanted, my lord, a report from them. In the report, they say, my lord, that the consent to establish which was given was wrong and it was given inadvertently. Kindly appreciates, my lord, this is given sometimes in 2020. I put in a few crores. I establish it. There are 300 my lord, workers who have been, my lord, given employment. Today they say that the consent to establish which had been given to you earlier, that is wrong.
For what ground?
On the ground that there is a notification which says that non-polluting polluting industries will not be set up within that ESZ. Now,
so admittedly, it is within ESZ.
No, there is another problem. Now the state comes in. The state says that it is now within the ESZ, but they have applied before.
Oh, there was a change of notification.
Yes.
Thereafter, it
5
was
kilometers, 0 kilometers, 5 kilometers, Supreme Court judgment, everything came into play then. Now, once, my lord, I have established it. Pollution Control Board, I don't think was blind. Pollution Control Board knew I was establishing it. There is no complaint from anybody.
But Mr. Chatterjee, one part is whether you have a right now.
Vested right. My lord, I have a vested right. Not just a vested right, legitimate expectation. The stopped by authority of law. They are stopped from even making a submission before your lordship that I cannot operate. Why? Now, why? It is not their, my lord, their stand that no industry can be set up. It is not their stand. Their stand is the local industries have to be set up and have to be given, my lord, the push. So if I am within the orange zone, there is no difficulty.
So you are not within the orange zone.
I am within the orange zone. I am a small scale industry, a rice mill. I have the boiling license.
But you are not a local.
I am not a, Milord, it's a rice mill, has to be local. Rice mill.
No, you said that only a local.
Yes, they are not understanding that. This is where the report is wrong. This is exactly where the report is wrong, because they have annexed, my lord, the notification. So any which way your lordship looks at it, my lord, I could not have been prevented, my lord, from operating that rice. After putting in so much money, after taking every license possible, my lord, or not. Even the record of rights, which is, my lord, the classification of land says it's, my lord, a rice mill.
Record of rights, maybe because you wanted change
Lord,
of
it's the
classification
government.
that has been
Granted. PLRO has granted. Nobody has challenged it.
But
Nothing.
Mr. Chatterjee, in a case of this type,
Yes,
it concerns the environment.
I bow down. So there has to be
So-
checks and balances. It can't be, my lord, that you have made me, my lord, invest the money, made me, my lord, establish, my lord, the rice mill, and now you can't say that you can't operate. There needs to be checks and balances. I'm not even saying, my lord, that I will pollute the atmosphere. I don't know how many tigers are there, my lord, in Baksa Tiger Reserve, but everybody is very bothered about that. I don't know anybody has seen tigers there.
No,
But
that's
be that
the
as it
luck
may-
which one says
Be that as
that
it may.
Without invitation,
So
if
whether-
they visiting their house, definitely the tiger will not
whether
come.
you sight a tiger or any wild animal or not, it's your luck.
Milord,
So
I'll
at
tell you,
times
your
you
lordship,
may-
nowadays what happens is, the earlier, Milord, this was sheer luck. Now humans know, Milord, where the tigers are. It's not because of the chain, because tigers are very territorial. My lord goes to any tiger reserve in India. If your lordship has 4 to 5, my lord, safaris, at least
Yes.
in 2, your lordship will see.
Yes, that's the, you have to do continuous.
You have to. At least in 4 to 5 safaris, Lord, your lordship will see at least 2 on them. And
Not that in a
how
single
much your
safari,
lordship will see?
Not that, and I'm saying of luck, because if you go on a single safari, you may not.
You
Because
might
4
see,
to-
you might not see.
Yes.
Because my personal experience is, Milord, that in every safari, the first safari, Milord, there's a beginner's luck. You get to see in the first
So in
safari.
some of the safaris, my personal experience I have got, but now last
So
one
now-
or two occasions, no.
Lordship didn't see. But Milord, if your lordship goes in this time,
Baksa also I have not.
Baksa, Milord, there is hardly. But I'm not on that. It is a tiger reserve.
Yes, tiger reserve.
It is
Maybe
a tiger
Mr.
reserve.
Chatterjee, whether
It
we
is
cite it
protected.
or not, we cannot say
Absolutely.
that.
There might be some tiger somewhere. We are not on that. I'm taking it for granted, Milord, it's a tiger reserve. But my mill is not inside the jungle.
No, may not be inside the
They are saying I am
whether
within
it's
the
in
ESZ.
that territory.
They are
or-
saying
yes.
I am within that ESZ. Now, Justice Bhattacharjee, Shogata Bhattacharjee, Milord, his lordship wanted the central government to be, Milord, added as a party.
I think I also directed
No,
this.
your lordship wanted the forest officers to be
No,
added.
to issue a notice, I
To
think.
the forest office. Because my learned senior friend
No,
said
some notification I wanted
yes.
to whether that was notified.
from the forest office. And Justice Shogata Bhattacharjee, Milord, directed this Union of India to be
That
added.
is, yes, Union of India. I
Was
think.
added.
Who
Was
is,
added.
where is he? Who is representing?
Milord, this is a problem, Milord, with these poor. What happens is, it's not that, Milord, I put in money, Milord, from my house. I have taken money from, Milord, the bank. I am putting in, Milord, the money, my money, Milord, into that EMI.
Now, where is that order directing that central government to be made a part?
Justice Shogata Bhattacharjee.
Which order?
Last order.
Last order.
Yes, last order. Now comes, Milord, I'll show
So
you
last
the-
order is by Justice Roy. Aniruddha Roy.
Justice Rai, Milord, did not take up the matter.
So, no response from the ministry based on the draft proposal. Yes, this is the, whether it has been finalized or not, that's
Now
the.
this, my learned senior friend, Milord, Mr. Chaudhary told your lordship, is waiting, is being
Yes.
under consideration for
By
3
the
years.
union.
For 3 years.
Yes.
Milord,
so-
I am saying that even if it is within the ESZ, it's not that they cannot, Milord, there will be no industry.
No, but who is representing that authority? Add Ministry of Environment, Climate, Government of India and its secretary. Where is, who is representing them?
Mr. Mojumdar should be represented.
Where is, Mr. Mujumdar is not available.
But we have to cite this.
He is a tiger, but we can cite him at times. We can cite him at times. Look, kindly looks to his report once.
Whose report?
The pollution control.
Which respondent?
But this is a report filed on
Filed by
respondent number 2.
2.
Yes.
Yes, I have got a report of the respondent number 2. Let me
1st
check up
May.
the date.
1st May.
1st of May. It was 1st of April that have been. It has been
I
made
have been
May.
April Fool blood in this matter quite regularly.
So it was 1st of April,
Changed to
then
first.
changed to 1st of May.
Kindly looks to the second paragraph.
Second
A
paragraph.
few paragraphs I'll show. Looks to the second paragraph.
Yes.
I humbly submit that the consent to establish pairing such and such was issued on behalf of the member secretary. So this is an admission. Kindly marks this.
Yes.
In
No, that he
favor of
cannot, he has said that that was issued, but through
I'm
inadvertence or
I'm
wrongly.
coming to that. Kindly see how it goes. For installation of rice mill under the seal and signature of the then environmental engineer in charge, Shiliguri Regional Office of the State Pollution Control Board. I humbly submit, my lord, your lordship need not, my lord, look into that. These are not really, my lord, important for my lord's consideration. Comes to paragraph 4. What is required is given in paragraph 3. Turns to paragraph 4. Ease of doing business. I humbly submit that following the said order dated such pertaining to ease of doing business, the consent to establish was issued to the petitioner herein by relying upon the land documents, marks it, of the petitioner, particularly the conversion certificate issued in favor of the petitioner by the land department. The said conversion certificate showed that the land in question, where the rice mill of the
So you'll be arguing on promissory estoppel?
Absolutely. And legitimate expectation. Beloved, this is a promissory estoppel of a different level. I go to an authority, the authority looks into my documents, does whatever it has to do, gives me the clearance, and now he's saying that it is inadvertence. And then, my lord, your lordship goes, if your lord, my lord, I'm so grateful your lordship understood what I would, where I'm going to.
Looking at paragraph 4,
This
and
is
the
what
council appearing, I apprehended that this would be the argument.
I'm taking that, Lord, as a compliment. So I will be, Lord, I'm on three points.
Because the way you have started,
Yes.
it's everything taken together.
Yes. Lord, promissory estoppel lies on the state. There is no dispute on that, but there is a rider to that. If there is a
Some
larger,
exceptional cases,
there are
with a-
larger, my lord. So
that's the
I'm coming on
the
to
larger
I am coming to that.
environmental aspect.
That's
very
exactly where I'm coming.
deep.
Exactly where I'm coming. Now, my lord, if it's a larger aspect, if you're thinking of, then there has to be a complete bar in establishment of, my lord, an industry. There had to be a complete bar. They themselves will say, my lord, in this affidavit itself that there is no complete bar. If there is some leeway where, my lord, an industry, my lord, can be established, they will have to give me, my lord, consent to go.
Mr. Chatterjee, if that notification that is approved or
Then there is no problem at all.
I think then it's
There is
better
no
if we-
problem at all. But then
when-
I don't know.
When Mr. Mujumdar will
Lord,
come
I am
available.
going to make this submission, Lord. Mr. Mujumdar can come whenever he wants to. There is no problem on that. But I'm saying, Lord,
That
even
can-
if that notification
that
doesn't
will
come,
simplify the issue,
I
Mr.
I bow down. I completely bow down. But suppose, Lord, they don't take it for granted, Lord, they don't notify it. They don't agree with the proposal of the state government. Because we don't have a double engine, Lord, government here. So the state government and we don't know that. So if that happens, Lord, your lordship knows where I stand. I am in the middle. They will be fighting amongst themselves. I am there in the middle, my lord. Money, who's gone? Mine. But who is suffering?
Additional advocate, then who is representing the?
Generally, the additional deputy solicitor general ought to have addressed, and once he has appeared.
He will appear.
But even he
be
will not be able
appearing
to.
with juniors. Who is the junior assisting him?
Junior, he has.
Someone has to be present.
He has 2-3 juniuniors.
But who is engaged?
Ah,
in this matter?
Singhania.
সিঙ্গানিয়া কি দাসের কোর্টে দেখি অফিস তালা মারা তোমরা যদি না ওদেরকে কাজ করতে দাও ওদের তালা মেরেই চলে যাবে
ঠিক বলেছে। So it is very difficult, the central government, because we have sent a draft proposal for reducing the area.
That's on the basis of a Supreme Court
order.
judgment.
That and say.
on the basis of a Supreme Court
That
judgment.
is right. Because
Now,
if that is done, Mr. Chatterjee was saying.
That's a direct way.
Yes.
Direct.
So
I
because.
am saying, my lord, since there is we are at loggerheads. My lord, I am not at loggerheads, they are at loggerheads, both of them. But I am suffering. I am saying, my lord, in the present situation also, I'll show your lordship, my lord, that I am entitled to, my lord, operate that. I'm not for a second saying, my lord, that I have a vested right where tigers go to hell. I will make my rice. I am not for a second I'm saying so. But I am saying so, my lord, that if the law is that if an industry can be established and I fall within that, then there is no bar under the law to give me a consent to operate. Kindly appreciates this. Once, if their, my lord, proposal is allowed, I have no problems whatsoever.
That is why I'm thinking that.
No problems
thinking
whatsoever.
along that if that
But
is.
my lord, if they will say, my lord, that I will think about it forever, and now the elections are on the way, I will think about it forever. Their proposal went probably in 2022 or 23, if I'm not mistaken.
2 years.
Yes, 2 years they've done nothing. And during that time, my lord, the consent to establish was given by the pollution control. Yes, 22.
That was 24, this is 20.
Correct. He's given me in 22 when the proposal was not there.
Oh, no, it was not in 20, it was in 2020, kind of like that.
Their
That's
stand
even
is
better,
that.
sir.
Their stand
2020
is.
is even better. The proposal was not even there. The proposals come in much later. Much later. So if the proposal comes in, then there is no problem. But at that point of time, there was no proposal at all.
So what's the basis of that proposal? That must
That
be
I don't
that.
know, that's for him.
What is the basis of
Initially,
that
the
proposal?
ESZ was declared for 10 kilometers with the boundary.
Yes.
Then thereafter, by a review petition, Supreme Court said it cannot be a state jacket formula, case to case basis, it has to be decided. Then it reduced from 10 kilometers to 5 kilometers.
For this reserve.
ESZ zone.
For this reserve.
For this reserve.
Not
for the entirety.
No, entirety. Entirety.
No.
Entirety will be 5 kilometers.
Yes. No.
Maximum 5 kilometers.
No, maximum is 0 to 5.
Yes.
0 to 5, it has been reduced from first 10.
Yes.
Then the second reviewed by the Honorable Supreme Court, then it came 0 to 5. Then Supreme Court said in another review application that it is the state's government decision. Suppose now, my lord, there is a, my lord, the neighboring border, international border.
Bhutan.
So that cannot come within the ESZ area. So in case to case basis, it has to. Suppose there is a forest village.
Yes, I appreciate that. Now with regard
Now,
to
this
this
is the
Boxer Tiger Reserve, wherein we are concerned now.
Yes.
So you have given a proposal.
Yes.
So a modified proposal defining the ESZ.
Yes, is somewhere 2 kilometers, somewhere 1 kilometer.
Yes. So if the modified proposal is taken, Mr. Chatterjee is out of that zone.
Probably.
Probably.
About probably can.
Because why I'm saying probably, my lord, this is then
No,
subsequently.
you have given a
why I'm
map.
saying
You
that?
have given a map.
No, my lord.
Or a boundary,
Why
whatever.
I'm saying, why I am saying? Because there would be then a draft notification to be published to the central government. There will be no objection. But this is the reason I use the probability. Then there will be an objection to the draft notification. Then the central government shall consider the draft, objections raised with regards to the draft notification. Then you will reach to the final. Then, my lord, the final publication would come.
So this is at the preliminary stage.
Not even the stage is reaches there.
So that's where I am.
Stage.
That's exactly what I'm apprehending. So I am, my lord, in a doldrum. since 2020, my learned senior friend wants me to correct me, my lord, from 2020, now it's 2025 end. Can't go on forever. So I am trying to now, my lord, convince your lordship that there is no impediment on the my lord, the pollution control board to give me this consent to, my lord, operate. If your lordship turns to 112 once of the writ petition, this was what they said when I went to them for consent to establish, operate. Establish or operator মধ্যে মাথা খারাপ।
তুমি establish ভুলে যাও।
Establish টা হয়ে গেছে।
হ্যাঁ।
Establish হয়ে গেছে, এখন অপারেশন এর ঘটনা। এ দেখলে তুমিও ভুলিয়ে ফেলছো।
আমি বলতে চাই
Looks to
Does not fall.
Exactly. And sees, with reference to the above, this is to inform you that you are required to obtain no objection certificate from competent authority as your unit does not fall within the eco-sensitive zone of Baksa Tiger Reserve.
Who is the competent authority?
Mr. Chaudhary is clear. Mr. Chaudhary has told your lordship, looks to my lord's order now. Turns to my lord's order.
I said, I will try.
Can you turns to my lord's order once? Yes. Kindly turns to my lord's order, my lord, dated 9th April.
Yes.
Looks to page, internal page 2.
Yes.
Sees the third paragraph. Mr. Additional Advocate General submits that the site of the unit in question falls outside the forest boundary, and therefore there is no requirement for obtaining NOC from the Principal Chief Conservator of Forest, Government of West Bengal. That's why your lordship wanted below the him to be added and an affidavit to be filed. After this, the story of below PCB saying that the consent to establish was wrong. So
That is the pollution control board.
Yes.
And Mr.
Well,
Chaudhary's submission is that it's
yes,
outside.
pollution control board asked me to go to Mr. Chaudhary, asking for
Chaudhary says
objection.
that he does not have anything.
Nothing. Thereafter,
No
pollution
NOC from him is not required.
NOC with regards to forest department.
Yes, yes, yes.
But
Forest
NOC
department.
from the ESJ monitoring committee established by the statute. That monitoring committee shall give consent to operate or consent to establish.
They have not
Just a
given
second.
Pollution control board, according to you, is no one.
No one. Just I'm clarifying. Pollution control board is one of the member in the monitoring
Yes, yes.
committee. Now, when the consent to establish was granted, there was no objection or matter placed before the monitoring committee for giving consent to establish. We do not know. Monitoring committee do not know. That I have clarified.
So kindly
Despite in the meeting, he is in the board, he is one of the member. It has not come reaches to the ESJ monitoring committee to consider such.
Kindly appreciates now, my lord, my problem after this submission. I go to him, he says you come to him.
No, Mr. Chatterjee, one thing, if the monitoring committee is the only authority to give
They have
consent.
not given anything. They have not said no. They have not said no.
No, the question is, at times, pollution control board may have the authority, full authority to give consent to establish and operate
Yes.
in ordinary or in general areas. In a specialized area, there may be some specialized body. And the pollution control board and
a member
officer,
there.
yes, may be a member in that, of that authority. So the question is whether that member on his own can issue some certificate.
But he has, if he has given a consent to establish, he has to, Millard, in that consent to establish, it's written.
Yes, I
That he
appreciate,
will.
but that's honest in the eye of
Let him
law,
say
Mr.
that.
Chatterjee.
Let him say that. Honest in the eye of law, Millard, at this stage cannot be said in my respectful submission.
If he does not have the authority.
Millard, he has the authority. He is the only authority.
No, he says the monitoring
That is within
or
the
the
ESA.
monitoring.
ESA. That was within the ESA.
Yes,
We have not even reached the ESA. We have not even reached the stage of ESA at all.
no, it's the unit, if it is within the ESZ.
The pollution control board has said it's not within. Let me show then. Tally turns to 112. Tally turns to 112 of the read petition. Why your affidavit? I'm giving you a letter, sir. This is also your document, sir.
I've already stated that in the previous petition. I've already pointed out, my lord, when my lord was previously hearing the matter, that part.
Whether 112 is your document or not, sir, Mr. Rahman. Mr. Rahman, whether 112 is your document or not.
Erroneously put there.
Mr. Rahman, before giving any aspersion against me, kindly tell the court whether 112.
No, Mr. Chatterjee.
112 is your document or not.
Chatterjee, he is not.
From where I have got.
He's not giving any. He's not making any aspersion against you.
No, he said that from where I'm getting. He is saying from where I'm getting. I'm showing where I'm getting.
Chatterjee, don't get agitated.
I'm
Maybe,
never
but yes,
agitated.
this is on record.
I
He's
don't
not.
like being told about this.
No. Maybe in a different way it could have been said.
Yes.
Please don't go into that. Now, 112, he is not denying that he has not issued.
Then where
He's
do I
not
go?
denying. He is not denying.
Has he
says,
cancelled it? May I ask this question to myself?
yes, that's on a point of
He
law
doesn't
or
I am
to be.
on a
So
question.
he says that his stand according to him is that was wrongly or through
He
inadvertence.
hasn't,
or
no, he hasn't said so. Comes to his report. Kindly comes to his report.
which letter?
Kindly comes to his report.
Yes.
That is erroneous. Whereas
To obtain no objection from the competent. No, but you have said, as your unit does not fall within.
Falls within the ESZ. If it does not fall within the ESZ, why?
So where am I? Where am I to go?
No, whether his unit falls within ESZ, yes or. If he falls within ESZ, so if he falls within ESZ, which authority has to give consent to operate and consent to establish? Please tell me that.
And he says.
From the. Where have you said? From the box.
112.
You have not said from which authority, as your unit does not fall within the Buxa Reserve, you have said. But from which authority, which is the competent authority?
But that is the authority which is looking after the ESZ. That is the ESZ.
No, just a second. I am clarifying. My lord, the monitoring committee only has the power to issue a NOC. Authority is either PCB.
Yes, that's the NOC that I'm asking.
Now, my submission that at the time of granting the consent to establish, there was no NOC.
NOC.
So, but the permission, the permissible, the authority is to grant license by the PCB. So,
PCB will issue the consent to establish and
also
consent to operate. But before granting consent to establish,
yes,
there has to be a no NOC from the monitoring committee.
No, my lord, subject to correction, let them show the law. No.
All right, Mr. Chatterjee, when
Monday, I'm any day, my lord, since your lordship has started hearing it, any day your lordship. It's up to my lord. I just want to finish it once and for all, whichever. Monday 2 p.m., Tuesday 2 p.m., Monday morning.
Mr. Chatterjee, I thought so because some matters will let it remain because fixing may be a problem. Fixing may be a problem. Mr. Chatterjee, you can also.
If it was Calcutta, there was no problem.
Mr. Chatterjee, you can also appear virtually.
This
because
matter,
fixing, Mr. Chatterjee, because
this matter, because of the nature of this matter.
Effective 3 days, Mr. Chatterjee.
Can you tell this human being, I have no problems at all.
For what?
Don't allow me to sleep if this matter can be taken up next.
Taken up?
Next day, if there is any chance, at least 20 phone calls, then Dada Kokon ticket cut. Now, my problem is that yes, I've started this matter, so I also have a little bit of interest so that I finish off the matter. It's an interesting question.
Mr. Chatterjee, interesting everything. I'm
And
not
I will
saying
try
anything,
and
but fixing is a problem. Because effective,
may I
Mr. Chatterjee,
most
I'm telling you, effective is 3 working days.
Yeah, I bow down. Completely.
One is a holiday, and many matters, I've seen many motions.
Friday, nobody takes up matters, on Friday, nobody does matters.
Friday, last day.
Last day. 10:30. Then Thursday in the afternoon.
Last day, Mr. Chatterjee, when I will pass, I have to pass the orders.
That
Mr.
is also,
Chatterjee.
your lordship can take it to Calcutta.
No. I have not, Mr. Chatterjee, I am telling you, I have not brought any file from the principal bench to here.
Now you
From
cannot.
here. No. For the
Here through there, your lordship can.
No. For the purpose of preparing the judgment.
Pardon.
For the fact of preparing.
But there is a provision.
From none, yes. But I have finished here as well as Port Blair.
Then
I have delivered judgment even in CIV matters within the circuit.
Then Tuesday.
Not also
that
going
Tuesday.
to the principal bench through video
Then
conference.
Tuesday.
That's
Once
the
your lordship has
problem.
started, you lordship can.
That's
fix
that's
anytime.
that's
I'm
the
sure
only.
Mr. Rahman will not oppose me on that.
No.
I wish I had a baggage like you.
Let this appear because fixing a time, Mr. Chatterjee, I am telling you, it's a
It's
difficult.
fairly at the top, so that some sort of
It's fairly at the top in the motion bench because you are here. Many matters have gone to the hearing. There may be one or two matters. Motion, you are fairly at the top.
ki dhulbe na new motions are there. My lord, kindly
New
my lord,
motions, Mr.
Sir,
Chatterjee,
may I make this submission?
motions.
May I make this submission? Wednesday.
Because
lord,
my endeavor was
I bow down, my lord.
to take up the new motions. I have accepted all the
Completely
mentioning
understand.
slips for new motions.
I'll kindly give me this, my lord, indulgence. Wednesday is a holiday. If your lordship keeps it, my lord, around 3 o'clock on Tuesday and finish it off till, my lord, it finishes. I will even, now we have a flight, my lord, at 8 o'clock. 8:50. So give me this indulgence.
Circuit, Mr. Chatterjee.
Then your lordship has Wednesday and Thursday and Friday to give judgment.
Let it remain on Tuesday. Let me see.
The problem then keeps it on Monday also.
No, Tuesday. Because Monday.
Tuesday, your lordship has
matters,
kept
let
a
me see.
lot of matters. I was here, my lord.
Monday also many matters.
And
Monday
Tuesday
it
there's
will
a
not
full-
be able to reach.
Tuesday there is a full court reference. Tuesday kindly do not keep at all. Then Thursday keeps it at 2 p.m. Kindly.
2 p.m. Mr. Chatterjee is Thursday. Some matters have been fixed.
Thursday 6. Very well. Even Thursday, my lord,
I
at
think
2 o'clock or 3 o'clock, I will, my lord, with the understanding that we will finish off the matter and then.
Let me see. Let it appear. Let me see the
Lord,
position. I do not know.
Because our, Lord, the problem is that it's not Calcutta. If it was Calcutta, my lord, I would
Please.
not have even
Mr. Chatterjee,
said anything.
you know from the position of the list, you are the best person. You have sufficient experience. Mr.
Ekdom, my lord, this is nobody,
So-
Mr. Shoktinath Mukherjee will not have this experience.
And
But never say, Lord, when the judgment will.
no, that I'm not saying. Some reasonable say, or you can also appear virtual.
I am ready. Please give them an order.
He's not allowing
give
you
them
to
an order. No.
appear virtually. Why?
He says in this matter, because it's this sort of a matter, you will have to go and do the matter physically. This Kylie puts him on notice. I have no problem.
I cannot put your junior on notice. I'm giving you liberty, physical, virtual. It's your choice.
Lord, he's
Physical or
Chakravarti's
virtual.
junior, my lord, I will not take that. Lord, he's Sri Chakravarti's junior. No. I have to, Lord, remain in High Court.
Mr. Chatterjee, learned senior advocate, commences his argument but could not conclude due to paucity of time till 5 p.m. Hey, paucity of time. Pastor Pans लिख देना due to paucity of time.
It will be
So,
like
sir, the
Gopal
learned
Bhatta.
advocate on record of the petitioner is directed to state is represented by the learned additional advocate general. The pollution control board. Pollution control board is represented by the learned additional government pleader and Mr. Rahman. This matter on November 6th.
হবে না একটা টাইম দিলে সব থেকে শুরু
Tuesday I can keep it, but 3 p.m. is there. You are right. That was not in my mind. No, not in my. I should not say not in my mind. Full court is on 3rd. Monday.
On 3rd or 4th.
So it is Monday. Full court is on Monday.
So full court of what?
Huh?
না না বিভাগ নেই। বিভাস ডে কবে? হ্যাঁ তাই তো বলছি।
Third and fourth, both days.
Then both days.
Difficult, Mr. Chairman.
তাহলে 6th day করো, 6th day 3 o'clock.
6 মানে কি? Thursday? ঠিক আছে, চলবে।
তাহলে time fix করবেন।
আবার problem happens is the morning, I don't know, I will come at 10:30. Entire day, I will be only on this matter because Calcutta very difficult to do.
Appear virtually.
How, in Calcutta, I can't do it virtually.
No. Here I am telling, from Calcutta.
If it doesn't, if it's not
Mr.
taken
Chatterjee,
up,
in principal bench regularly, I could not see you physically, I think,